Welcome you to the Institute for the Humanities at the University of Illinois at Chicago. My name is Estrida Orly Tantillo. I'm Dean of the College of Liberal Arts and Sciences, and it is really my pleasure to be here to open this final day of the Sharia and Halakha in America conference. I would like to first thank the sponsors of this event, IIT Chicago Kent Law School, the UIC Jewish Muslim Initiative, and the UIC Institute for the Humanities. I would most specifically like to thank the coordinators, UIC's Samuel Fleischacker and Junaid Quadri, and Chicago Kent's Mark Rosen. Thank you very much for bringing this together. I've been looking at the program and it's really amazing. I've heard that yesterday's program was really wonderful, and I can think of very few things that are more important to discussions of liberal democracy about where religious freedom and where law intertwines with the notions of a liberal democracy. So I'm really grateful that we're able to do this conference here on our campus. So we're really proud at UIC to be the home of the Jewish Muslim Initiative and all the valuable events and collaborations we're able to do here with community groups, with other organizations, and of course today most especially with IIT Kent Law School. We are a school with a large Muslim population in one of America's most ethnically diverse cities, and in fact our campus is one of the most diverse in the nation. And we have a group of faculty with strong interest in Jewish and Islam studies, and so we are well situated at UIC to take a lead and to work with others in this area of Jewish-Muslim collaboration and initiatives. A major component of this initiative is the interdisciplinary work brought about by the research done by our faculty, and even in the discourse that is centered in our classrooms. The results of this research and discourse on this campus are then brought to a wider community through events, through publications, through actions and activities within the communities, and including this one, which we're especially proud to be part of. So I would like to thank you for coming, and I wish you a very successful stay on our campus, and I also wish you a very productive conversation today. Thank you.
Thank you very much, Dean Tantillo. We are very grateful for UIC's support for the Jewish Muslim Initiative and all the help that you and the Dean's Office and your predecessors have given us over the years, which has really been terrific. We're also grateful for the support we've had from Chicago Kent, and we're proud and pleased to have worked with Chicago Kent several times in this initiative, which is really quite wonderful. I should also mention that there was an individual gift by an alum, I believe, of UIC named David Gassman, who contributed specifically for conferences on Jewish-Muslim relations, which has also helped out with the conference. So we'll begin this morning with a slightly different format than we had yesterday, different from all the other panels, a roundtable discussion. I will introduce the three participants now. They will all come up. They'll all speak for about 10 minutes. 10-15 minutes. We're not going to be strict clock watchers here, but it's basically short introductions. They'll then respond to one another somewhat, and then we'll have an open discussion with the entire audience on the topic of the anti-Sharia movement in America. Unfortunately, I think of this as a Lemony Snicket conference. We had a series of unfortunate events. And one of them was, and this is actually the saddest, but I think everything's okay, that Nadia Marzuki, who was going to be one of the speakers, had a bike accident last Friday. Fortunately, she was wearing a helmet, and she seems to be okay, but she was warned by her doctors not to fly, so she did not come here. But we are we over here at least are lucky in that we, in the last minute, as we have throughout this conference, found a wonderful person to speak in her stead, who is Leanne Bambach, who is a PhD candidate at Emory University, where she is writing a dissertation about Islamic arbitration in the United States. She received her master's in theology from Harvard Divinity School and a JD from the University of Georgia. She's clerk for Judge Sam J. Irvin III on the Fourth Circuit, and was one of the drafters of the American Bar Association's report and recommendation opposing anti-Sharia and anti-foreign law legislation. And she works with our keynote speaker last night, Michael Broyd, and Abdullah Naim at Emory in her dissertation. We also have, I'm not sure exactly what order, did we flip a coin? We'll go in, but...
I know what we're doing, yeah.
Yeah. You've worked it out?
Yeah.
Okay. So in some order that is different from the order of introduction, I assume, we also have Sam Friedman from the New York Times speaking. He's an award-winning author, columnist, and professor. He's a columnist for the New York Times. He writes the religion column, and a professor, which I read religiously as it comes out, and a professor at Columbia University, and the author of 6 books, including Small Victories, The Real World of a Teacher, Her Students, and Their High School, which was a finalist for the 1990 National Book Award, The Inheritance, which was a finalist for the 1997 Pulitzer Prize, and Jew versus Jew, The Struggle for the Soul of American Jewry, which won the National Jewish Book Award for Nonfiction in 2001. As I've mentioned, he was a staff reporter for the Times from 1981 to 1987, and he currently writes the On Religion column. He was also a regular columnist on American Jewish issues for the Jerusalem Post from 2005 through 2009, and has contributed to numerous other publications and websites. Wajahat Ali is a playwright whose work, The Domestic Crusaders, was the first major play about Muslim Americans living in post-9/11 America. It was published by McSweeney's in 2011. He's also an essayist, a humorist, an attorney at law, and writes for, I think, several websites, but primarily for Goat's Milk, is that correct?
That's my blog.
That's your blog.
I'm really proud of it.
So some of the other websites I've seen listed at the end, but
It's all right. It's all right.
okay, I'll just say numerous other websites. And what order will you be speaking in?
I'll do false.
So Wajahat will open, and then Leanne will speak, and then Sam. And if you'd all come up here, and I will find a watch clock roughly. I'll put up my hand with 2 fingers, and there's 2 minutes left.
Maybe side of
What's that?
I'm going to go 15, 20.
Oh,
Just a
that's
second.
fine.
If I go too long, you can cut.
So I'll give you 18. I'll give you.
You can start? Okay.
Yeah.
All right, guys, good morning. Assalamu alaikum, shalom, and everything in between. Thank you so much for having this conference, and thank you for allowing a non-academic like myself to, at least for 2 days, be in the company of academics. And thank you, academics, for tolerating me. We start off the conference with this very heartwarming, inspiring, great conversation about the Islamophobia network and the Sharia controversy that you must have heard of. And for those of you who have not followed the Sharia meme, there is a fear of creeping Sharia supplanting the United States Constitution with Islamic law and replacing the stars and stripes with star and crescent. And I think some of you have heard of this. But I say Sharia has already infiltrated and conquered America. I mean, the signs are everywhere. Here are some of the signs. We re-elected a Muslim to the Oval Office, Barack Hussein Obama. Indeed, 17% of 2012 registered voters think that Barack Hussein Obama prays to the Kaaba, and as such is anti-American. First term Obamacare, second term Caliphate. We've also made strong progress in the culture war. 3 years ago, we put a tiara on Miss USA, Miss Rima Fahi, who comes from anyone? Dearborn, Michigan. And Ms. Rima Fahi is otherwise known as, quote, the Hezbollah-supporting Shiite Muslim whose bid for the pageant was financed by an Islamic terrorist and immigration fraud perpetrator, end quote, according to blogger Debbie Schlussel. Also, Sharia, according to some others, has crept into our supermarkets. We have placed hummus and tahini in every Whole Foods and Safeway supermarkets, which is eaten daily by suburban moms. And once you win over suburban moms, you've won over America. We have conquered American turkeys with our ally, Burt Butterball. Thanks to intrepid culinary detective Pam Geller, we've learned about the conspiratorial, quote, Butterball cover-up of foisting halal turkeys on the unsuspecting public, end quote. We've also infiltrated the most influential voice in America, the television. If you guys know about last year, we had a reality TV show called All American Muslim. Anyone know about that controversy? A simple reality TV show produced by the cable network TLC that erupted in international controversy. So if you do not know anything about this show, All American Muslim, you would ask yourself, what is this show about? You know, is it like Downton Abbottabad Abbey? Is it like, thank you, I'll take that. Is it like the Real Housewives of Al-Qaeda? Does it show homemaking tips, jihadi training grounds? What is so outrageous about this show that would cause a national and international controversy? It was so outrageous that if you guys remember, and Sam wrote about this as well, Lowe's, the retail giant, caved into what they said was, quote, enormous pressure and withdrew ads from this show, citing a response from, quote, a broad spectrum of customers. If you actually did the research, they actually submitted to an email campaign run by one organization by the name of Florida Family Association, which is an operation run by one dude with a terrible website and a huge email list by the name of David Catton, the sole employee of Florida Family Association, who has a history of boycotting corporations who sponsor shows like Family Guy, Modern Family, Degrassi, and worst of the worst, Disney World. And he received his talking points about the show much earlier from members of the Islamophobia network that I'll highlight. For example, again, her name will come up unfortunately a lot, Pamela Geller, who wrote on her blog that the show was trying to manipulate America into ignoring the threat of jihad. Did not know a reality TV show had that much power. And also David Horvitz's Front Page magazine, in which a writer wrote, the show was stealth propaganda to promote submission to Islam through the hijab, end quote. If you guys have been following the news last week, Muslims have already infiltrated the Tennessee state capitol with our, quote, foot washing sinks, end quote, for our ablutions before our 5 daily prayers. Our prayers, which if you were paying attention last week, are, quote, acts of terrorism, according to North Carolina Republican State Representative Presno. The stealth edition of foot washing sinks was uncovered by Senator Bill Ketron, who brought it to national attention. So upon investigation, the Legislative Administration Director Connie Ridley wrote in an email, quote, I confirmed with facility administrator for the state capitol complex that the floor-level sink installed in the men's restroom outside the House chamber is for housekeeping use. It is, in layman's terms, a mop sink. Mop sink, foot washing sink. Tomato, tomato. Hummus, Hamas. This stuff is ridiculous. One last one, the creme de la creme. Our infiltration of the international boy band sensation One Direction, featuring, if you have daughters, you know this, okay? Featuring Zayn Malik, who is a Muslim, and this is proof, and I quote, boy band jihad, mega pop star pimping Islam on your daughters, end quote, by blogger Debbie Schlussel. Now this is ridiculous, and we should laugh, and we have laughed. However, each one of these examples that I've given has been cited by members of the Islamophobia network, who are very much responsible for the fictitious Sharia threat, of proof that Sharia has infiltrated different parts of America. And in fact, if you guys pay attention from last year, nearly every single major Republican presidential candidate of 2012 ran on the anti-Sharia meme. I'll give you the names of the people who did it openly. Rick Santorum, Tim Pawlenty, Newt Gingrich, Herman Cain, and Michelle Bachmann. The manufactured fictitious Sharia threat is about as threatening as uncovering the unicorn or Bigfoot threat. Yet, 31 states in the past 2 years have introduced what we call the anti-Sharia bill, or a version of the anti-Sharia bill. Specifically, there have been 78 bills which seek to restrict the religious freedom of Muslims. And as you will find out in this conversation, it affects not only Muslims, but essentially all Americans. And many of them, unfortunately, have been given leadership support by mainstream Republican leaders. 62 of these 78 bills were based on the model template that was written by attorney David Yerushalmi entitled American Law for American Courts. I'm going to talk about that in this 4 minutes I have left. He is also the private attorney of Pamela Geller and Frank Gaffney. I'll be talking about him. 6 states have passed one version of this bill. This includes Louisiana, Oklahoma, Tennessee, Arizona, South Dakota, and Kansas. So the question should be, how did this all start? We got to go back to 2009, and a New Jersey family court judge, he denied a restraining order by a woman who said she was forced to have non-consensual sex with her Moroccan husband. Judge Joseph Charles Jr. said he did not believe the man, quote, had a criminal desire to or intent to sexually assault his wife because he was acting in a way that was, quote, consistent with his practices, end quote. The judge, for those of you who are attorneys, is clearly in error. And thankfully, within 2 months, the appellate court overturned the decision. So that's great, wonderful. The US law and court system works. Hooray. Release, exhale, awesome. Not so fast, because the Islamophobia industry uses that as a smoking gun proof of Sharia infiltration. Fast forward to 2010, we go to Oklahoma. State Representative Rex Duncan introduced State Question 755, also known as, quote, Save Our State Constitutional Amendment. For those of you who don't know, you should be asking yourself, save our state from what? Good question. This was a ballot measure barring, quote, state courts from considering international or Islamic law when deciding cases, end quote. The proposed constitutional amendment had really good timing because it coincided with the manufactured controversy over the Park 51 building in New York City in the spring and summer of 2010, which, as we remember, was dubbed the Ground Zero Mosque controversy, which was neither a ground zero nor a mosque. And the same way that controversy got mainstream, the Sharia controversy got mainstream. We'll talk about it in the discussion, just to save time. The leading anti-Muslim grassroots organization, Act for America, launched a $45,000 grassroots campaign in Oklahoma in 2010 to urge voters to support State Question 755. It also sponsored 1-minute radio ads that ran across the nation to warn against Sharia. 70% of Oklahoma voters voted for this to ban this non-existent threat. However, a federal judge quickly blocked the law for violating the Establishment Clause of the First Amendment and for blatantly targeting the Muslim community. In January 2012, an appellate court affirmed the ruling that prevented the voter-approved state constitutional amendment from taking effect. Specifically, in the opinion, the appellate court pointed out that proponents of the law admitted to not knowing of a single instance in which Oklahoma court applied Sharia law or the legal precepts of another country. An elected official who supported the anti-Sharia bill admitted he could not find any evidence of Sharia, quote, creeping into the state. And yet here we are in 2013 and 31 states are still talking about this. So there was a genesis to this fear-mongering created by very few people. And in addition to my goat milking, I also was it's an honorable profession. I also was the lead author of this document, investigative report that we spent 6 months on, entitled Fear Incorporated, Roots of the Islamophobia Network in America. We've released it on the Google if you type in Fear Incorporated. And I did this with Center for American Progress, was released August 2011. And it's an investigative report on how we exposed how 7 funders have given over $43 million over the past 11 years to a small, interconnected, and I will say incestuous network of individuals, think tanks, and grassroots groups, and some religious right personalities to promote these divisive anti-Muslim memes. Before I go on, I think we should give the definition of Islamophobia that we uncovered, especially the type of Islamophobia that we've witnessed post the 9/11 tragedy in America. And the definition that we came up with is the following. Islamophobia is an exaggerated fear, hatred, and hostility towards Islam and Muslims that is perpetuated by negative stereotypes, resulting in bias, discrimination, and this is the key part, marginalization and exclusion of Muslims from America's social, political, and civic life. So for the first time, we dissected and exposed the network, categorized it, named the names, traced the funding and the money, and showed the genesis of several once fringe memes that have now gone mainstream. Nod your head if you've heard the following. President Obama is a Muslim. Sharia is a threat to America. Mosques are Trojan horses. Radical Islam has infiltrated America. There's no such thing as moderate Islam. Traditional Islam is radical Islam. And what's most damaging for Americans, practicing Muslims cannot be loyal Americans. Anyone heard at least 1 or 2 of these? It's very sad. Everyone's nodding their head. The threat of creeping Sharia is wholly manufactured by certain individuals and organizations who have a rich history of fear-mongering and hysteria and dubious associations. And I want to quickly break down how this happened. So the Islamophobia Network has 5 categories. I won't go into all of them in detail, I promise. We're doing okay so far? Okay. 5 categories. Everything always begins with the money. The first group is what we call the money trail. We've identified 7 funders. The money primarily goes to the second part, which we call the nerve center, the Islamophobia scholars, and policy experts. Oftentimes originate from DC and think tanks. They're the ones who create the memes. Then the question should be, well, who cares? They're just memes. How do they spread? The third group is what we call the grassroots organization, and unfortunately also members of the religious right. The memes go spread through these constituencies, which also use new media, which goes to the fourth group, the media megaphone. Not just traditional news. There is a news channel in particular that is very responsible. On the count of 3, let's take a guess. 1, 2, 3.
CNN!
Dr. Muhammad Fadel wants to be a smartass. No, it's Fox News, but thank you. I respect Dr. Fadel. I hope you don't mind. He's smiling, so he's not going to hurt me. Don't misunderestimate also new media, blogs, online radio. It's been critical. After it gets mainstream internationally with the media megaphone, these memes literally end up as talking points, verbatim in the mouths of politicians. And I just gave you an example of the 2012 Republican presidential candidates. I'm not going to mention the 7 funders. We've listed them. But the money then goes to the nerve center. And I want to talk about the nerve center real quick. The architect of the current anti-Sharia legislation we have uncovered is Attorney David Yerushalmi. Are people familiar with Mr. Yerushalmi? Most people nodding their head. The ADL, Anti-Defamation League, has written of Mr. Yerushalmi, quote, he has a record of anti-Muslim, anti-immigrant, and anti-black bigotry, end quote. In a 2006 article, Mr. Yerushalmi even went so far as to claim that, quote, Muslim civilization is at war with Judeo-Christian civilization. The Muslim peoples, those committed to Islam as we know it today, are our enemies, end quote. Despite this, he has been invited by elected officials to give expert testimony on Sharia. He has appeared on mainstream press, such as NPR, to talk about Sharia, even though he's not a scholar in Islam, Islamic law, or a master of Arabic. He also happens to be the attorney of Pamela Geller, and the attorney of Pamela Geller and Robert Spencer's hate group, Stop Islamization of America, which has now evolved into being the Stop Islamization of Nations, which is cited as a hate group by the Southern Poverty Law Center, and cited by the ADL as promoting a radical anti-Islam agenda. We'll talk about this in our conversation, but they were also behind the manufactured controversy of the Ground Zero Mosque. And I really keep saying it's manufactured. And I think we should talk about how it was manufactured in the panel discussion, because that same template of how a non-issue became a local issue, became a national issue, became an international issue, the same way they did that playbook is at play with the Sharia controversy. Mr. Yerushalmi is also the founder of the think tank SANE, S-A-N-E, not making this up, Society of Americans for National Existence, which in 2007 proposed legislation to make adherence to Sharia a felony punishable by 20 years in prison. In 2007, his organization initiated the Mapping Sharia in America, Knowing the Enemy campaign that wanted to, 2 minutes? I can't even say my name in 2 minutes. All right, I'll try to finish. Sorry for going so long. Give me 5. Can I do 5? You guys, all right. Sorry, guys.
Special warning.
All right. You want to see what type of Sharia was practiced in every single mosque. In the press release, they said the campaign would test the proposition that Sharia amounts to a criminal conspiracy to overthrow the U.S. government. Equating Sharia with criminality, Yerushalmi further proposed legislation to make adherence to Sharia a felony. This includes then a Muslim woman who's wearing the hijab, like you in the back. That would be a felony under this definition. His major ally and funder is Mr. Frank Gaffney, who is the founder of the think tank Center for Security Policy. And specifically when it comes to, I want to give a great quote. Frank Gaffney, a mosque that is used to promote a seditious program, which is what Sharia is, that is not a protected religious practice. That is in fact sedition. Despite this, he concedes, I don't know much about Sharia, but I have talked a lot about that as a threat. End quote. And he's made $300,000 in the year of 2010. In 2010, and this is key, Center for Security Policy released a 170-page report called Sharia, the Threat to America, which misdefined Sharia as the preeminent totalitarian threat to America and the legal, military, political doctrine that seeks to supplant the Constitution, also co-written by David Yerushalmi. It's designed to provide a comprehensive and articulate second opinion on the official characterizations and assessments of this threat, as put forth by the United States government. Specifically, they define Sharia in a static, ahistorical, unscholarly way in which no practicing Muslim will ever recognize. Okay? And also what they do is they misdefine this word taqiyya, and I want to spend 20 seconds talking about it. They misdefine taqiyya as religiously mandated lying. In essence, they say that Islam encourages Muslims to lie and be deceptive. If you ask most Muslims what taqiyya is, most Muslims will think taqiyya is a new taco released by Taco Bell with extra guacamole. Most people have no idea. Taqiyya is an Arabic word which allowed a Muslim to hide one's faith in order to protect their life and family. It's very similar to in Jewish faith. It does not say you're allowed to lie, but look how insidious it is. It says that every practicing Muslim lies, so there's no such thing. Even the good Muslim, you can't trust the good Muslim because they're practicing taqiyya. In 2011, Mr. Yerushalmi developed a template for the current anti-Sharia legislation, I'm ending now, I promise, in a minute, entitled American Law for American Courts, at the behest of the self-proclaimed nonpartisan advocacy group, American Public Policy Alliance. The organization claims one of the greatest threats to America and American values and liberties today comes from, quote, foreign laws and foreign legal doctrines, including Islamic Sharia law that has been infiltrating our court system. Leanne's going to go into more detail about how this has shown up in Tennessee and Arizona. And the American Bar Association reviewed this, and they called this entire movement an anti-Sharia initiative. They said, quote, many of the legislators sponsoring the anti-Sharia initiatives in other states are using the model legislation drafted by David Yerushalmi. The bill, if passed, would prevent Muslim American communities from having the same rights and access to courts as any other religious community in America. The fact that they've taken out Islamic law, because you guys remember in 2010 in Oklahoma, they realized it wouldn't pass constitutional muster, so they replaced it with foreign law or religious law, which has now concerned business communities and Jewish American, Catholic American, and Muslim American communities. Because if this is implemented, it infringes on all of our rights. And I'm going to end on this, promise. He also helped co-author Frank Gaffney's 2011 report, Sharia Law and American State Courts, an assessment of state appellate court cases, which evaluated what they said was 50 appellate court cases from 23 states that proved Sharia had infiltrated the US court system. The ACLU thoroughly debunked the findings of this 2011 report in their 2011 report, Nothing to Fear, and concluded that the CSP report promoted a, quote, mythical Sharia threat. They rejected Mr. Yerushalmi's unsubstantiated claims of Sharia infiltration as, quote, wrong, and said it was, quote, based both on misinformation and misunderstanding of how our judicial system works. However, the ACLU suggested an insidious purpose behind this entire movement to criminalize Sharia. Quote, prohibiting US courts from considering Islamic law serves only one purpose, to bar Muslims from having the same rights and access to courts as any other religious individuals. So by defining Sharia as a problem and as a totalitarian threat, we are now to assume that all adherents of Sharia, which is essentially any practicing Muslim, they are deemed as threats to America. This casts suspicion on all observant Muslims as a potential fifth column. Politically and culturally, this inaccurate framing lends people to believe that Islam and subsequently all Muslims are not only utterly incompatible with America's political, civic, and social life, but they're also a continuing hostile threat. And in the conversation, I'll talk about how the grassroots groups and the media groups and the political groups have mainstreamed this. And I would also like to talk about how this has actually, ironically, served as a major national security threat to American citizens. Thank you for giving me the time. I'm sorry for going over. I'm finished.
Leanne, you're next.
So I want to talk a little bit about the evolution of these laws and their various guises that they've appeared in. Early iterations were very broad, and they have two prongs to them. It's not just Sharia or religious law. They also attack foreign and or international law. Now there is a difference actually between foreign law and international law, but that gets lost in the shuffle here many times. especially for example, in Oklahoma Save Our State Amendment. That one, as we talked about, specifically prohibited Sharia law, and also, let me see, the courts were not to consider international law or Sharia law, or even the law of another state if it included Sharia law, and also was specific against foreign law. So foreign law is the law of the country. So if you contract a French company, you specify that you want French law to apply to that, a choice of law clause, very, very common in business, that would not be allowable under Oklahoma law had this amendment been put into effect. International law, treaties, international norms of law that may influence opinion. For example, you have 2 United States Supreme Court decisions. You have many decisions that consider international law and international laws. So you have a 2008 Supreme Court decision, Medellin versus Texas, where the Supreme Court decided it was not bound by the International Court of Justice judgment to stay the execution of a Mexican national. So we don't have to listen to the International Court of Justice. We can do what we want to according to our laws. On the flip side, in 2010, the Supreme Court of the United States had another decision in Graham v. Florida, where they didn't base their decision on it, but they referred to international opinion against sentencing juveniles to life in prison without parole. So there is this real fear of international legal norms coming into the U.S. system. We should put up a wall. We should not look at what anybody else is doing. There's a fear of foreign laws of other countries. We should put up a wall, not let that in. And then there's this fear of Sharia, which I've talked about. So all of these are combined in a lot of these legislation efforts, and was definitely all appeared in the Oklahoma amendment. So we know that was struck down. It was struck down purely on First Amendment grounds, but it could have been struck down on a whole host of other constitutional grounds. You have the contracts clause. You can't freely contract during choice of law. That would have been a problem. Full faith and credit. They weren't going to look at the laws of other states if those laws somehow included Sharia law, which was totally unclear what that meant. And the supremacy clause. International law includes treaties. They weren't going to allow that to happen either. That's against the supremacy clause. So you had a fear among Muslims and other religious people, but there also engendered a great deal of fear among business communities that this was really going to handicap them in international trade and put them at a real competitive disadvantage. So if we're worried about it not passing muster under Sharia, which is because it singles out Sharia, then the next attempt was really to broaden it to not just include Sharia. So there was an Arizona bill that was introduced in 2011, and that opposed implementing or incorporating laws of foreign countries or foreign bodies in any state judicial decision, and also barred courts from using any religious sectarian law. So not just Sharia, any religious sectarian law, but they helpfully described what was included. So that would include Sharia law, canon law, halakha, or karma. I'm not sure you can bar karma from a court, but I guess it's worth a try. So you have the same problems. You have, even though you're not singling out Sharia law, even by specifying religious law, you're still running afoul of the First Amendment. It's still bad for businesses. It still runs afoul of other constitutional amendments. A slightly different tact was taken in Tennessee, which is one of my favorite laws just because it was so egregious. And it was introduced by Ketron. And it was really an anti-terrorism bill. It was ostensibly designed to criminalize material support for terrorism. And it passed with generic language regarding material support for terrorism. But as it first appeared, it was only Sharia organizations that provided material support for terrorism. So it had this whole big thing about Sharia, and the language in many cases was lifted straight from the Sharia Threat to America report. It was saying Islam is a military fascist totalitarian. They had wording that said, the observance of Sharia is prima facie evidence of a desire to overthrow the government. So if you're eating a halal turkey, you're trying to overthrow the government. It was ludicrous. But it was clear that by singling out Sharia, it was never going to pass. And it was really unnecessary. You can just strip that whole language about Islam and Sharia away and pass a reasonable law outlawing support for terrorism, and that is indeed what ended up happening. So it quickly became pretty clear that if you speak of Sharia specifically, or even religious law more generally, it's never going to pass muster. You're never going to get these laws passed. So they changed tact and adopted facially neutral versions of this law that don't talk about religion, they don't talk about Sharia. And by and large, the model for these is what we talked about, the American Public Policy Alliance's American Laws for American Courts model legislation. And this too has gone various iterations. The website, well, the legislation is facially neutral. The website that touts this specifically mentions the need for this law because of the threat of Sharia. And the specter of it somehow creeping into the court system. And has lots of lofty language about the necessity for protecting individuals' constitutional rights, especially that of women and children. So there are two main provisions that exist in it, and then over the years, the last 2 years, they've added specific carve-outs as well to overcome arguments against this legislation and concerns by business community and others about the possible impact. So the first provision is designed to protect citizens from the application of foreign law when doing so would violate their constitutional rights. You can't violate someone's constitutional rights anyway. So this is unnecessary. You can't apply law that's going to violate constitutional right. You always have state law that is above you. You can't violate criminal laws. This is just a total non-issue, and that whole part of the law is just unnecessary. The second provision says the court can't consider any law, legal code, or tradition that would not grant parties the same fundamental rights as in the U.S. Constitution. Now this is really trickier, and it's not clear what this means. So if French law doesn't provide all the same protections as the U.S. Constitution, we can't apply French law. there are a lot of systems in this world that don't have all the same protections. Freedom of press, due process, freedom of religion, Islamic law, Jewish law. A lot of religious laws don't provide equal protection for women. So it seems that just the fact that somewhere in this law tradition there is something that is not totally equal to the United States would mean that the whole tradition would need to be thrown out. It's not really clear if that is the case or how this would be interpreted. It's a very strange, poorly worded provision that can and has, as I will point out in just a second, had really bad impact on people's lives. So the concerns about international law, treaties, business laws have resulted in specific exceptions to the application of these two provisions that are listed now towards the end of the, most of them listed at the end of the model legislation. So this should not apply to Native American courts. This should not apply to corporations. So all business, corporations, limited liability partnerships, everything is not excluded from this law. So they're trying to get away from the concerns that the business community has. It will exclude religious organizations for ecclesiastical matters. So hiring and firing of clergy, church membership, that is not included at all. And it says it's not to be interpreted to conflict with U.S. treaties. So it started out this big, and it's been narrowed down, and all that's really left of it is a veiled but very targeted attack on religious law that's designed only to get, they only talk about Sharia, but it basically will get all kinds of religious law, including Jewish law, in its grasp. So what is the practical effect? There haven't been very many cases after these laws have been passed. They've been passed, I think, in 6 states. But Kansas gives a really good example because there were 2 divorce cases, one before the law was passed and one after the law was passed. That provide a good contrast. In 2010, there was a divorce case of Hamda v. Hamda. And if you go to the website for this bill, this is touted as one of the reasons why we need this law, to protect women, protect women's rights. Because in that case, couple met in Lebanon, they were married there, the wife came over, things went sour, and the husband argued that the Islamic marriage contract meant that the wife was only entitled to $5,000 deferred dower as the divorce settlement. And so this is terrible for women. It's denying women the rights that they would have under the U.S. legal system. They don't talk about what the actual outcome of the case was, only that the husband argued for this. Just like the husband in New Jersey argued that his religious beliefs would allow him to rape his wife. So definitely we need this legislation to protect these poor, defenseless Muslim women. Then in 2012, there was another divorce case with the Soleimanis. The Soleimanis were married, I believe, in Iran. It was a short marriage. There were allegations of domestic abuse. And the wife, in this case, asked the court to enforce the marriage contract. And the court said, oh no, we can't do that. We have this American law for American courts law now, and we don't think that that would be allowed. So the wife, as a result, did not get the deferred dower, which in that case would have been $677,000. So the wife was basically cheated out of what it would have been her legal right otherwise because of this law, it did not protect her. It did the exact opposite. So these laws are really distorting a system that was working fine to begin with. So the laws are unnecessary. The courts already have the tools to deal with them, and I would say that basically they're a red herring. And all they're doing is serving to demonize Muslims, but saying, we're not against Muslims, we're just against Sharia. So Muslims are fine as long as they don't do any of these Sharia things. So I call this the only good Muslim is a bad Muslim paradox.
Thank you.
As a religion journalist, I've written a fair amount about some of the issues that particularly Wajahat addressed, and so I don't want to be redundant to that, although we'll be able to root some of this around during the Q&A. So rather, my purpose here is to provide the contrast, which is to look at how issues of Jewish religious law have played out in the public sector, which I think really provides a significant difference and shows how, while these issues are sometimes painful to are involved in them, they stand in real contradistinction to what Wajahat and Leanne have described, which is the disputes about Muslim religious law, which are actually stalking horses or Trojan horses for Islamophobia. The three types of disputes I want to talk about. If you want to push your baby carriage, if you want to carry your prayer shawl in its bag, if you want to carry a bag of crackers or Cheerios for your child to nosh on during the service, something like that, you can't do it if you're fully observant of the commandments of the mitzvot without being inside your house or symbolically inside the extension of your house, which is the purpose of an eruv. An eruv is basically a piece of thin wire, something like fishing line or very small, generally almost invisible to the naked eye, wire which will be strung from tree to tree or from light pole to light pole over a certain agreed upon area. And in the Jewish or parts of the Muslim world where walled cities were the norm, you didn't need to string up wire because the wall of the city served ritualistically the same purpose. So this is sort of the problem of modernity and particularly the North American and Western European idiom. But it's also, and I have to cite the work of Rabbi Adam Mintz, who's written very well on this already, it's also become a way of an Orthodox Jewish population feeling confident enough to take some of its ritual concerns and needs into the discussion of public policy. Because up to the 1920s, I think there were only 3 eruvim, that's the plural term, 3 eruvim in all of North America. So it's been primarily in the last 10, 20, 25 years in which there's been a more confident Orthodox population, Orthodox Jewish population in the US, in Canada, in Western Europe, when that population has felt confident enough, secure enough, not living in fear of being attacked, where they have been willing to go to generally the local municipality and say, may we put up this symbolic border around our community. And it's very important because not only is it vital for individual Orthodox or just really fully observant practice, even if you're a conservative Jew as well and follow the mitzvot, you would feel the same obligation. But in building a community, in creating community institutions, you're not going to be able to have an effective religious life, an effective synagogue life, an effective communal life if people can't carry within the eruv. And I'll just put one little asterisk next to it, which is that there are some ultra-Orthodox, I hate that term, it sounds pejorative, but let's say fervently Orthodox or Haredi Jewish groups that still don't believe that the eruv is theologically correct and won't do it. But by and large, it's accepted as an Orthodox norm. In any case, so as some of these efforts to get municipal approval for eruvim have come forward, there's been controversy. There are 3 in particular in the United States that I point out. one in Palo Alto, California, one in West Hampton Beach in New York State, out in the Hamptons summer resort area, and one in Tenafly, New Jersey, which is a bedroom suburb of New York City. What instantly distinguishes these kinds of battles from what you've just heard from the other two speakers is that there has been no organized outside demagoguery on this issue. There is nothing equivalent to the kind of reservoir of money that Wajahat talked about. There's nothing equivalent to, here's a great term, a nerve center. There's no one passing around model legislation, supplying it in the way both Wajahat and Leanne described it. The other really significant thing is that the opposition has generally come from fellow Jews. These have been Jew versus Jew, my métier, my little part of the world. These have been Jew versus Jew controversies, and in fact, in reporting on some of them, it's been fascinating to see the non-Jews in these communities sort of scratching their heads and looking at the Jews like saying, will you guys figure it out and let us know what we're supposed to do? Because I think for two reasons. A, they don't want to do anything that will look anti-Semitic. And, well, let's just leave it at that. That alone is a significant enough factor. They don't want to look anti-Semitic. And that's also another difference. So far from the effort of using this to drum up anti-Semitism or Islamophobic feeling, there's been a concern in these communities to step in lightly. And what you see, rather than using these disputes as a way to not only at sort of the familial or congregational level punish observant Jews or whip up anti-Jewish feeling, these controversies are really arenas in which the struggle between observant and less observant or non-observant Jews play out. And it's not accidental that all three of the examples I cite, Palo Alto, West Hampton Beach, and Tenafly, are communities whose Jewish populations traditionally had skewed very much towards less observant. And this is part of the demographic plate tectonics within the Jewish community, that traditionally, and this has changed rapidly in the last generation, the more affluent, more prosperous, more outwardly mobile, residentially mobile part of the Jewish community tended to be unaffiliated or affiliated with the Reform movement or the conservative movement. Orthodox Jews, we can broadly generalize, tended to stay in city neighborhoods, to stay closer to institutions that they could walk to, tended to be poorer, partly because of family size. And it's only been really in the last 20 to 40 years with the advent of the modern Orthodox movement, or really it's not the advent, it's been around since, depending on how you want to date it, at least the 1930s in this country and longer than that with its origins in Germany, but kind of the fulfillment, the fruition of it, in which you have Orthodox Jews, modern Orthodox Jews, going into the professions, becoming lawyers, becoming doctors, becoming professors in non-Jewish areas, becoming investment bankers, becoming public school principals, and developing the same desire to have a bigger house, to have a nice yard, to move out of the city, to move into these suburbs, into these sort of communities of choice, which brings them then into conflict over the communal norms with the non-Orthodox Jews who preceded them. And so that, and the language that attaches itself to these Eruv controversies is the language of Jews saying to other Jews, I don't want to be coerced. Jews saying to other Jews, I want to be able to opt out, as if there's something that's going to be required of even a non-observant Jew by the fact that some fishing wire is strung up between a few trees. And a sense of fear that stores that are owned by Jews but aren't observant to religious law will be pressured into closing on the Sabbath. A pressure, and I think this is the one legitimate part of it, that school systems, public school systems that have thrived with a lot of Jewish students and with a lot of Jewish taxpayers willing to pay high public school taxes will suffer as more Orthodox Jews move in and send their kids to day school, and without the enlightened self-interest of having kids in public school, won't vote as readily for the school tax referendum. I mean, I think that's the one legitimate piece of this, but that alone doesn't explain the vitriol. The vitriol is about other things. And so as you look in Palo Alto, some of the major opponents of the Eruv there, and this dragged on for 7 years before being decided in favor of putting up the Eruv included actually a notable Jewish scholar, Joel Bainan of Stanford University. The leading attorney against it was Mitchell Zimmerman, whom we may surmise from that name is an MOT, member of the tribe. And I'll let you in on that little secret. And in West Hampton Beach, again, some of the leading opponents of the Eruv there have been Jews. There have been 3 different federal lawsuits brought. That case still isn't done. And one of them was brought by a group called Jewish People for the Betterment of West Hampton Beach. And in Tenafly, New Jersey, the initial vote, which was later overturned by a court in the Borough Council to refuse to put up the Eruv, was a unanimous vote, but 2 of, I think it was the 5 members of the Borough Council were Jewish, and I can tell you from having done first-hand reporting on that case, the non-Jewish members of the council were completely looking to the Jewish members for the cue of what to do. They didn't want that mess. They didn't want to be part of that controversy. And they really looked for the clue, and I think they were taken by surprise when later the Orthodox community got a chance in a more aired-out way to tell its story. So this could not be more different than what's happened with these ginned-up, devious anti-Sharia controversies. I mean, the effect and the way these are felt by Orthodox Jews is similar in the sense that they feel that an effort is being made to make a community unlivable for them. And in fact, I sometimes say that these battles brought by less observant Jews against observant Jews over the Eruv are the contemporary equivalent of the restrictive covenant with which non-Jews used to keep Jews out of a neighborhood. If you don't allow an Eruv to go up, you're de facto creating a restrictive covenant against Orthodox Jews. Okay, I have 5 minutes, so let me quickly go through the other examples. Another controversy that's flared up in New York specifically is over a procedure called Metzitza B'Peh. Now, we know as Jews and Muslims about the religious requirement to circumcise a newborn male. In certain very Haredi, very fervently Orthodox circles, there's also a belief that religious law requires some of the blood from the male penis after the circumcision to be sucked out, to be extracted by mouth, by the mohel, by the man who's done the circumcision. And this has led to anywhere from a total of 12 or 14 cases of infants in New York dying from having contracted herpes to, I've seen one estimate of 15 a year. That hasn't been ratified by the New York Department of Health. But in any case, this has been a significant public health problem, which already makes it very different from these anti-Sharia efforts or refusing to recognize international law efforts, which have no public health application whatsoever. And so in New York City, there was an extensive debate about what the public policy response and the public health response ought to be. And ultimately, what I thought was a very diplomatic solution was that the New York City Department of Health requires families to sign a waiver, basically acknowledging the risks of this procedure and saying we want to do it anyway. So an informed consent. I think you very easily could have made a case to outlaw it entirely because the newborn has no way of giving consent, and the newborn is the one who's at risk. And while a small fraction of the Orthodox Jewish world, which makes it an even smaller fraction of the total Jewish community in New York, went to court to oppose this, first of all, they lost in court, but also they were opposed on this not only by non-Orthodox Jews, but also by many Orthodox Jews whose religious leaders and whose decisors of Halakha have said there's not a textual basis, there's not a basis in rabbinic law for doing this procedure. So again, very different. And then the last example, which is the one that bears maybe a bit of parallel to what we've talked about earlier, were the efforts in California, one in Santa Monica and one in San Francisco, to pass ballot measures that would have outlawed circumcision altogether. And these are largely driven, although they've included some prominent Jewish people, I think they're largely driven by both, I'd say, a somewhat misguided application of children's rights, but more than that, by a very ascendant atheist movement in this country, which sees any role of religion in the public square as being anathema. And that movement has become much more willing to assert itself in ways such as this. And so in San Francisco, until actually they had in 2011 a ballot measure up for November, a judge later struck it from that. In Santa Monica, they never got enough signatures, and the whole issue for California was ultimately settled when the state legislature passed a law that would bar municipalities from banning the practice of circumcision, and Jerry Brown signed that. But I think here is the only example in which you had an attempt to demonize religious practice, to make it atavistic, or to portray it as atavistic, superstitious, cruel to children, and to drum up a groundswell of public opinion on that basis. I think one of the things that really helped fight back against it in these cases, aside from the fact that it created an instant alliance of Jews and Muslims, which immediately meant it couldn't be used to pillory just one community, is that there were strong public health arguments in favor of circumcision. And in fact, at the very time this controversy was flaring, the American Academy of Pediatrics came out with its most recent report on circumcision and said that the health benefits outweighed the health risks, particularly in terms of HIV and other sexually transmitted diseases being more likely to be acquired by a male who had not had a circumcision. And also, we haven't seen anything like this flare up anywhere else in the country, nor has there been any kind of organized effort to transplant this in the way that we've seen, with the anti-Sharia issue popping up in state after state after state. So that's, I think the very instructive contrast from the Jewish side of the tracks, and I think what it shows is something we can aspire to someday for American Muslims as well, which is that dispute and discord about the application of religious practice in the public sphere can take place without being something else, without fronting for something prejudiced. Unfortunately, as you've heard, we're a long way in terms of the American Muslim idiom, a long way away from that now.
Very interesting. I want to give the panel, I think, a brief period to respond to one another. If you had more things you wanted to say in response to each other's presentations, and then open the discussion up more widely.
So, a lot of the rhetoric aimed against Muslims today really echoes stuff that was used against Catholics earlier in the century. Not as much, but some against Jews. How do you feel that the Jewish community got to the point where it is now, and what do you think it will take for Muslims to get there?
That's a good question. I think one reason maybe that kind of bigotry didn't attach itself in the same way to Jews as it did to Catholics. Mm-hmm. The bigotry against Jews, first of all, I am a believer in American exceptionalism as far as the Jewish experience, and even at the worst moments here, there's been nothing for Jews parallel to what they experience in virtually all countries in Europe. So even during the Henry Ford and Lindbergh eras, even during the period of restrictive covenants, it's not comparable. But one reason we weren't singled out the way Catholics were is that Jews were very much part of the public school system. And also because Jewish, in spite of the fevered imagination of anti-Semites and protocols, the Elders of Zion, Judaism as a non-hierarchical religion, as a religion that's multivalent and doesn't have a single head Jew in charge, wasn't vulnerable to the same kind of misportrayal as American Catholicism was. Because if you look back at, say, at the vicious rhetoric used against Al Smith when he ran for president in 1928, which is the exact parallel, the analog to what Barack Obama has had to deal with the exception that Obama isn't Muslim and Smith actually was Catholic. That little footnote. But it was all about the Vatican running the country, and it was very much about Catholics being portrayed as aliens, partly because they'd created a Catholic school system for themselves. But why had they done that? Partly as a bulwark against forced Protestantization in the public schools. So I think that one of the reasons Jews weren't subject to the same kind of prejudice is because they didn't set up parallel institutions the same way. Another reason is that there wasn't one person you could point to as the evil puppeteer In the way you could point to the Pope as being, you know, the fifth column incarnate.
It's interesting because there is no, except for certain brands of Shia Islam, there is no hierarchy like that.
Right, Islam is very multivalent as Judaism
Yeah.
is. I think that Jews, and this is a complicated reality also, if you know the language of white studies, Jews became white. You know, Jews were, in the binary American view of race, ambiguous for at least the first couple of generations. You see this particularly in the American South. Were they white? Were they black? What were they? And over time, as we've, you know, done well in this country, as we've become more present in the public life, as we've given aspects of our religious culture, but also our popular culture to the broader country, you know, we've really impregnated it and in turn been embraced by it, you know, even literally loved by it in terms of interfaith marriage. That's whitened us. That's whitened us in the white studies scheme of things, just like Irish and Italians were whitened. And using that white studies archetype, Muslims haven't become white yet. And I'm not recommending it. I don't think it should require it for anyone, Jews, Italians, anyone else. But as a fact of American life, that seems to, you know, to be the case. And it's also, I think, that there was never a concerted effort that Jews had to face of presenting them as the geopolitical, as the military, as the national security enemies of the United States. The anti-Jewish discourse never took exactly that role, and that's a very hard negative to disprove. How do you prove that you're not, you know, the gremlin on the wing of the American
Especially when you're
Republic?
lying because of that.
Right,
Yeah.
we all know that.
But Jahat, did you want to?
Yeah, you
Oh,
can
yeah,
add-
no, it's so much to unpack, but I mean, the question of being absorbed into whiteness and thus being mainstreamed is a problem for American Muslims, where 2/3, you know, come from immigrant background with the most diverse religious community in America in terms of racial makeup.
And the largest group is African American.
Well, no, but close. I'm not trying to, just for technical purposes, it's like 30% African American, you know, 30% South Asian. They say about 25 to 30% Arab American, then the great miscellaneous. But you know, the question then assumes is also what's going to happen in the 21st century now that we're a minority-majority country. Will that shift the landscape and make us mainstream in a country which is very useful to, which is now elected biracial president? And this is a tension. This is a tension within the community. As far as the narrative goes, I think you made a good point, is that American Muslims, despite being here, some would say, even they came on the Columbus ships, and a third of the slaves that were brought over here against their will were Muslim. So we've been here, if you will, from the beginning of the country, our narratives run deep in the American soil. And yet, it's 2013, and I would say the American Muslim narrative, or American Muslim narratives, is anchored in perpetual stasis around national security. So the concept of the good Muslim versus the bad Muslim is always colored by national security, in the sense that the good Muslim is he or she who is either helping law enforcement and or one of the good guys who is not one of them, the terrorist. And if you're not, and that's it, right? And your entire utility as an American Muslim, anchors around what you are doing to help national security, which is very dehumanizing and humiliating, and robs us of the great achievements that we've made in the last, especially the last 15, 20 years in academia, in law, in media, which we're still lacking. And I think there's something that I always tell people to learn from our tribe from another mother, is that, you know, Jewish American communities really did something, I think, that has really benefited their community and America, in the fact that they've become cultural contributors. Especially when it comes to media, especially when it comes to pop culture, especially when it comes to academia, when it comes to political life. There was this fantastic study that came out in 2002, was a statistic that said in 2002, 90% of American Muslim professionals were part of what I call the Holy Trinity. They were either doctors, engineers, or the catch-all business.
Yeah, no, we make Muslim immigrant parents cry at Columbia J School graduation.
Oh no, the fourth is failure. But it's something that we've learned from, and the last 10 years, and I just want to, there's something about that, 9/11, the two towers fell, a moment of tragedy and crisis, also forces communities to have introspection. And I think we've seen the emergence of these new proactive, I would say rather progressive Muslim communities grow up, making some of the same inroads, learning from Jewish American communities, that this is how you not only, because you are the multi-hyphenate identity. You can't just cut off your Muslim hand, cut off your American hand. People are like, I'm Muslim and American, there's no conflict. But it's a sense of, I think, this implicit contract that someone talked about yesterday. We belong to this country, the country belongs to us. And shared narratives. I'm sorry that I just made me talk about these
Well, can I
things.
just add one thing? I think you're so right, but what makes this especially tragic is that I think things were trending in the immigrant absorption model right up to September 11. And actually, what's worse is that it wasn't the immediate aftermath as much as the concerted politicization by Islamophobes after. The kind of gets worse the more distant you get, which would be the opposite. But if you think about where we were, in the 2000 election when both parties were vying for Muslim voters, Newt Gingrich, who later changed totally, put a Muslim prayer room in the U.S. Capitol. When you saw Muslim American athletes, these could be heroes to kids growing up and worshiping star athletes. So things were really heading, in a direction, probably not as fast as it happened for Jews and Catholics, but heading that direction. And the tragedy has been so reversed.
Can I just wait, as far as the research goes, what they say, I just want to mention the research, I'll be finished. What they say is the two underlying root causes of Islamophobia, if you really want to break it down, they say is the following, is ignorance. There was a time study that was done about 2 years ago that said 62% of Americans say they don't know a Muslim. All right. So number one is ignorance, and that's important because it's not malice. Most of the studies show that Americans don't have a malignant heart towards Muslims. Most of them, they say, I just don't know most Muslims. The second part, they say, is what they do learn about Muslims and Islam, they get from the media and media misperceptions, and specifically sensationalized media reports. And the American Sociological Review came out with a study about 3 months ago, that said the major discourse about Islam in the media, especially in the past 10 years, has been shaped by many of the people that I unfortunately mentioned. And the mainstream media has kind of plugged on these anchors. And what we've also seen as the trends that have caused a recent spike of quote-unquote Islamophobia in the past 10 years, I just want to mention them, is the 9/11 tragedy, the election of Barack Hussein Obama. I know it's humorous, but that's the 2010 Ground Zero Mosque controversy caused a recent spike, huge spike, according to Southern Poverty Law Center. The anti-Sharia meme has also been globalized. And also what people are saying is the fact that this country is becoming a majority country. This is huge, and also some of these factors, and also the sixth one, and a very important one, which is also the factor leading to this exponential rise in anti-government and anti-immigrant hate groups in the past 5-10 years, is the economic collapse of the past 4 or 5 years. This has made this a very volatile, if you will, cultural space, with the ignorance and the media misperception that is exploited by some of the people. And I think explains why what you were just saying, there has been this resurgence. I'm done, I promise.
No.
I want to open it up, Rob. I will just to jump off of something you said just now and echo, Dean, I'm proud to say you are speaking at a majority-minority university. We've been both quite a while. So I already have a queue going, and I will keep a queue. If you have a very short comment directed immediately at the last comment, put your hand up like this. Otherwise, ordinary hand gestures will do. So, Michael, Mohammed, Tim, Shlomo, and then we'll keep going. Yeah.
I want to maybe pick up on that last kind of list of factors, and also maybe push back a little bit against Sam, some of the things you just said. Maybe like 10 months ago, with the recent Hamptons Arab controversy, I wrote a piece in the LA Times. Just normal op-ed, I thought not much of it. And then I got a call later that week from somebody at the LA Times saying they had received so many phone calls against my pro-Arab article that they wanted me to write a follow-up, kind of responding to critics. And I was kind of taken aback by it. I actually thought what I'd written was kind of like straightforward. It was like what every place had ever said. And the pushback wasn't just kind of local. I'm writing out in LA, like, it was national pushback.
How much was Jewish help? That disproportionately.
So I think that's right, although I guess more national than local. And then kind of what you touched on at the end about the circumcision stuff, the way in which it's funded by largely by mgnbill.org, a national organization that has its own that model legislation that it tries to push on the federal and state level. And part of me makes me wonder, if there's, I feel like part of that debate, there's like an LGBT component too, like resistance to heteronormativity, and part of that kind of pushing some of the anti-circumcision, which gets kind of bound up with some other issues. And I guess here's what I'm really wondering. Maybe some of those factors that Wajahat mentioned should make us think that it's not just that we're going to have two different paradigms. There's a Jewish paradigm where it's kind of internal and local, and an Islamic paradigm where it's going to be national and invidious, but that maybe we're, this is kind of a sad thing to think about, that we're seeing a turning of the tide, that kind of the Islamic model as to how minority groups are treated in the United States maybe is going to tip, and we're going to start seeing more and more resistance, not to just, Islamic initiatives, but Jewish initiatives, maybe the way in which even the Islamophobia and the Sharia, anti-Sharia legislation is now incorporating Jewish law and other things. That's going to be the new paradigm that we face as minority religions in the United States. And I'd love for you all to tell me something really happy about why I'm wrong.
Well, I do think that Jews and other religions are getting caught up in this anti-Sharia hysteria. I think Canada was a perfect example. Jews had used arbitration act with no problem, and nobody said anything, and then when there was talk about doing it by Muslims, they just said, okay, nobody can do it. So I don't know what the Jewish community is doing in Canada, and there I would be interesting to see whether they're still doing bakings, but I see it primarily fueled by fear of Islam, and there's a little bit of this secular backlash against religion as a whole, but I don't really think that's a huge part of it.
Anyone else?
Yeah, I just don't, again, I really don't see what you're describing as a resurgent anti-Semitism. I think if there's a cutting edge, it's what Leanne just described. It's more, a very vigorous, assertive atheism that really hasn't been part of the American public language in quite this way for a long time, if ever, that sees anything that brings religion into the public square as objectionable. And as someone who's been through both a civil and a religious divorce, and now a civil and religious remarriage, of course it would horrify me if someone would say, how dare New York state law, incorporate in Sam Friedman's, divorce decree that, the settlement money isn't paid till the, till the get is given to the ex-wife. That's just such an ordinary, prosaic way of civil law acknowledging, a parallel track of religious law. But if the fight happens against that, I don't think it's driven by anti-Semitism. I think it's driven by anti-religion, period. In fact, in the religious sphere, we're looking at the 50th anniversary of Vatican II this year, which is the paradigm shift in Jewish-Catholic relations in this country. The end of deicide totally remade relations between, not just at the level of elites, but at the grassroots level between Jews and Catholics. And while I find Christian Zionism, because of its its expansionist view of the land of Israel and Palestine, very problematic, and I don't have trouble with it, at a more cultural level, there's been a de facto Vatican II experience for evangelical Christians in this country, who I think in many ways have given up or downplay their supersessionist and millennialist way of looking at Jews and see Jews as part of a religious continuum rather than as deviants who need to be replaced. And I think that, you know, Jews and Muslims in some ways are pit and conflict against each other in this country, which is terrible. In some ways have become allies and see parallels among themselves. So I don't see it as, you know, we're not dealing with religious folk, you know, trying to stigmatize us as Jews. We might be dealing with, you know, again, very secular folk who would find anything, even what I described from my divorce, as, you know, objectionable. And I'll stop there.
Maybe actually, I would love if you said a little bit more about, I'm sorry, I just wanted to hear, I completely agree that this is not anti-Semitic and more now looking more like anti-religious. I'm just curious if any of you kind of, just to follow up on that piece of it, if you have something to say about where we're headed.
I mean, I want to actually talk about some good news, only in the sense that I do believe that it is, well, I mean, Chris Hedges described it as the rise of this militant atheism as a new fundamentalism in a book about 4 years ago. And I don't know if you guys have been following the conversation, specifically Glenn Greenwald in Guardian and Nathan Lean in Salon about 2 weeks ago wrote these 2 pieces calling out these, like the henchmen of atheism that have been really kind of resurgent, and these articles that went viral, specifically Richard Dawkins and Sam Harris and the late Christopher Hitchens. And I think there is something about the rise of militant atheism that is uniting religious communities of shared values. And I think also, and this is why I want to say some good news, is unfortunately the fact that this anti-Sharia legislation has united in the past 2 years, cousins from other mothers, if you will. And specifically when it comes to, I want to give just 3 quick examples of why I think that we're on a trend towards something hopefully good. Because I do hope that the Islamophobia tide has reached its highest peak and is receding. In Florida last year, the Sharia bill was introduced, and it was in large parts thanks to the Jewish American communities and the rabbis of the communities who stood up with Muslim American communities and leveraged their support that those bill died in Florida. As far as the cultural space goes, about 12 years ago, 13 years ago, no influential pop culture personality really went out of their way to bat for Muslims. Now, I gave the example of the Florida Family Association's petition against the show All American Muslim. But there was a petition against that petition that said Lowe should not cower to bigotry and fear, and that was signed by, I mean, this sounds like a joke, but it was signed by gay blogger Perez Hilton, Rabbi Mark Schneier, William Donahue of the Catholic League, you know, wasn't really a friend of Muslims, but stood up for this, Meghan McCain, hip-hop mogul Russell Simmons, Susan Sarandon. That never would have happened. And also when it comes to, I think, the activism space, you guys have been following Stop Islamization of America's Metro ads the past 4 or 5 months in New York, DC. Everyone knows what I'm talking about. Pam Geller and Robert Spencer have come out with these very inflammatory ads. In the war between the civilized man and the savage, support the civilized man, support Israel. And also the other one is they have a photo of the 2 burning towers, and next to it they take a Quranic quote out of context saying, attack them where you find them. Well, right next to those ads in New York, very similar aesthetic ads, it almost looks like a duplicate copy, were taken out proactively by sojourners and rabbis for human rights to show that this should not be happening in America, and this is poisoning the communal well. So, and I also think in the political space, some good news is even though Michelle Bachmann won, she narrowly won. But Alan West, and I'm giving these names if we had more time, these people work in concert with the people that I mentioned. Alan West called Frank Gaffney his mentor, and Michelle Bachmann supported the 2010 Sharia threat to America. She did a press release for it. Alan West lost. And your own elected official here, Joe Walsh from Illinois, you guys remember what he did last year, went to a city council meeting and said, these Muslim neighbors here, they're out to kill you. He lost. And I think, so what we're seeing is a trend now, hopefully, towards some shared values. And I think, ironically, the Sharia legislation, as Leanne has said, in its current manifestation, should really give pause and concern to religious communities. And we've seen Muslims and Jewish groups come together in places like Florida. And I hope that it's a trend. And I think, I can give you a specific answer as to the rise of this militant atheism, but it is on the rise. And I'm very curious to see how religious communities keep uniting in concert. I hope I gave an answer to your question.
Muhammad.
I was just going to make a point that I think Sam, when you made in his closing remarks, that I think really the situation of Muslims in the United States is very different than other minorities because of the national security dimension. If you go back to, I think it was Frontline did a story on the Murfreesboro mosque controversy. And they were interviewing this otherwise very sweet middle-class woman in Murfreesboro about her objections to the mosque. And at the end she goes, well, it's the religion of our enemies. We are in all these places fighting them, so why are they going to build a mosque here? And I think that is a, whatever, how illogical or irrational, it's very visceral. And it's a very hard thing to, first of all, I don't think it's impossible to deny. It's useless. I think it would be very, very silly for Muslims in the United States to ignore the fact that the United States is fighting, and for the foreseeable future will be fighting numerous wars in Muslim countries. I mean, that's just sort of the way it's going to be, I think, for my lifetime, unfortunately. And I think that's just, that's going to have a dramatic impact on Muslim rights in the United States. So anyway, the second thing I want to point out is I don't want to lump this all on right-wing nuts. I mean, the right-wing nuts are right-wing nuts, and they are despicable, etc. But unfortunately, in this case, the federal government is really taking the lead, in my opinion. Right? You can go back to 1996 legislation criminalizing material support to terrorism. If you go and look at that criminal provision, those criminal statutes, there are actually two statutes. One is criminalizing material support for foreign terrorists, and the other is criminalizing material support for domestic terrorists. And there's an important difference in the two statutes. For the criminalization of material support to foreign terrorists, no purpose element is required, right? Whereas for domestic terrorists, there is a purpose element. And then in the congressional record, it says because there's nothing redeemable about foreign terrorists, whereas there might be something about domestic terrorists that have something, so we have to prove that you intended, the defendant intended to further violence, right? So when you introduce this nebulous kind of statute that doesn't require any intent or proof of any sort of intent to commit violence in order to commit the crime, then you get this kind of infinite chain of causation, right? Which is what the right wing is using, right? Of course, if you're wearing a hijab, you're contributing to terrorism because we can look at this link of inferences, right? But that's exactly the reasoning the federal government uses, right? I've testified in different terrorism cases, and the kinds of evidence that the federal government uses to convict people is very similar to the kind of reasoning that these right-wing nuts use. So I'm sorry to say this: the rot begins from the head, as they say, the Turkish saying that if the fish begins to rot from the head, right? And it's spread down, and unfortunately, the federal government has been the greatest teacher in this regard.
Now, I just want to give an example of the national security narrative and how we're going to unfortunately be dealing with it. And I just want to touch upon how the local becomes the national, becomes the international, and why we should be so concerned. If we are really concerned about national security, why should we be concerned with Islamophobic invectives? All right, just real quick. The studies have shown that our enemies abroad, you could call them Al-Qaeda and Taliban, the number one recruitment tool and the number one propaganda that they use that has worked is the following. The West is at war with Islam. Now, I've traveled around Muslim communities for the past several years, and I'm telling you, they are very acutely perceptive as to what's been happening in the U.S. landscape. I was in Turkey, and they're like, in Pakistan, they're like, man, this Harman game, this is crazy. I mean, they're acutely aware. They follow U.S. politics. They'll make Sharia, man. What the hell? I can make that accent because I'm Pakistani. You can. In the U.S., if you hear the language is Islam is at war with the West. Extremism seems to beget extremism. I want to just give you two quick examples, if you don't mind. Anders Breivik, the Norwegian killer, 2001, left behind a 1,500-page manifesto where he detailed exactly why he killed 77 people, mostly children. He said that he wanted to punish Europe for becoming Arabia and for being very lenient towards multiculturalism and specifically towards Islamization. In his 1,500-page manifesto, he cites every single member that I mentioned in the Islamophobia network. Mark Sageman, counterterrorism expert, reviewed the document and said we can't blame the people of the Islamophobia network for causing this, but he, Breivik, emerges from the same infrastructure. The rhetoric is not cost-free. Speaking by Ground Zero Mosque controversy, for those of you who remember, Pastor Jones, the dude with the handlebar mustache, looks like Yosemite Sam. You guys know him? He has a constituency of like 3.
Yeah.
But we were talking about this.
Yeah, literally 19 or 20.
And he's becoming an international figure. He said, if you don't move the Ground Zero Mosque, I'm going to burn the Quran. So what people don't forget sometimes is in April 2011, he actually went ahead and burned copies of the Quran. The Afghan Taliban were waiting for that to happen. About 2 weeks after he did that, they laid a siege on the UN compound, killing nearly 24 civilians. When asked for justification, the Afghan Taliban said, the West is at war with Islam. Pastor Jones burned the Quran. And I think the national security, I just want to touch upon the national security component, and I think you're right that many people share the same, I mean, I don't know if it's the head, there's a difference of agreements about the federal government, but the federal government has used many people of the Islamophobia network as experts when it comes to training law enforcement. And specifically when it comes to FBI, counterterrorism officials, it got purged based on the Wired article that came out last year, but Robert Spencer's information about Islam and Prophet Muhammad was being used to train FBI recruits who would then interrogate potential Muslim terrorists. So there is a component of law enforcement, both at a state, local, and federal level, that I think has unfortunately worked hand in hand. I'll give the last example is the AP Pulitzer winner from 2011. You guys have all followed it, where the new NYPD widespread surveillance of Muslim communities for no other reason that they're Muslim. I'm talking about schools where they eat, even elite universities like Columbia, where they infiltrated the MSA and went on a kayaking trip, and the reports were they talk about praying a lot. I'm not making this up. They want to pray 4 to 5 times a day, and they're very religious. And a year after AP's groundbreaking Pulitzer report, the NYPD had to admit that as a result of investing all this time, this money, and these resources in counterterrorism, they found nothing. I just want to comment on that. I hope, sorry for talking so much. Tim.
During all the comments, I just want to make an observation, especially to Wajahat, that I don't think it's a coincidence that the anti-Sharia legislation in some ways uses the examples of court cases. Because I think that court cases have a certain ability to legitimate and they have a certain ability to go viral in American political life. And a great example of this is in a slightly different field. If you look at the tort reform debate, so the whole country, I mean, 15 years ago, nobody in America knew what the law of torts was, and no one had ever heard of it. And most voters now have some view about the tort reform debate. And one thing that everybody knows about the tort system is the McDonald's coffee case.
Yep.
Now, right? I mean, 15 years ago, people asked me what I taught, I told them they never heard of it. People ask me what I teach now, and I say torts, and they say, oh, the McDonald's coffee case. So, just as in the cases that you're describing, the McDonald's coffee case is misdescribed, or the famous case of the woman who got compensation damages for being a psychic, right, which is also a case that either never happened or was quickly reversed on appeal. Those stories were leveraged by the business community and the Chamber of Commerce to create a narrative that was then used to leverage legislation in state houses around the country. And the pattern is extremely similar, and I would say even more pervasive in a sense. I mean, Islamophobia is a few years behind the tort reform movement, but the mechanics of it, which you seem to be interested in, can be clearly traced. And one of the things that's so difficult about this is that in order to change the narrative, you have to introduce complexity into what the case was really about, or what the grounds of decision were, or why it is that this was self-corrected by the judicial system internally. And those complications actually don't make for particularly successful narratives in American political life. And so the ability to leverage kind of outrageous cases seems to me as a stock tool in the building of political movements in the United States that also lead to this sort of widespread move for legislation.
I think that's a very astute observation. I think the fact that you talk about narratives is key. And the counter-narrative, we're in the space now in the past 5-10 years when it comes to lawyers or activists or journalists or people in the pop cultural space. How do we create either counter-narratives or alternative narratives? And the one thing, I mean, I'll give credit to the Islamophobia industry for a lot of things they do, which just sounds strange, is they're very good at creating these emotional narratives. They anchor, which is, Leanne talks about, it's almost absurd, but the absurdity of the legislation becomes nullified due to this very compelling narrative that taps into an emotional root, right? And they run with it. They run with it quite well for both their constituency and both for these memes that go from local to national to international. And it seems sometimes that those of us who want to inject sophistication, facts, sometimes are unable to make a compelling narrative to the people that includes the complexity but also taps into the emotion. And to be honest, we've been talking about the last 2-3 years behind closed doors. Oftentimes people are in a space of, okay, let's hit them with facts. Let's hit the public with facts. Sometimes, as you know, public couldn't care less about facts. As Mom was saying, you seem nice, but you're a good Muslim. You're not like those guys. They're trying to kill us. And that narrative is like steeped in the head. So I think you made a very good point, and we're still in that space now of crafting narratives.
Yeah.
You guys want to talk about
Right, I mean, with being a journalist and a journalism professor, I can make a couple of observations. One is that if you're not trying to be accurate, then all you need to do is sort of refine your message. And just that phrase, ground zero mosque, I don't know if it was a lucky guess or if they focus grouped it, but by making that the phrase, the first thing you had to do was, in covering that accurately, was try to walk it back and say, well, actually, it's not a ground zero, and it's not actually a mosque. And for that matter, as I wrote about in my column, there had been a Muslim prayer room in the Twin Towers, so what? But it's hard for that complexity to win the battle against a simplistic label. I think another point that I would make that goes to something Wajahad said is that there are all kinds of advantages to the digital revolution in media, but there are huge disadvantages too. And two of them that really come to play in the current climate are, number one, the line between a professional and an amateur, or between a real journalist and an ideologue, has all but vanished for most news consumers. When people get tweets, when they go on the web, all too few of them can discern when they're reading a curated site that at least makes an effort either to be nonpartisan in the American journalistic tradition or to be responsibly partisan on one side or the other in more the West European tradition. Between that and between just rampant advocacy or no pretense of verification at all. So it's very hard to discern for much of the public what they're getting, what its provenance is, how believable it is. And then the second thing is that it super empowers, this is like one of Tom Friedman's phrases, it super empowers a Terry Jones, or this is more about homophobia than Islamophobia, or a Westboro Baptist church, that you can be what they call in black church a jackleg preacher. Basically a preacher who's kind of a fraud. And if you can do something outrageous enough to get picked up on the news, then it's instantly going to echo around the world. And it's so difficult at times. I wish the journalists would agree to just boycott Westboro Baptist, boycott Terry Jones. But the problem is that even if we did, they can still through Facebook, through YouTube, as we saw, with that, crazy, bigoted, version of a movie that that the Coptic Christian from LA made, put it out there anyway, and it becomes its own reality. So how do you get that stuff back in the box? I don't have an answer. Then the last thing, something that really saddened me, when we're talking about what are the counter narratives. So I'm a big pro football fan, and as I was watching all the games this fall, I kept on seeing this Prudential commercial. Even though I usually have the sound off, but they put the guy's name up, and it was Mushahid Abdul Rashid. And then I said, wow, he's like a Muslim guy in the TV commercial selling insurance. How great is that? So I actually deigned to put the sound on during a football game and, heard the text, which was very wonderful. It's him talking about being a grandfather, and you see him going fishing with his grandkids, et cetera, et cetera. So I thought, this is so admirable. This is such a healthy sign an identifiable Muslim being used to sell an ordinary product like life insurance or annuities. So I decided to do my column about it, and got a hold of the ad agency that put it together. They were psyched, they were proud of it, justifiably. Got a hold of Mujahid Abdul Rashid. He was really happy to talk about it. But Prudential didn't want to own their own good deed. First they didn't want to talk at all. Then when it became apparent I was doing the column with him or without him, they released these preposterous statements that they had no idea that he was Muslim. No. And I thought this is the really sad postscript to a really admirable piece of popular culture, which is that you do something that in its own way is a blow for tolerance, and then you want to distance yourself from it. And that was as depressing as some of the Gellerism that's out there, that even when there's a positive thing, people like, oh, New York Times is going to point out that we had a Muslim on that commercial. Yeah, that might be bad for business. Let's, let's hold that at arm's length.
I have a longish queue, and I think what I'd like to do at this point, we're not really running out of time, but just to make sure everybody gets a chance to be heard, is take questions in a little bit of a bunch. So if you guys take notes to make sure you remember what happened, I'll take them 3 at a time. At the moment I have Shlomo, Inamo, and Sylvia, and then then I know about another 3.
So I'd like to make I guess a little bit of an observation and also a question in relation to the anti-Sharia laws that obviously affect Islamic arbitration and in the U.S. Because I've done a little work in this area as well, and my sense is that, and this goes back to what Michael Helfand spoke about yesterday, is that a lot of this, at least in the non-popular, in the legal community, in the political and legal community, a lot of this seems to have to do with a misperception of viewing Islamic law, Sharia, Islamic courts, and arbitration tribunals and the like in religious rather than legal terms. And in many ways, I don't think this is the case with Jews anymore. And part of the reason I think that is so is because there have been developed over time, and I think that's one of the key things in this entire discussion, is that it just takes a lot of time for a particular community to kind of become a normative presence in American life. But over time, Orthodox Jews have developed various organizations: Orthodox Union, Agudath Israel, Beit Din of America, the Rabbinical Council of America, other Yeshiva University, various institutions that play a very major role in lobbying, in general political life, people looking for a quote or a comment. They can get one from the head of the Orthodox Union, they can get one from the president of Yeshiva University, and that represents something about what Judaism is, what Jewish law is, and makes it far more accessible and far more understandable to the wider society, and particularly those in the legal political community who are willing to think of these things in a nuanced, sophisticated way. And I wonder whether there is any sense in the Muslim community to use organizations like the Fifth Council of North America, like AMJA, other organizations. I don't know how many there are or how widespread they are, associations of mosques and imams, and to kind of take on this, become gradually more sophisticated at dealing with the public, interacting with political community, legal communities, journalistic communities, and kind of getting the message across that a lot of, especially with respect to Sharia, that a lot of what you're dealing with is law, not religion. I think there are places to inject nuance into the discussion where people are receptive to it. But if there aren't organizations and institutions that are seen as being authoritative, and again, part of the problem is that there's no hierarchical organization really for the religion. But if there are such institutions to make semi-authoritative statements, persuasive statements about Islamic law, about Sharia, what it entails, how it works, that might do something significant to kind of begin to shift things into a more honest understanding of what's really going on and what's really at stake.
Now, two very brief points and a question. You mentioned taqiyya in your talk. Taqiyya is basically a Shia principle and not a Sunni principle, which is that you can hide your faith if your life is in threat. You mentioned about David Shalabi, who is involved in this entire Islamic phobia. I just wanted to add that another dimension of that is that how these things play then in the Muslim community. That when they see that, it creates this perception that it is actually Jewish community or some kind of Jewish conspiracy that they are trying to demonize Islam. They don't, since Muslim community does not understand very well the Jewish community, various shades of opinion, their internal diversity. So it has this dimension too, that it reinforces a prejudice which exists in the Muslim community, hurts our community relations. My question is that, and again it somewhat follows what Dr. Fadil says, that is this war against Sharia is part of a global foreign policy in which particularly some Republican lawmakers and politicians, they see that in post-Arab Spring there are rising Muslim political movements, that Sharia is very important part of their agenda, like Muslim Brotherhood and elsewhere. So they see that America is at war with this interpretation of Islam, and they want to secularize these societies. So they do need to create a very strong negative opinion of Sharia, so that these conflicts should be justified, because you are fighting against a kind of evil ideology, and it gives you a moral justification of these conflicts. Is that possible, or it's just a domestic thing?
Yeah, I just wanted to respond to something that was a couple of comments that were made earlier about an alleged rise in atheistic radicalism, and that this has something to do with this issue. To me, this is quite an astounding thought. Those of us who are not affiliated with any religion actually have exactly the opposite feeling, that the religious influence is increasing in this country. There is no place for an atheist in public life. No politician would admit to being an atheist, and I'm sure that none of these people in the organization, this whole group that you're talking about, I'm sure none of them self-identify as atheists. So I don't know where this is coming from. I mean, I just feel quite surprised, and I'd like to have some evidence that the radical atheists are at all involved in any of these things that you're talking about.
I inadvertently switched Sylvia and Charlotte, so I'll add in Charlotte and then we'll take another group.
Well, it's a little bit supplementary to that, because I also wanted to question that point, and I think in the end the comparison with Europe is sort of instructive on that, and I think of the circumcision case in Germany, where, these things all become indicators of there actually really is, Germany is supposedly one of the most atheistic and religious countries in Europe. And so there that seems to be warranted, that is the driving force behind that, and Islam now comes to represent religion, quote unquote, more than Judaism. And the argument, one of the most intelligent arguments that I read in that whole debate on the attempt to illegalize circumcision was that, what's his name, argued that if the Muslims had been the only one who circumcised in a second, that would have declared it illegal, but because the Jews also circumcised, Germany had a PR problem, and therefore, right, they had to make, based on that, had to make a
Holocaust always gets in the way.
Exactly, but and to supplement your point in the end, according to the Pew Forum and all these surveys, America is one of the most religious countries of the Western liberal democracies compared to Europe.
Okay, we have a lot on the table here on this.
Can I start, and I'll address Shlomo? I would argue it's the opposite. It's not that you see Islamic law as religious rather than legal, but popular opinion sees Islamic law only as legal and not as religious. If you ask people about Jewish law, well, you've got, kosher, and you've got prayer, and you've got things like that, and those are all religious. But if you ask about Sharia, it's, well, they amputate, and they behead, and they stone. And when I was talking to my brother one time about working on this ABA project about Islamic law, he immediately said, oh, well, we don't want Islamic law in this country. I mean, they kill people. I said, I'm in Georgia. We kill people anyway. I mean, so I think getting people to see more that Sharia is not necessarily these criminal laws, which I have not met a Muslim who wants to apply these criminal laws in the country. Even when they do want Sharia tribunals, it's more for domestic issues, some contract, marriage and divorce, definitely. Women need tribunals, Muslim women need tribunals oftentimes to get out of what we call limping marriages, which is basically equivalent of agunot, or chained women in Judaism. So they actually help women. But that perception is lost by the general public. It's not seen. I think there are Muslim organizations that are trying to educate the public, are trying to reach out. You have ISNA, the Muslim Public Affairs Council, and that have had campaigns specifically against anti-Sharia legislation, and then more general, what is Sharia? But you're swimming against the tide, so it's not made a big impact.
Well, not only that, let me just throw in one thing on that, which I was going to bring up, which I'm very alert to as a journalist, which is that there's this constant effort to smear CARE, Council on American Islamic Relations, ISNA, Islamic Society of North America, MPAC, Muslim Student Associations, any of these groups, which I consider as a journalist fairly responsible places to go for comment or explanation. They're perceived as being fronts for terrorism or fronts for Hamas, etc., etc. So it's not that these groups don't exist, it's that they're subject to an effort to not just erode their credibility, but flip them into being front organizations for worldwide terror that the RCA or the equivalent Jewish groups certainly, generally aren't. The only thing I can think of that's somewhat similar is that there's certain discourse around Jewish groups that uses terms like neocon or Likudnik, often as, at least in my view, as a euphemism for Jew, period. That would be the closest parallel, but entire groups, like the American Jewish Committee, the ADL, aren't called into question the way CARE, ISNA, etc. are, even though by my journalistic lights, these are sort of the mainstream organizational voices. And one thing I'd add to it, besides, I think this is where the point earlier about it's not just the far right wing, there's a mainstream element too. I think that part of the elephant in the room here, and part of what we as Jews and Muslims need to work out with each other, is that I think one of the reasons for the portrayal of those groups that way it's our backhanded, screwed up way of acknowledging that we disagree often, though not always, on Israel and Palestine, and instead of just saying that our relations as American Jews and American Muslims are going to have to include at times, vigorous but civil disagreement over that one issue while we can agree on many others. Instead, we don't talk that through, we don't, but we sort of say that, well, because these groups are sympathetic to the Palestinian cause and Palestinian nationalism, they must be fronts for Hamas. They must be fronts for terror. And that's just a twisted way of legitimate disagreement being played out. And we need to find healthier ways of saying we're going to come together on immigration reform, we're going to come together on other social justice issues, we're going to come together on religious freedom issues. But you know what? We're still going to disagree a lot of the time on Israel and Palestine. So let's just say we disagree and figure out what things we can work together on.
I'm going to try to consolidate actually all 4 questions if it's possible, succinctly. But just going off that great point, when it comes to Muslim American organizations, I would still say many of them are like newbies, if you will. And 9/11 was a baptism by fire. I mean, if I may use that. And the spotlight and microscope was placed upon American Muslim communities and institutions, and many of them did not have these deep roots, deep strategies, deep networks, deep sophistication in responding effectively. I mean, forget about alternative narratives, counter narratives, just response, right? So it did illuminate, if I may, some of the incompetence that exists as a result of being relatively, I think, new in these fields, which is, I always am critical, is a self-reflection of that we didn't invest wisely in some institutions and certain professions, and it showed. But we're getting better. And also, what he was saying, there is a very deliberate effort by the Islamophobia Network, and speaking about the definition of Islamophobia, marginalization, exclusion, to paint any mainstream American Muslim organization, individual, or politician as being a member of, now they say, the Radical Muslim Brotherhood, right? Anyone who gets mainstream. Keith Ellison, if you guys remember that several years ago when on Glenn Beck, Fox News, and Glenn Beck openly said, sir, prove to me you're patriotic American. So the fact that anyone gets a mainstream voice, even cultural contributors. I mean, I've been hit as a man who hates America. So they call me like Hamas, Hezbollah, I'm Radical Ikhwan Brotherhood, I'm like everything.
Well, that's all true though.
Yeah, it's all true. And also with Muslims themselves, I mean, I want to go back to the point where we are like, not only, we're the most diverse religious community in America, we can't even decide what day to celebrate Eid. I mean, so think about like getting like a consistent message that represents our community. Muslims would say, well, what community? Sunni community? Shia community? Tablighi Jamaat Sunni community? Or the Barelvi Sunnis? Barelvi Sunnis or Deobandi Sunnis? Barelvi Sufi Sunni Arabs? Or Barelvi Sufi, Desis, South Asians, and so forth, and so forth, and so forth. So sometimes it feels like we're running around like a headless chicken, but I think what we're finding out, especially because people realize there's a shared space both in America, and this is affecting national security abroad, we're getting a lot of help, especially in the last 3 years, especially, ironically, from the 2010 Ground Zero Mosque controversy. I've seen the last 2 to 3 years, a lot of people are coming to Muslim American organizations, and Muslim American organizations are going to both secular and religious organizations asking for help. You guys have a model, teach us how you did it. And we've been seeing that. When it comes to Jewish conspiracy, unfortunately, like it's already mentioned, the elephant in the room is always Israel. And this kind of contaminates even what should be shared space and shared messages. And as I've said, like when you travel around Muslim communities, people, they looked at those players in the Islamophobia report and they said, hey, Frank Gaffney, Pam Geller, David Horowitz, Daniel Pipes. Is this a Jewish conspiracy? And I always push back against that. Because if you read the report, we don't give impugnant intentions to why people did what they did. And it's not fair to say it is just the Jews. Because if you look at the people behind the last 10, 12 years, it's not just certain Jewish American organizations, right? It's also what I call the evangelical Christians, okay? Certain evangelical Christians. Pat Robertson. Also the Maronite Christians of Bridget Gabriel, Act for America.
Atheists like Sam
yeah.
Harris.
We'll talk about the atheists. And also some Muslims like Zudi Jasser.
Yeah.
So it's like this multicultural coalition of the willing on the Islamophobia front. But what we've seen in the past 3 years is also this multicultural coalition of the willing from, I think this diverse American front as well. And it's very important for American Muslims to say that we have Jewish American partners. And that's why I think when speaking about the narrative does not, it's important to have two things. A narrative that's crafted by diverse communities, but also the messengers of that narrative have to also be our non-Muslim partners. It's very key. Which is why we've seen a lot of headway in mainstream space, because people say, oh, this is not just a Muslim issue, this is an American issue about pluralism.
Something you just touched on reminds me that in my old man with LASIK and hearing aids way, only now did I come up with a better answer to a question someone asked probably an hour ago, which was what allowed Jews to become mainstream, and for that matter Catholics as well. In fact, maybe it was even Leanne's question, so I can't keep anything straight. Interestingly, what allowed it was World War II. And for two reasons. Number one, the quote Judeo-Christian tradition is not a tradition, it's a social construction. And as the historian Deborah Dash Moore points out in a terrific book about Jewish soldiers in World War II called GI Jews, it was constructed to have a unified fighting force in World War II. Because in World War II, with mass conscription, you had a lot of Jewish soldiers and a lot of Christian soldiers who either never encountered the other before or who had encountered each other only in volatile ways. I mean, the Jewish, archetypal experience was to be chased by the Irish Catholic tough kid in the neighborhood and beaten up for being a quote-unquote Christ killer. All the men of my father's and uncle's generations had that experience, every one. Vatican II, by the way, made that totally not my experience. 180 degrees different. But to create a unified fighting force, the Judeo-Christian tradition was invented. And it also helped in fighting against, godless Nazism, godless racial supremacy in Japan. It was another way of defining who's on our side, who's on their side. But that Judeo-Christian tradition was such a good idea, it had legs after the war. And the other way in which the war contributed and enabled the inclusion of Jews and Catholics and ultimately African Americans with the idea of double victory is how could you fight a war against two forms of racial supremacy and then come back and continue to have racial supremacy or religious bigotry tolerated in this country. It's no accident that in waves, first, anti-Catholic bias, then anti-Jewish bias, then a lot of anti-black bias, at least the legal instruments of it are toppled in the 20 years after World War II. World War II makes it impossible to politely sustain that argument in the United States. And what we'll need is a comparable moment for Muslim Americans. It's terrible that we haven't utilized the loss of Muslim American life in the September 11th attacks and the valor of Muslim American soldiers and first responders in the years since then as a way to make that exact point. And the other thing that I think will be needed is leadership. In a way, Eisenhower, this ultra-white bread Protestant, was a good man to put across the idea of Catholic and Jewish inclusion because he had no skin in that game. He was neither. And I think similarly, Barack Obama, because he's already perceived, sadly, as an alien and as a closeted Muslim by so much of this country, will never, as articulately and eloquently as he can make this point, be able to be the person who can put this point over. It's going to have to be the whitest, most Christian, and probably non-Catholics, and certainly non-Jewish person in the political landscape who's going to have to be the one who messages this. I mean, there were brief flickers of it. When John McCain, talked back to that woman about Barack Obama in that town hall debate, but that's just one fleeting moment. Or when he, talked back to the people who booed Obama on his election night as McCain gave his concession speech that night. But you need someone, the whitest white person, the most Christian person.
Most American.
Symbolically, just like Eisenhower was, who's going to have to be the person who who carries that message out.
But W was very good at that. I'm sorry to interrupt. I mean, W was very good, but then he made the decision to marry wrong, which undid everything.
I agree. I think what W did going to the mosque 4 days after September 11th was major. And you're right, and it undid it all. But I think one reason that there wasn't the backlash that's happened since then is that he gave a hugely important message that day. And that bought some time.
And the State of the Union address.
And the State of the Union address. And it's just, unconscionable that that moment was lost and that it's veered so far to the other extreme.
Can I mention that atheist, in response to the atheist one? I don't know if that, she left. But we're not, yeah, we're not, I mean, and perhaps it was inelegant wording on my part, but I did not mean to suggest that it's, all atheists or like there's all militant atheism. I was very specific about 3 names in particular, and I want to stress those 2 names again. Sam Harris and Richard Dawkins. And yes, they are tied to the Islamophobia network, and I'm going to again give you 3 names. Just go to the Googles because they do a good concise summation. Glenn Greenwald last week came up with a great article in Guardian, which followed up Nathan Lean's great article in Salon. And specifically Dawkins and Harris do, I would say, is a sense of militant atheism which has a specific animus towards Muslims and Islam. And Dawkins has been using many of the literature and some of the writers who have showed up in the Islamophobia network and are used by both Pam Geller and Robert Spencer. And Twitter, speaking about being both a venue of good and bad, I think some people should never get on Twitter. Because, some academics just stay away from Twitter. Because Dawkins, in the last 2 months in particular, has unleashed certain very clumsy, lazy invective against Islam and Muslims. And he said that he hasn't even studied the Quran. But he knows enough about it, which kind of betrays, no, I'm serious, you go research, which betrays some of, if you're an academic.
Well, so much for scientific.
Yeah, scientific method, but if you really see some of these claims he's making, first and foremost, they have teamed up with some people of the Islamophobia industry, at least implicitly, and there seems to be a high level of animosity specifically towards Islam, whatever Islam means, and Muslims. So I wanted to narrow that focus of atheism, specifically to those 2 people.
Okay, I was going to say we have time for one more round. We don't have time, but we will have one more round anyway. Let me just say before we do that, after that, we'll thank our panel, and then there will be a lunch break, and we'll reconvene here at 12:30 for the last panel and the final keynote speaker. There's lunch available in various different venues around here. For the last group of 3, Mohammed, I was going to give you a short one, but I'll let you have that last one about W. I'm going to have to pass it to the others. Our visitor from Hawaii, and then Jonathan, and then...
My name is Gary Levitt, a member of the public.
Gary, great.
My name...
And a tiny one from Mustafa, and then we'll get back to that.
My name is Karim Khan.
Karim, thank you.
I think Sam mentioned it, but I would like to know more about how much the Palestinian-Israeli conflict goes to soon after the Second World War. That one and the rise of Christian Zionism in this country especially, how much that feeds till this day into the Islamophobia that Wajaha.
By the way, is a model of a nice, crisp question. If everybody can keep it like that, that will be good for the final round. Johnson?
I won't be quite as crisp. I want to speak up in favor of something that's been criticized several times this morning, which is good Muslim, bad Muslim. As a Jew, I embrace the dichotomy of good Jew, bad Jew. When the New Republic had a wonderful cover story when he was alive about Mayor Kahana. Pages and pages of how terrible he was. Opposition to the violent settlers, Haredi movements in the Israeli rabbinate trying to monopolize and establish extremist interpretations of Halakha. The despicable Pastor Jones and the YouTube movie were outrageous, but so is killing 24 people because of that. I think it is very important for Jews and Muslims, if we're going to have, as I hope, effective, lasting close alliance to speak up frequently against the extremists and murderers in both groups, especially our own group. By the way, I always emphasize the fact that I am an American Jew, not a Jewish American. I'm a Jew first, I assume you are Muslims first, and we have more in common with other Jews than with other Americans. And Jewish American is something that the Christians invented in the US government that I don't accept. Sorry, American Jews. No, Jewish American.
Well, partly, I'm not working, so that indicates that I have some baggage when I come here. We have not yet found out what is the cause of the recent bombing in Boston. It probably wasn't done in the name of atheism or regarding religion in the name of the Baha'i faith. I think Christopher Hitchens made a mistake, with all due respect to him. God is not great, religion spoils everything. It's not just something people do harm in the name of. You can do good in the name of it. And I was born to a Jewish family, but I wasn't intellectual when I was 13. I became an atheist, but then I came to realize something. Freud and Christopher Hitchens were both very stoical. Most people aren't going down in history. You know, I haven't had a very good life, so I'm skeptical. And I should do my homework and find out what the philosophical skeptics mean. I do think religion was probably made up. But I'm hoping that there is something more than this, because we do tend to want there to be something more than this. Religion is ultimately very subjective, because unlike the physical sciences, you know, no doctor has seen a soul. God doesn't talk to people through burning bushes that don't get consumed. So, and again, you know, I have baggage, so if you want to unpack something, you know, what I say is, laws must be based on secular reality, which doesn't mean atheistic. It means non-theistic. For example, our traffic laws are not based on atheism or theism. It's based on safety. And ultimately, this does have a religious dimension. Safety and protecting each other, protecting the environment, being above board in our legal and business practices. And so, I hope I've made some, I'm not yet famous or rich, I wish I were both, but I sometimes do tend to make a statement after a lecture, but I hope it wasn't totally inappropriate. If you know my problems, you'd forgive me.
Thank you.
Oh
yes, sorry, Mustafa, yes.
Just a couple of quick questions. One to Wajah, thank you for the paper. Is there anything being done on a grassroots level, like in schools, Jewish schools, Christian schools, public schools? And also, I'm not sure because I'm an outsider, are there Islamic schools here where kids are being prepared to kind of face these challenges? Especially someone like yourself, if you are doing some work in schools, because we have some stuff in the UK now, where Jews, Christians and Muslims go in together sometimes in schools, or it will be just a Muslim to do something for the kids there. And something for Samuel and Leanne, and Wajahat can come in as well. But, you know, I'm thinking about the idea of joint, I mean, you touched upon it, of joint statements, like between Christian, Jews, Muslims and whoever else. You know, I don't want to use the NATO line of, you know, attack on one is attack on all, but, you know, instead of Muslims defending Muslims, it's kind of, you know, cross-party defense. And we did something like this in Europe for the circumcision controversy in Germany. Well, I was told to write a statement, but it was signed by a rabbi, a Muslim scholar, and also a Christian priest. And we found that's a much more effective way of doing things, especially for the Muslims, when we have Jews and Christians on board. So, and if you get a large enough member base, it's not just the Muslim, Christian, Jew. If you can say, you know, we've got 2,000 members who have signed up to our mailing list, for example, you are represented as an organisation with possibly many thousands, and that gives you quite a bit of clout if you can work in that way.
I'll start by addressing your issues that you raised. And you said laws must be based on something secular. We can never get completely secular in our laws, and I think we lose sight of that. I'm from Georgia, living in Georgia, and I was walking in the grocery store one Sunday with my 11-year-old son, who said, the fact that they don't sell liquor, isn't that against the Constitution? So these blue laws are definitely based on a Christian, you know, Sunday, Sabbath, and things like that. But I agree with your idea that they shouldn't be blatantly religious, and we do the best that we can to really get a secular, non-religious, legal system in this country. But I don't see that really anybody pushing back against that. Even the most Orthodox Muslims who I've interviewed who really want to establish Islamic tribunals in this country and see that as essential to their faith in the way Orthodox Jews would, because Orthodox Jews shouldn't sue each other in non-Jewish courts, for example. They're clear that the civil law, the secular law, if you would, places limits on them in this country. We have health and safety regulations. We have criminal regulations. And so I don't see that as an issue really for anybody in this country. Why don't you pick something else to address?
I'm going to try to be succinct on all of them. Good Muslim versus bad Muslim, the reason why I think it's still problematic is I'm not averse to self-policing or calling out those amongst our Jewish communities who are bad. There are people who do bad, and there are people who try to legitimize and rationalize their badness in the name of religion, which taints both the religion and the religious communities who are part of that community. The problem with Muslims, as still being, I think, not mainstream, is that there is a rich ocean of Jewish narratives in America. I'll give you an example, like Seinfeld. When people see Seinfeld, they're like, oh, that's the Jewish comedian. Like, we all know he's Jewish, right? Like, Seinfeld is a comedian who's from New York, who's funny, and happens to be Jewish. Okay? And there was a process of the, if you will, the assimilation, the integration, the whiteness, where the Jewish not seen as exotic anymore. You can be a character who then happens to be neurotic, and then who happens to also be Jewish. Whereas now, there's still an exotic marker attached to Muslim. And when something, let's say, we'll use the Boston example, if it is done by a Muslim, we don't know yet, the American Muslim community, and even those who look Muslim and aren't Muslim, will be asked to interrogate, defend, and investigate and explain their Muslimness. All right? The burden is borne not by the individual or those who help that individual commit that terrorist act. It is borne by both a local, national, and international community that looks Islamic or as Muslim. And the way I try to, talking about stories and simplifying it, if it's a white dude who does it, like suppose it's McVeigh, suppose there's an anti-government individual who does this, we find out in the next week. White people will be like Bugs Bunny. The anvil will not fall on their head. Nothing will happen. If it happens to be, however, God forbid, say a minority, forget Muslim, a minority, that does not have that cultural, political space, right? You will be like Daffy Duck. The anvil will fall on all of our heads, and the shotgun will be blasted in front of our face. Which is why I think the good Muslim, bad Muslim dichotomy is also very troubling. And going back to the national security narrative, there's so much more to our lives and our narratives than just national security. Right? Just go to sports, like Muhammad Ali, Hakeem Olajuwon. And so when a lot of people say talk about national security, I mean, honestly, I've been in discussions with, NCTC and NatSec, like, tell us where, Abdul, the Nidal Hassan Maliks get their information. Where did the Taliban hang out? This is awesome. No, seriously, and this is the response. We don't hang out with those people. Those people are effing crazy. Like, why would we hang out with those people? Do you see what I'm saying?
Do we need a Muslim Woody Allen?
Well, it's interesting that some of it has started in stand-up comedy, a little bit in theater, and in literature. The Muslim American story is starting to get a little traction. But those are forms that speak really to the cultural mandarins, the elite. I think the question is when the really mass media, when a big Hollywood movie, when a Seinfeld level popularity TV show will have a Muslim, audience loves this person protagonist.
And the Muslim in this is not a primary or even a secondary consideration. It's a process. And it's a process others have gone to. And I just want to make a quick point about, someone talked about the succinct question about evangelical Christian
Israel-Palestine.
Israel-Palestine. We'll talk. No, we should talk about it. As far as the Islamophobia industry goes, there is very significant ties to what we call evangelical Christians, the extreme version of evangelical Christians, and I would say a cynical and politically expedient union with those who are for, if you will, the right-wing Zionism. I don't want to be
Yeah.
Inelegant in my terminology.
No, that's a fair character.
Pastor Hagee, Christians Unite for Israel. Okay. We all know the narrative that, the Messiah will come back to the Holy Land, Jews need to control it and sedate it, and once the Messiah comes back, he's pretty much going to kill the Jews. Which makes, let's take it, let's be real about this. Yeah, and then Muslims die after that, apparently. But then you have, Christians United for Israel, and you have Bridget Gabriel, who's a Maronite Christian, leader, co-founder of Act for America, the leading anti-Muslim grassroots organization. We'll talk about grassroots for a second. Who gave a talk at Kufi, and who said, quote, "Arabs and Muslims have no soul. They're dead set on killing." Pat Robertson of the 700 Club, very influential evangelical Christian, deeply tied to the Islamophobia network, also proponent of the anti-Sharia legislation. And also now you have the son of Bill Graham, Franklin Graham. So there is a political union between these groups that plays out on the grassroots initiatives in a big, big way. And Muslims and our allies do not have a strategic, organized force to counteract that. What we've seen in the last 2 years are pockets that spring up in communities like New York, Tennessee, ad hoc stuff that is emerging and bubbling.
Well, let me even tie in, you said, Muslims need to speak up. And every time there's some kind of attack, whether or not it's by a Muslim, it's always, well, Muslims need to condemn the bad Muslims within their group. Well, yesterday, within hours of the bombing, I started getting, press releases from all these Muslim listservs, CARE and other ones, condemning the bombing and praying for the victims and the victims' families. But somehow those don't get translated into Muslims saying anything. So,
right. Yeah, I think I couldn't. It's exactly something I was going to say. Not just yesterday. Every time, and I'll bet if I went back, if I could recover all the email I've deleted. After that attack on the UN base, I would be surprised if I didn't have an email, an e-blast from CARE and some other American Muslim groups condemning it. The problem is that there's such an unexamined premise that there are no moderate Muslims, or why won't the moderate Muslims be heard, that even when these statements go out, they're kind of ignored because we all know there are no moderate Muslims, and also because I think, and this is, I think there's a use of the legitimate disagreement between many American Muslims and many American Jews on Israel-Palestine. There's a misuse of that as a way to delegitimize anyone as Muslim moderate. That if you're a Palestinian nationalist, if you're a unitary state person, I'm not. I'm a Zionist of a liberal sort, but a Zionist nonetheless. But if you're a unitary state person as a Muslim, that doesn't make you immoderate. To me, that can't be the definition. Then we're going to probably wipe out 98% of American Muslims as moderates. So I don't think there's any reason to do that. And also one more thing on the good Muslim, bad Muslim. The problem is that life is more complicated than that. And, someone can be good on one issue and terrible on another. As I was going through my preparation for today, Rabbi Herschel Schachter from, REITS, the Rabbinic Seminary at Yeshiva University, has been great on the issue of Metzitzah B'Peh. He's been, an important voice in the Orthodox world saying this is anathema, this is dangerous, it's not religiously required. But within the last few weeks, he made some outrageous racist statements about blacks. So is he the good Jew or is he the bad Jew? I can think of, there are, Jews in the Torah world who will take stances I might approve of on medical ethics and take stances on, territorial expansion or maximalism in Israel, or the power of the chief rabbinate in Israel that I might find objectionable. So good Jew or bad Jew, I think is, it's risky. It's to try to boil things down that way.
I'm going to give you guys a chance for a second more. I did want to make sure that somebody said something about Mustafa's question about school initiatives.
Yeah.
And then you can take it 20 seconds, 20 seconds on that, or you and Sam can both talk on that.
I'll just go quick. I'm sorry, Mustafa. My kids went to a Jewish day school, although as they always said it was a very hippy-dippy one. And they did a lot of interfaith. There was a lot of emphasis on interfaith work, and there they had speakers about Islam in America. They did a lot of work at speakers about Palestinian Israelis and Jewish Israelis and the efforts at coexistence there. In fact, the founder of the school they went to is big on that issue. So some of it's out there. I also want to, and some of these statements, the need for joint statements, absolutely. One of the days I was proud of Mike Bloomberg, as my mayor in New York was in the middle of the quote-unquote ground zero mosque controversy. He put together an interfaith group. I think they were on Liberty Island, or they had the Statue of Liberty in the background. Rabbis, priests, probably Hindu and Sikh clergy as well. A whole, array of religious leaders to speak up in favor of the tolerance for the Park 51 plan. So I agree that has extra traction, and the more we can do that, the better.
The more that you see in the last 10 years, more and more communities locally are creating, if you will, their private Muslim schools or Montessori schools, and to get like the dual education of both, very similar to what we've seen in Catholic schools and Jewish schools. We've seen in the last 10 years happening with Muslims. American education, but also an educational institution which gives our values as well. And now in the last 2 years, we've seen, especially I'm from the Bay Area, they've seen an active engagement with local synagogues and churches. So this is encouraging. I myself am a product of an all-boys Jesuit Catholic high school, where I was a token Muslim who got the highest grade every semester in religious studies classes. much to the sadness of my priests who saw my name every semester. But as far as when it comes to grassroots, I'll tell you where we're in right now, which is somewhat encouraging, but we have a long way to go. An acknowledgement and awareness from the diverse communities that this problem exists, that we haven't addressed this problem, and we need to get to point B. How do we get to point B? What do we do? The messy first steps, second steps. For better or worse, we're in that part right now. So we're not as consolidated and organized and systematic as, say, the Active America, but people have realized the need for the counter to, say, Active America, both on an education level, grassroots level, activism level, political level. The point I wanted to make, the last point is, notice, and this is disturbing, when you're talking about the responses to what happened yesterday, there is a sadness that people have to prove that they're Americaholic enough. There is a litmus test or these hurdles that, do I do 2 lapels and wave the flag wearing the Uncle Sam hat? How much do I talk about loving America? 6 times? 7 times? What will prove to this judge, jury, executioner that I can't see that we are America enough? I think that's troubling. The second thing we have to mention is, speaking about the responses, there's a Washington Post article that came out yesterday that didn't talk about the response from Muslim American communities. International Muslim communities are waiting with bated breath, praying that the individual is not a Muslim for the Boston Act. Why? And even me, yesterday when I was looking at this, that thought popped into my head again and again, and I hated myself for that thought popping into my head, because I'm like, why am I already prepping a response and dreading the fact that if it's a Muslim? Because again, going back to the memories of 2001, which are very, very seared into my mind like they are yours, I was a student leader at UC Berkeley, and I remembered that time, and I was just having, I'll be very open, I was having a conversation with another American Muslim leader. I'm like, man, if it's a Muslim, God forbid, I don't know if I have an inmate to do the post 9/11 dance, if you will.
But
again,
they are looking for a life.
No, but what I'm just saying is because again, it goes back to the point where internationally, this is the key thing. Internationally, Muslims know that the local will become the national, will become the international, which will feed into the narrative that has perpetuated in the last 10 years, which will not only affect that Boston community, it will affect international relations, and the anvil will fall on the Daffy Ducks who look Muslim. And that is very, very telling.
I'm sorry to close on such a dark note.
We are sorry.
We'll see you back here at 12:30, but thank you. Let's thank
This was absolutely outstanding. I want to ask the three of you one question first. I'm Bob, is one of these first sponsors, and we are launching publishing
we know, and I think that you and I share this because we are in a law school context, so we think about it in this way. We see the ways in which Jewish law or Islamic law operate just like any other legal system, and it's our duty to sort of make that very widely known. But I think that for me that the resistance is about how it gets fetishized within legal academics or in popular discourse as something other, and that's what we need to also focus on.
Yeah, I agree with the idea of how the terminology can set us adrift, as it were. I think that the question is that are you attempting, or do you think we ought to attempt to show that religious law really meets the standards of what even secular people would consider to be law? Or should we take an approach to try to show, and I see this as the approach, for example, of something like John Whitty, that even law that is supposedly secular is really rooted in religion in the following way. First of all, the question is, and the fundamental question is, why should I obey the law? Why? Which means, basically, why should I obey anybody, let alone why obey the law? And once you get to that question, what is my obligation to obey the law, you find that secular, such as contract theory, really kind of breaks down, because the reasoning gets very circular. So I would suggest a more proactive approach to indicate that law, and you know that, for example, in Hebrew the term dat, the medieval, it was actually a Persian term, is both a term for law and religion. And interesting, Thomas Aquinas sees religio and lex coming from the Latin ligare, which means to bind, to obligate. And I think that's, whether the etymology is correct, but it's intuitively it's correct. And I would simply just suggest that those who are both students of religious law and also who live by it as well, that's kind of important, be a bit more proactive in, I know it's an uphill battle, but nonetheless, I think it's one worth engaging in.
I don't disagree with that. I mean, I think both strategies are good, but I think that what I'm pointing to is actually a deeper critique about the category of religion to begin with, and the way that it has a genealogy that it's intimately related to racialized categories, and a process of exoticization that we should be resistant to.
So, thanks for correcting our title. And while you were talking at first, I was thinking, oh, but we did it because this will bring people in. So I guess we were commodifying.
Thank you. Proving my point, yes.
So now you have a bigger audience to tell them that you actually shouldn't have come because. Anyway, but no, I think your points are really excellent and well taken. The one thing is, at the end, you want to say, and I'd like to suggest. I think I'm going more or less the opposite direction from David here. I'd like to suggest maybe you're overstating your conclusion a little bit. I don't know if you want to walk it back a bit. When you want to say Sharia and Halakha, or fiqh and Halakha, let's say, are just like any other system of law, surely that can't be right. Neither Jews nor Muslims, unless you take very, very reformed tradition, elect representatives to a Judaism or Islam Congress in which we can rewrite everything if we like. We don't have a constitutional convention. There is a conception of what we are trying to understand, even in the very distinction that you brought out so nicely, that constrains the form of the law and makes for certain kinds of moves that you just wouldn't have in a secular legal system, and shouldn't have in a secular legal system.
So I'm glad you brought up that point, because that's part of the overall message, is that religious and secular are really code for non-state and state. And there are ways in which using those terms obfuscate the real analysis that's going on, which is precisely what you're talking about. So I wouldn't say that Jewish and Islamic law are just like US law, for example. They're obviously not. But the distinctions have less to do with the category of religion and more to do with the category of non-state. And that's the key issue to be discussing and to be thinking about, rather than to be like imposing this category of religion with all of its problematic sort of assumptions.
So just brief follow-up, although I think that's helpful. Non-state will include the laws of the Boy Scouts or some
Yes.
volunteer. And all of those can be rewritten they don't have an authoritative text. There's surely it's not just this is one of many non-state kinds of
So if you want what is an authoritative text, any legal system is based on legal hermeneutics based on an identified within that legal system set of canonical texts. So it just so happens that in Jewish and Islamic law there's a mix of those texts being divine but also realistically speaking products of jurists, right? The rabbis or of Muslim jurists. So, but that's not in and of itself a key distinguishing marker, I would say, about a legal system. Mark is grimacing.
Yeah, I'm sorry, so tell me, I agree with what you've said so far, but what are the non-religious, non-state legal systems? You know, what's going to come under this tent?
So, Michael wants to answer Native American law,
International law.
international customary law.
International law is non-state, tax-based, but no one knows what its grounding is. You.
Yeah, I know. Michael and I always agree. Starting yesterday.
Corporate charters, bylaws.
Yeah. Thank you.
Tim, really quickly.
I wanted to also just mention an implication of this collapsing between the sort of strict categorical barrier between religious legal systems and the American legal system. And David mentioned that one implication of this is to understand that there are either religious or value-laden roots in the secular legal system, but another is that the category of law is much larger, and the way it functions is much larger than simply directive behavioral regulations and sanctions. And I think a lot of, for instance, law students come into law thinking that the law is essentially a series of behavioral mandates and punishments if you don't obey, when in fact, when you look at religious law, you see very clearly that there are other things, for example, an expressive dimension. There are a lot of laws in the Jewish legal tradition, Ben Sura, Moreh, the rebellious son, that are really about expressing values and not about behavioral regulation. And that when you take that as a platform and you go back to American law, you actually see there's an enormous amount in the American legal system that really is about expressive as well. And so there are many things that are highlighted or much clearer in Jewish and Islamic law that I think when you see them so clearly and you come back to the American legal system, you realize the category of law, the genre of law is actually far broader than what most people think when they study law as a sort of simply as a system of public regulation.
I agree with that.
We're going to have to defer the rest to the open discussion. Our next speaker is Asher Lopetin, who's a rabbi at Anshe Shalom B'nai Israel congregation. He received his ordination from Yeshivas Brisk and also from Yeshiva University in New York. He holds an MPhil in medieval Arabic thought from Oxford, as well as a BA in international relations and Islamic studies from Boston University. He's a recipient of many awards, including a Rhodes Scholarship. And the title of his talk is Creative Interpretation in Halakha and Sharia. Quotes, I guess. What is the definition of public prayer?
Thank you. Thank you very much. It's really an honor to be here, especially as a rabbi in a wonderful and amazing academic conference like this. And actually, it's interesting, yesterday I got a call from someone complaining about the use of the word Sharia. So I could have, had I heard this already, I said, you are right. Now, it was probably coming from a different direction than you were talking about. But still, I would have had something clever to say to her. So, but that's the life of a rabbi, which is great. I'm passing. We're passing through around an article that was written. Is from the Forward, the Daily Forward today online, and it talks about this how powerful this issue is, a human issue of the participation of women in the services. I'm an Orthodox rabbi, and there's a lot of discussion on the listservs that I'm on that talk a lot about the minutiae of the details and this, and can we do this, and slippery slope, and all sorts of ways of looking at this issue. This article is really very much from the human side. And it also involves a rabbi who's an ordinee of the rabbinical college that I'm going to be going to in a couple of months. So you can read it. If what I'm saying gets dull, feel free to read it. And I wanted to really use Islamic law and Islamic interpretation of law as a support for an idea that I thought as an Orthodox, a modern Orthodox rabbi, to address the issue of women's participation in synagogue services. So mainly, I'm thinking from the point of view of a rabbi, and an Orthodox rabbi that feels compelled to come up with an accurate interpretation and a traditional interpretation of Jewish law. And I'm using small elements of Islamic law and Islamic tradition to be supportive. And this is, I guess, something new. It's not normally discussed on my listservs that, well, Islam believes this. But I think as I present it, it might be helpful in this sense of that when the two religions resonate with each other, and when we hear things so much in common, they give strength to each other. So there's almost a sort of the whole is greater than the parts. And so let me start with actually one of the easier issues that we talk about in, I'll say, in Orthodox circles, and that is about women leading services for other women in prayer. You'd think that shouldn't be any question whatsoever. The Bible talks about Miriam dancing with the women, so clearly women have led women. In Eastern Europe, there was, when women began to go to synagogues, there was really separate synagogues for women, or there was a wall. And the women, in order to know what to pray, and many of them were illiterate, they had a zogaka. They had a woman who was reading the prayers to them, and they repeated the prayers. So this is not an innovation. This is something that goes way back. And in fact, in many of the very religious day schools like Beis Yaakov's, the girls daven in the morning. There are no guys around. The girls daven in the morning, and there is somewhat of a leader. So you would think that it's not such a problem, that there's clear precedent within Judaism for a woman leading other women. So we'll get back to actually that in Judaism it has been controversial, in traditional Judaism, in Orthodoxy in particular. But let's take a very brief look in Islam. And there are, and by the way, I really look forward to a discussion and either pushback or support or whatever it is from people that in the audience that know much more about this than I do. But there are hadith, there are traditions of Aisha and Salama, of the wives of the Prophet, who led women in prayer and stood among them in the obligatory prayer. And there are many different traditions like this. And both of Aisha and Salama. And it really seems on the surface, if you look at many of these traditions, you could bring a powerful argument that women leading women in prayer is something that is very well accepted in Islam. But it's not so clear. So some of the schools of fiqh, the Shafi, Hanbali, and Hanafite, in general accept it. The Hanafi are, which it's a little surprising because sometimes they're normally considered a more progressive school or modern, whatever you want to sort of tweak those terms. But the Hanafis are less in favor of this, and the Maliki school feels it's prohibited. So even though there are many traditions, many hadith in Islam that have show a precedent for women leading prayers, it's not so clear that women are allowed to lead prayers, even for women in congregational life. And this might be the beginning of a distinction. How do you explain traditions? You could always say that it's an inaccurate tradition, it's not a tradition we accept. But you could also say that when Aisha and Salama were leading the prayers, it was not done in a congregational setting, it was done in a more of a private setting. And that's sort of the direction that I want to get to. In the Jewish world, women's tefillah groups, and this is almost like a footnote, women prayer groups have been actually, they've come into, they've been normalized a little bit. In fact, some of the rabbis that are most vociferous against women leading services for men and women themselves have women prayer groups where women are leading services for just women in their synagogues. And I always get frustrated because some of them are like so religious and leading the charge against women leading services, mixed services. And I say, but you're not religious, you're a sinner. You know, you have a women's tefillah group, you have women leading service for women. And many of the modern Orthodox or centrist Orthodox decisors, some say even Rav Soloveitchik, but Rav J.B. Soloveitchik. Others, the students definitely at Yeshiva University. Some call, there's a group of 5 rabbis in the late 70s who were opposed to this. They were opposed to women leading services for women. I don't know if we have to go into such detail here because that's not my main focus, but just to what could possibly be the problem, because it's all women there. And the issues were actually that if the main issue, first of all, might be considered a break from tradition, but as we see, it's not such a break from the tradition from Miriam and from Eastern Europe. But also, mainly what they were looking at was that it's better for a woman to pray when there is a full minyan, there's a full quorum, which traditionally includes 10 men. In other words, women praying on their own, it's something that's kind of nice, but if they have an opportunity of praying in a regular synagogue with 10 men, that is much better. So if we could actually show that traditionally a woman could lead services for men and women in a traditional setting with a quorum of 10 men, then these rabbis, if they would agree to that, would say that's much better than a woman leading services for women. So, in other words, the more religious option, the stricter option, might not be a women's tefillah group, just women with women, but actually a woman leading services in a regular congregational setting with men and women. So what does, this is where we're going to get to the main point that I want to focus on. What does Islam say about women leading services for men and women? And there don't seem to be as many hadith, but there is one famous hadith that I've seen about Waraka, that a companion of the Prophet, or living contemporaneous with the Prophet Muhammad, where the Prophet apparently lets her lead services, but Kadi fi baitiki, she has to read them, she has to lead the salah in her house. It has to be fi baitiki, in your house. And it is for the ahla dariha, it is for the ala dariha, the people of her dar, of her house, her neighborhood, her community. It's not clear what that means, but it is clear that it has to be in a home setting. And this is what compels some, or allows some Muslim thinkers to say that, you know what, if it's a private matter, if it's just in a home, and maybe even the men of the home don't know exactly how to pray properly, then she could lead it. It's private, and there's no problem of modesty. There's no problem of issues that come with men who might not know her, so that is permissible. Now, you can debate this and extend this. You can say Ahla Dariya is the people, it might be the whole neighborhood, might be a huge group of people, but I want to focus on this idea that in Islam itself, it seems the Prophet was saying, you have to stay in your house. And I'd like to use this idea to take it back to my Jewish roots, to look at why is that significant? What is the significance of, let's say, the Prophet? Again, if you want to accept, not everyone accepts that tradition, but if you do accept that tradition, why would it be okay for the woman to lead the services, perhaps mixed services, men and women, in her house, but not in the public sphere. And this, I forgot which came first, whether I had heard this distinction in Islam between the public and private, where private a woman could lead mixed services, but in the public sphere she couldn't. Whether I had heard that first, or whether I had thought about this in the Jewish realm, where there was a discussion of Jewish women leading services for men or for women. And that's where I thought normally the complaint about that is kavod hatzibur, is that it's not honorable for the community. And this is a very famous Braita. There's also a Tosefta that is similar to it. So a tradition in the Talmud, in Tractate Megillah 23a, the rabbis taught, Tan Rabbanan, Hakolo Luminyan Shiva, everyone counts towards the 7 obligatory readings of the Torah on the Sabbath, even a minor, Vafilu Isha, even a woman. So it first of all says that a woman can do it, that it will work for a woman doing it. But the rabbi said, Amru Chachamim, Isha lo tikra b'Torah, a woman should not read from the Torah. This is normally accepted, a woman should not be one of these 7. Mipnei chevod tzibur, for the honor of the tzibur, of the community. Now there's a lot of discussion in this in Jewish circles. Does this change? Maybe what was honorable for the tzibur 2,000 years ago or 1,500 years ago was honorable for the community then. Changes, maybe that's something that evolves, and that requires really maybe following a school of thought in Jewish law that thinks things can evolve. But most, I would say, Orthodox halachic authorities, legal authorities, would say, no, how do you know that things change? So they might come up with something else, that there's another value. Yes, it's a value to have respect for the community, but there's another value of respect for humanity. And if you read this article, I think that sort of brings it out. A sick woman who, tragedy, her neurological problems, and she wants to do a little bit of Torah, of leading. In this case, it's not Torah, it's leading a Friday night service. Of course we have a value of respect for the community, but what about the value of respect for an individual, respect for human life, all that kind of stuff. So that's another direction people can take, and there have been a lot of arguments about that. But when I saw this, what struck me was this idea of kvod tzibur, that we're worried about the honoring the community, the honor of the community. And, or the public, however you want to explain that word tzibur. Tzibur is sort of a gathering, tzibur, coming together. And what is this honor of the community? I mean, you could say it's just, some people say it's not honorable if a woman reads instead of a man reads. There are many different interpretations. One of the most authoritative, centrist, orthodox poskim of today is Rav Herschel Schachter. And he writes online, in the laws of reading the Torah, he says the Shulchan Aruch quotes from the Talmud that although, according to the law of reading Torah, a woman could get an aliyah. I mean, there's no problem with it. That's what the Talmud said. But he says, Kvod HaTzibur, this honor to the community, is a matter of tzniut, is a matter of the modesty of the woman. It's not modest for the woman to lead this service. So if we go with this logic, he says everyone has the image of God within them, and one of the things that you're most godly like is when you're kel mistater, when God is hidden, when you're modest. And God prefers to hide in tzina. Therefore, I guess we let women have this aspect of godliness. A little bit of apologetics here. But basically what he's saying is that to protect, and bear with me, is to protect the dignity of the woman, we do not have her paraded to lead services. But that's kvod hatzibur. That's when it's dealing with a public showing of this woman who is leading services. And interestingly, in halakha, in Jewish law, in the area of saying kiddush, of saying the paragraphs and the prayers that sanctify the Sabbath. Or in the case even of Megillah, reading Megillah, or there is a distinction between a woman doing it publicly and a woman doing it for members of her household. So this harkens back to the hadith where the prophet said, only do it in your household. The Aruch HaShulchan says, Kevan barabim hu, that if a woman is doing something rabim in the public sphere, then it's zila milta. Then it's demeaning to her. Same kind of idea. They're lumping the same concept, and Rav Shechter is of kavod hatzibur, that it's not honorable to the woman. It's demeaning if it's done in a public way. But if it's done in a private way, and the Mishnah Berurah says that as long as, it's all members of her household hearing this prayer sanctifying the Sabbath, the Kiddush, then it's totally proper. And in fact, there are other laws that distinguish between a public synagogue and a private house. For instance, you have to give the first reading of the Torah, the first aliyah, to a kohen, to a priest. If it's done in a public sphere, you have to. If it's done in a house, the halacha is that you don't have to do it. The Mishnah Berurah says no, because it's a private sphere. And also issues of supporting the synagogue. If there's one synagogue for the whole town, it's a public synagogue, everyone is required in that town to give money towards that synagogue. But even if there are other synagogues, and each synagogue is a sort of a private space, then you can't compel anyone to give money to that synagogue. So finally, the fourth point of this distinction is that sometimes you have all these laws of respecting a synagogue, but if people treat it as a home, like scholars are in the synagogue and in the Beit Midrash learning all day, then our medieval sources, the Ran says that, well, first the Talmud says in Megillah again, Beita D'Rabbanan, the Beit Midrash, the synagogue, the place of learning, becomes Beita D'Rabbanan, becomes the house of these people studying there. Lefisha omdim sham kol hayom. The Ran says because they're there the whole day. There's a transformation that can occur from a synagogue becoming being a public place to becoming a private space. And if it does become that private space, then, as in the laws of a woman doing kiddush, and in other areas, then a woman is certainly allowed to lead religiously and lead rituals and services, reading Torah. And there's a discussion about services for other reasons, perhaps, but this idea that kavod hatzibur, that you have to show honor to the woman by not parading her publicly, falls away if you're saying that the synagogue is private space. And that's really my argument about today's synagogues, both in the way they are. They're synagogues, people pay membership in general in America in synagogues. They are private space. They are private communities. And also, ideally, they should be like homes. They should be warm places. People should come to them and should not feel like a stranger. People should come to the synagogue and feel welcomed and feel like they're part of the home. And I think that if we can turn these synagogues that we have, the public arena, which is a place of anonymity, it's a place where no one knows who you are, no one cares who you are, you're just there, to private space. It's a space where people do care about each other, and it's a sense of community and a sense of family. Then the rabbis who said that women should not read from the Torah at one of the aliyot, the rabbis who had other issues of leading kiddush, other ritual leadership issues for women, they would say, well, we were talking about tzibur, we were talking about rabbim, we were talking about public space. But if it's private space, then there's no woman, then there's no problem. There is a woman, there is no problem. There is modesty. She is amongst people who care for her, who would not want to embarrass her. There is God hiding, as it were, inside, because these spaces are inside. And so I think that in the Islamic tradition, there is this sense that if it's in the home, then a woman can lead services, and perhaps for men as well. The question really is, are we transforming, are we willing, do we want to transform our synagogues and our mosques into private space, not exclusive private space, but private spaces that are open. The model of the home that is hospitable, that brings strangers in and welcomes them, but treats them not like strangers, treats them like family. I actually think that the Jewish community needs to move in this direction, that we actually will not succeed in America in keeping people part of the community, the Jewish community, if our synagogues are just public space. But if we can bring people into them and they can feel like they are homes and they are private, welcoming space where everyone is valued and everyone is, in a sense, ahladad, our people of our family, then I think we can really succeed, not only in the issue of allowing women to lead in a ritual way, but also in really building up a community that is connected to each other and that is able to pass the tradition from one generation to the next.
First of all, thank you very much. From a halakhic perspective, I've actually never heard that distinction made before. I think it's a really fascinating, interesting one. I wonder about your thoughts on another way of looking at the issue, primarily because I'm myself also very interested in these issues. And I've thought about the issue in terms of kind of looking at the way I see it, I think, especially with regard to the question of women leading mixed-gender congregational prayers. In Judaism, at least, in Orthodox Judaism, the conversation has sort of crystallized, I think, at this point, around several different views, and I think it's kind of crystallized along the lines of when pressed, everyone will have to agree that there's a legitimate technical legal argument to be made either way, both for permissibility and for prohibiting the practice. The sources can be read and interpreted in either way, whether you would say it's strained or not strained. It's a fundamentally legitimate reading of the sources, and that the disagreement has kind of crystallized around meta-halachic issues. For example, questions of tzniut, of modesty, questions of the intent of people looking to innovate new practices, the concern for conservatism and continuity of tradition, and I've thought about and suggested that in Islam, which is more recently dealing with this similar issue, and in the United States particularly since 2005, when there was the famous, or I don't know how famous, but Amina Wadud was the professor, organized a female-led mixed-gender prayer in Manhattan, and there were many responses to this, and at this point, from what I can tell, the discussion is, the disagreement within the Islamic community is a technical, legal discussion about interpretation of the technical legal sources, about the persuasiveness of the hadith which you mentioned, and of the persuasiveness of the consensus of jurists since then who have held one way or possibly the other way on the issue. And I think that there's a great value in kind of accepting that there is legitimate disagreement over the technical interpretation of the sources, that we can agree to disagree. There are different ways to interpret the sources, and leaving and kind of basing the argument on one way or the other,
on these kind of meta issues, which I think you have these devices and tools within the Islamic jurisprudential tradition as well to make similar kinds of arguments based on tradition, based on concerns for modesty and fitna, and continuing prior practices in the absence of proof, conclusive proof to the contrary. And I wonder if you think that framing the argument in terms of those broader principles is a useful way of doing it, or is that's actually not a useful way of doing it?
I am fascinated by what you're saying, because I think it's a very it would be very healthy for the Jewish community, and I'm part of the Orthodox community, to look at Islam and say, wait a second, why are they as not worked up about these huge meta issues as we are? I got, related to that article, I got an email from a rabbi who says, this is feminism taking over, and it's this taking over, and it's these are forces beyond our control. I mean, it could be, but I think you're right. I think it's a healthy to see that Islam is not as worked up as we are. Then what's going on within us? I think that'd be very healthy, because we would always expect Islam, fundamentalists and all that to be worked up. And I think it's a very interesting point. And if it could just get in all these kind of things, we just step back for a second and think more reasonably. And so I think it's a fascinating approach.
I don't want to take too much credit. We got pretty worked up about that. David.
Yeah, it is a fascinating distinction. There actually is in the Talmud the distinction between Bet HaKnesset Shel Rabbin, Bet HaKnesset Shel Yachid, the public versus the private synagogue. I don't know if it would play out this way. But I would say this also as the proud father of a daughter who leads an Orthodox all-female, they don't call it a congregation because they haven't seceded from they make it a point not to. But I would suggest another tack. If it's a question of basically women assuming a more public role, then I think that a better tack is that in the halakhic system, the Bet HaMidrash, the place of study, has a higher sanctity than the synagogue. In the Talmud, you can sell a synagogue to make a Bet HaMidrash, but you can't sell a Bet HaMidrash to make a synagogue. In the Bet HaMidrash, actually, there are virtually none of these restrictions. There are virtually none of these restrictions. And the parallel to it is as follows. I've actually tried to advise young women that if they really want to play a role, a religious leadership role, they should go into the field of Jewish studies. And the reason is and teach Jewish law. Because when it comes to an opinion, for example, on what is a Jewish point of view on X, Y, Z, they no longer consult rabbis, they consult Jewish studies people. And therefore, that's not true. But in precisely the one that was more independent, and whatever. So I mean, this is a question. But the idea of just one last point, the idea of a service, where women do some parts and men do other parts. In 1983, when the group that I still lead seceded from the conservative movement in the United States and organized a group of traditional Judaism, we consulted whom we consider to be, and many of the people, the world's greatest Talmudist, Professor Saul Lieberman, Zichrono Livracha, may his memory be blessed, and he indicated, yes, on technical grounds, yes, he said, but he said to have this type of synagogue where men do one thing, women do another thing, he said, subjects to, and he invoked a value that I haven't heard anybody else, it makes the service look ridiculous. We can do this, but we can't do that, and everything else like that. It's the egalitarian route. But I think that distinction is that the synagogue really was never meant to be the major institution in the community. And that the Bet HaMidrash, the house of learning, is one where there are far fewer halakhic impediments to doing what I think you were trying to do.
So a couple of points. You made many good points, powerful points. First, it's funny, Rabban Soloveitchik used that same term that looks silly. I mean, and one thing I would say when you read that article, it's nothing about silliness, and I understand. I'm a student of Rabban Soloveitchik. These are great minds, but they might just not get it. What women feel when they're leading, whether it's an all women's group or what a bat mitzvah girl feels when she's leading an Orthodox bat mitzvah girl a service with men and women. So it's just funny. I didn't realize that they both said the same thing, and it's not a joke. I mean, it doesn't make anything look silly. No one reads this article about the rabbi letting the woman lead and say that's so silly, or bizarre. I mean, but the other thing I would say, just two more quick things. One is that yes, there is this talk about, and Saul Berman talks about this that let women learn. Women weren't always allowed to learn all the texts or have schools, but now for some reason that's happened, and let's stick to that. But that's also leading the direction of women wanting to become rabbis. And there again, I don't think you could really stop this. I don't think you can limit women to, well, we'll give you the Beit Midrash learning, and learning is even more important. Or in more ultra-Orthodox circles, we'll give you the home and the household work. That's holier than anything. The synagogue is just a men's club. Forget about that. I don't think that's going to work. I mean, I'm happy for a woman to feel where she's fulfilled, where she feels spiritually fulfilled. That's great. If she just wants to learn, that's great also. I just think we have to be open to these venues. The other thing I want to say just quickly about the Beit Midrash, and Rabbi Broid was actually very helpful in this transformation, that the Beit Midrash is the area where I think we can learn a lot from. You're learning from the point of view it's a place of learning. I see it as a place of real transformation where the people that are involved, it shows that can be a home where a lot of the laws, you're right, of the synagogue are put aside, and maybe also these laws that only men can lead also in that kind of surrounding where the people in the Beit Midrash and Learning Center really make it their home. So a lot to discuss, yes.
Thank you. I see the hands, but we'll defer them to the more public discussion, or more open discussion. Thank you.
Thank you.
Our next speaker is Charlotte Elisheve von Robert, who teaches in the Religious Studies Department and Jewish Studies program at Stanford University. She teaches undergraduate classes in religion and gender, religion and politics, and religion and ethics, although her field of research is rabbinic literature broadly, but in particular the halakhic discourse of the classic rabbinic texts. Her first book, dealing with the laws of what later became known as family purity, was awarded the Salo-Baron Prize for Best First Book in Jewish Studies of that year, and was a finalist for the National Jewish Book Award in the category of scholarship. She has also co-edited the Cambridge Companion to the Talmud and Rabbinic Literature, as well as the American edition of the collected essays by the German-American Jewish philosopher of religion, Jacob Taubes. Among her current projects, she is working on one is, of which this talk is a part, is on Jewish identity and territoriality in diaspora, and the title of the talk is American Arab, Halakha in Public Space.
Thank you now as the last panelist of the last panel of the conference. I hope you stay awake, but it's a special thank you to Sam and Mark for inviting me. And when I first initially got the invitation, I accepted it with somewhat of trepidation because I'm not a lawyer and I have not studied American law, and the only qualification I have to talk about issues somewhat about issues in American law is my citizenship test three years ago. But the questions that begin that test are sort of rudimentary, shall we say. But what I thought that I could contribute when I talked with Sam about this also to this, what has turned out to be a wonderful and very engaging conference from which I am also learning quite a bit, is a few reflections on a specific case study of an instantiation of Jewish law in America that takes place most literally in the public square. And Professor Freeman already talked a little bit about this earlier this morning, which is referred to in rabbinic halachic Hebrew as the Eruv, which I'm going to leave untranslated for a few seconds here. It's just very, it's one of those terms that are almost impossible to translate. But nonetheless, it can be demystified, I think, in some meaningful ways. So I have thought and written about this particular aspect of Sabbath law, a few essays, and mostly from the perspective as a scholar of classic Jewish texts with interest in cultural anthropology, rather than from the perspective of American law, about which, as I said, I know shamefully little, but had got much more interested during the last year or two, especially since law contacted me. So I wanted to start this out with mentioning to you that last August I received an email from a law firm in New York, and I talked a little bit with Michael about this. That was last August, where the law firm says the following, Ms. von Roberts, and I'm not saying that for self-congratulation right now, but there's a point.
Doctor.
I know, so that's already... I'm an attorney in New York, and my firm is involved in a litigation concerning a proposed Eruv. We represent a group of persons from diverse backgrounds, but largely Reform Jews, who are opposing the Eruv on constitutional establishment grounds. Your name has been given to us as the leading scholar in this area, and a brief blah, blah, blah. We are interested in an academic perspective on the issue, both to better educate ourselves about it, but also for the purpose of steering clear of some of the understandably emotional or political responses that tend to arise when it is approached from a purely religious angle. In that regard, the litigation is likewise focused on the purely constitutional legal questions and is not in any way attempting to advance an anti-orthodox sentiment. Yes, it is, actually. They offered me the possibility of serving as a consultant. So it only took a little while to consult with Golf Google and figure out that the Eruv controversy that this lawyer was talking about had garnered some notoriety by being featured on Jon Stewart's Daily Show on Comedy Central, which is in the Hamptons. So that's a controversy that he also mentioned. So accordingly, the Orthodox community in West Hampton Beach was trying to institute an Eruv, and to make sense of this with a few preliminary definitional notes. So I want to premise this a little bit. As per Jewish legal tradition, or there's 3 points that I want to make to be precise. Bear with me now for a few minutes, because we need these data to make sense of the controversy, I think, and the challenge for the neat confinement of religion to the private sphere that this poses. So as I said, it is part of, the Eruv is part of rabbinic Sabbath law with very little or no biblical roots, and that's sort of in part self-acknowledged in the classical sources, where we talk about Sabbath law as mountains hanging on a hair. According to Jewish legal tradition broadly, and here I mean the pre-rabbinic Jewish legal tradition that includes the Dead Sea Scrolls and a number of other legal texts that are arguably proto-rabbinic and non-rabbinic, the act of carrying or moving an object from a private domain, or your house or tent, into the public domain is prohibited as is carrying within the public domain or from one private domain to another. And so the broad Jewish legal tradition here is the prophets, the prophetic text, and the Dead Sea Scrolls, etc. Only the rabbis, as the progenitors of Jewish law as we know it, came up with a way to circumvent this. So here's the 3 aspects that I want to discuss a little bit with you, which is first, the various the ways on how to circumvent this. various private domains, including the semi-public sphere that they share, and in the ancient Jewish text and classical Jewish text is the walled courtyards in which the residences are situated, as in Mediterranean urban landscape, can be merged and unified, and that was the Hebrew verb of the noun connotes merging and unifying, if they share a symbolic meal. And the nature of this symbolic meal evolves over the centuries. Now, in the earliest text for this, in the Mishnah, the foundational text for rabbinic law, this late 2nd or 3rd century, it's bread or flour that is collected from the residents that share in this institution, that is then baked or every Friday afternoon. And that has to be deposited into one of the houses, not consumed. And then since Gaonic times, the period that Lina also talked a lot about, this is reduced to once a year, and there's, as you may imagine, only one kind of food that can retain its nature as food for a whole year, which is matzah. Even though one can argue whether... so that can, since medieval developments, can be deposited in the synagogue, even though there are some debates whether it's actually private residence. And there also are some practices where the matzah is nailed to the wall, which provokes some interesting symbolic misreadings. There's a controversy. There's a controversy in southern Germany in the 15th or 16th century where the apostates actually go to the Christians and say, look what they do, because the matzah gets always exchanged right around the time of Pesach when the new matzah has to be put up. So that's a whole interesting medieval sort of misreading of that. But that nowadays the practice is to put the matzah box in the rabbi's office. So now once merged, the elf, that's what that means. So everyone comes up with mergers or something like that. In such a manner, the boundaries between them between the private residences are symbolically dissolved, and now I can leave my house with my keys in my pocket or pushing my kid's stroller. So the kid's stroller is the favorite sort of practice that's evoked in advocating for the elf, because that sort of includes women in contemporary Jewish life, supposedly, and whatnot. So, though not immediately commonsensical, as if ritual ever is, it would seem easy enough to fit this within the place where religion belongs in liberal democracy, namely in the private sphere. Let them, Jews, do as they please and put a matzah box in their synagogue, just as the Eucharist is a matter of church practice behind the closed doors of the church. So, however, why should we care? However, the non-Jewish public does get involved in two further requirements internal to the system itself for such a circumvention of the original Sabbath prohibition to be effective. And these are the two. Now, if they're non-Jews living in the neighborhood, so to speak, and the classic sources here importantly assume that Jews do live among, intermingled with non-Jews, including in the land of Israel, they cannot be part of the food merger, since they're not, the non-Jews that is, since they're not subject to the Sabbath prohibitions to begin with, and therefore not subject to the same nomos. But neither can they be ignored, since they may have a share in the shared domain, the shared courtyards or whatnot. So therefore the classical sources introduce a further practice of renting from the non-Jew, symbolic rent for the purposes of the Sabbath observing. And this also originally was once a week, like the food merger. So the Jewish neighbor would march over to the non-Jewish neighbor and ask him to rent for the Sabbath his share in the shared domain. Now the classic sources consider this a rather fraught moment of Jewish, non-Jewish interaction, with great potential, again, for miscommunication, since to begin with, it is not entirely clear what it is that is being rented. Is it the right of domain as per permission to allow the Jewish neighbors to carry on the Sabbath? But from the non-Jewish perspective, they presumably already have the right of domain. And how is the rent assessed? Which here you get an incredibly interesting discussion in the Babylonian Talmud on what the reaction, projecting onto the non-Jew what his reaction is going to be once the non-Jew shows, once the Jew shows up, which is to think, what is this Jew up again? What is he up to again? If it's real rent for the value of the property, surely he's not going to give it back to me at the end of the Sabbath. If, however, he only gives me a penny or symbolic rent, it must be witchcraft. So that whole discussion, anyway, already anticipates what happens in a lot of the contemporary controversies. And then the medieval commentator Rashi also actually does consider this a social engineering trick, and that issue has come up again in the contemporary controversies. That, in other words, the rabbis come up with that practice because it's going to be so cumbersome that Jews will eventually move away. Meaning no Jewish source will explicitly legislate Jews should live by themselves in enclaves. But here's a way on how we sort of try to get Jews to move away from an immediate neighborhood with non-Jews. But that's only one reading of that practice. So this early practice too evolved over the centuries, and nowadays the practice is for drawing up contracts for a number of years, 99 years, whatever, for a symbolic amount of money from the appropriate non-Jewish representatives. And we'll get to one example towards the end. So let me emphasize what it is of interest here is that this additional requirement for effecting the possibility to carry and push strollers in the neighborhood on the Sabbath involves, by logic of the system itself, the non-Jewish public, indeed requires the involvement of the non-Jewish public, perhaps in principle somewhat parallel to the selling of leaven before the Passover mentioned by Rabbi Dr. Novak yesterday. But this here is a much more public version thereof, I think. So lastly, the third element, which is the one that's the most notorious ones in the contemporary controversies, is another involvement of the public, which however was not foreseen, arguably, in that manner by the classic sources and is incidental to modernity. The classic sources of Jewish law, from Mishnah to Talmud, etc., require that where there are no contingent boundaries, such as a walled shared courtyard, the walled alleyways of the Mediterranean urban architecture, and eventually the walled cities in medieval times, some intervention in the urban landscape is necessary in order to establish boundary markers, mostly of a symbolic kind. And here I spare you the halachic details, and Professor Freeman has talked a little bit about this. But there are many, 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 many volumes, halachic volumes, written on what qualifies thereby. So suffice it to say here that the contingent boundary is drawn by mostly by pre-existing boundary markers, fences, riverbanks, walls, etc., that already exist in the urban landscape. And then gaps are supplemented with symbolic gateways, represented by the infamous post with fishing lines spanning them. The supposedly most visible presence of Jews in the urban landscape. Or existing telephone poles are used but need to be supplemented with a signal plastic stripe, etc., to establish that contingent boundary. Now, the kind of intervention, which is not actual walls, and that needs to be emphasized again and again, envisioned in the classical sources did not raise any worry that anyone else in the town and city would object to. However, in the defortified cities of modernity, and especially in contemporary American cities, any kind of intervention in the urban landscape is subject to all kinds of administrative and public review. So also in this particular requirement of Jewish law. Just to clarify the in the ancient sources, they never envisioned that putting anything in the urban landscape would raise a controversy. That's really only an effect of the modern urban landscape. And here this is a little bit contrary yesterday to what you mentioned, and that was only in a footnote, that Sabbath law is actually firmly entrenched in the private sphere, because this whole thing actually fairly firmly entrenched in the public sphere. So let me return to the controversy in West Hampton Beach. Well documented on their website. All the documents of the last 5 years are on the website. So this is a classic model. The Orthodox community that wanted to institute the ERUV made a contract with the public utility poles company, Verizon, which later got invalidated after the debate started, and then, as Professor Friedman mentioned, the opponents incorporated themselves as a Jewish people opposed to the Eruf, which also at times was a Jewish people for the betterment of West Hampton Beach. And so they filed a complaint with U.S. District Court on establishment grounds, as noted in the email to me, and on 2 grounds. Number one, the public property and public display, the using of the public polls, but then also of government getting entangled in an intra-religious dispute, Reform Jews versus Orthodox Jews, and that is against the Establishment Clause. So that lawsuit was filed in July last year, but in the meantime, last week actually got dismissed. So none of the Eruf cases in the courts has ever sort of succeeded on establishment courts. So I should say now, I extracted myself from this, even though I could have earned my son's college money. And also, what I was really excited about, since at Stanford we have the ongoing debate of what really is still the justification of the humanities, and here was a moment of applied humanities. Finally, my scholarship had made it. So Michael can say something about the significance of this being cited in a brief. But anyhow, so Michael wrote the op-ed piece that was mentioned already earlier, which I in principle agree with, but I wanted to extract myself from that whole case because in the end I think it's really more about the social issues rather than the constitutionality of the institution of the Eruf. And here would say, contrary to Ibu Patel's ironic picture of how religious communities get along so well. Here you would have an example where some people have claimed that the body politic of West Hampton Beach is permanently damaged. So a couple more minutes, which is much more can be said in terms of the extended ethnography of this case. And this was just a brief narrative, but I'm not an ethnographer. And I just want to point out here that the literature is really growing. There was a long controversy in London, 15 years stretched out in the media. That was a case where there was really non-Jewish, heavy non-Jewish involvement, not just an intra-Jewish controversy. And that has been documented and discussed in this dissertation. There's no Eruf right now in Germany, but there is one in a German-speaking country in Vienna. That was just instituted by Rabbi Mintz was instrumental there last year, and there's urban Eruvin all over the place. And there's more literature, and the groups that have recently become very interested in this is also conceptual architects who have arguably written the most intelligent and sophisticated interpretation of what all this is about, and then artists, and there were a couple of exhibitions this year and whatnot. So the establishment of an Eruf in a community can serve as a gauge for social, 2 things. For the social fabric of the Jewish community, and that is the Jew versus Jew issue. And this is the most pronounced so far, I think, in the West Hampton Beach controversy. I'm not sure that that's true in the Palo Alto controversy, and the Palo Alto controversy is really what got me interested in this to begin with, where there were some prominent Jewish voices in this, but it really drew in the entire community. And the one issue I want to mention to you, since that has become recently an issue, is what actually is affected publicly by the Eruf is the question of property value, which has not been considered for a long while, right? That a lot of people are anxious about their property value going up or down, and since I'm not an economist and I can barely understand my own paycheck, I have to still figure out that issue. But at the same time, it's not just between Jew and Jew, but between Jew and non-Jews. As I pointed out, we have the symbolic rent. And so here I want to, at the end, read at the beginning of one document, which I love, which our wonderful librarian got to me at some point, which is the rental contract that the Congregation Kesher Yisrael in Washington instituted, signed by no lesser than the President of the United States, George Bush the Elder, which in that rental contract, the symbolic contract, he starts this out by I'm pleased to send greetings to the congregation in Kesher Israel and to the Orthodox Jewish community in Washington as you celebrate the inauguration of the first Eruv in the District of Columbia. This construction, the construction of this Eruv is particularly significant not only because it marks the growth of the Orthodox Jewish community in Washington, but also because the city is our nation's capital. Indeed, there's a long tradition linking it. And now the beautiful moment is that the voice of George Bush Sr., President George Bush Sr., quotes the responsa attributed to Rabbi Moses Sofer, the Chasam Sofer, and gives you a long paragraph from his tshuva on the issue of the Eruv in Pressburg, then Pressburg. And so he concludes, now you have built this Eruv in Washington, and the territory it covers includes the Capitol, the White House, the Supreme Court, and many other federal buildings. And it promotes family values. That's how he... Now, of course, George Bush never saw this document. The rabbi of that synagogue is Rabbi Barry Freundl, who was a ghostwriter for the document, but there was non-Jewish governmental representative involvement in this. So here we have an example of the establishment of an Eruv with no controversy, and that's noteworthy, and these great United States accommodating the religious needs and rituals based on the prerequisites of Halakha. Now, some of this depends on how the negotiations are conducted, how the nature of the ritual institution and the mechanisms of Halakha are communicated, but in some of it on the social fabric of the local community and the standing of the Orthodox community or its leaders in that community. So with that, I want to conclude, and we can discuss some issues.
So we can open it up for questions. Maybe a couple of minutes for questions for Charlotte in particular before we open it up.
Michael, do you want to say something about the brief? Just a brief.
Oh, just a brief. What I'm going to say, a friend of mine is doing a litigation in New York for the air, and one day he sends me a brief. He's like, "What is this?" He's never seen anything like it. It's the most extraordinary brief we've ever seen. And there's 2 pages cited in a legal brief from some of Charlotte's work. I said, it's literally the most extraordinary placement of academic work of all time. So I think they should put that front and center in Stanford's magazine to show that applied humanities. There's no better example of it.
Thank you.
Yeah, I mean, you alluded to what I said yesterday, and you're right, this is a Sabbath thing that's not strictly private. The difference, however, is where something like marriage is something that Jews have to engage in, they don't necessarily have to have an error. But the point I want to make is as follows. What has happened, and I've been involved in some of this on a practical level, non-Jews rarely are concerned about this at all. They don't want to be perceived as anti-Semites, so they're probably not. And why not, you know? And, you know, you'll have a concession that there should be a Christmas tree, you know, in the public square. This is understood. What the real objection are many non-Orthodox Jews who see their neighborhoods being, as it were, taken over by Orthodox Jews that make them feel uncomfortable. You know, as one man stated to me, I can't wash my car on the Saturday anymore. My neighbors stare at me. So therefore, they would much rather have non-Jewish neighbors who are not going to call their lifestyle into question, as opposed to... So it becomes an interesting factor where halakha does not unite the Jewish community, it divides it. In the same way that a bet din, that Rabbi Broid was pointing out, yes, that's very interesting to bring people together. However, if the bet din is a bet din of a certain denomination, and then a denomination within a denomination, very few people outside of that Jewish denomination are going to go to that bet din. So therefore, the idea that it brings people together is not the case.
Right. Thank you. Yeah. No, you're totally right. But you could add to that, I think, that this is actually a structural part of the thing itself, because already the rabbinic, I don't want to say invention, but the rabbinic sort of, well, let me say invention of the Eruv as a way to circumvent what was broadly accepted Jewish law across the right, Sadducees, Qumran.
And that's the whole point. Sadducees can't participate in this.
Sadducees can participate, right? So in its very nature, it is actually arguably sectarian, right? That it's only the rabbis, so they set it up, but they have to. In the end, rabbinic law sets itself up as sort of arguing, no, it goes back to the times of King Solomon, not to sort of argue about its long tradition, but in the end, the thing itself is really a sectarian, right, originally, which at least it's a sectarian thing.
Just on this, in this point, when our Eruv in Lakeview in Chicago, we went to the Chicago City Council with the Reform rabbi and conservative rabbi and me. So I think it can lead to disunity, but it can also be a unifying force, even if I think Reform Jews in general don't need an Eruv on Shabbat. But I think, also if you want to be more homiletical with the meaning of Eruv, of community, and of also creating a public space into a private space or the equivalent, and this shared meal. So I think if we work more on this sort of homiletical or this meaning of it, maybe a deeper meaning, then it can be more of a unifying thing, and it can speak to Jews, non-religious Jews, non-observant Jews, Reform, Conservative, and Orthodox.
Sam, and then questions for everyone.
Well, the exchange between Charlotte and David made me think about something that actually, I don't know what to do with it, but it could raise an issue of great interest for the whole themes of this conference. We've been thinking, I think to some extent we've all been thinking about law primarily in terms of an instrument of coercion. It isn't always that, but certainly the tensions that can come up between, I'll say, Jewish and Islamic law and American law have to do with, on the one hand, feeling that American law is coercing the religious structure of Jews and Muslims. On the other hand, a fear that the Jewish and Muslim legal structures will themselves be coercive to minorities in their community, etc. But there's another way by which we influence one another that's been really important to religious communities particularly, that, to use a Foucauldian term, I can say, put in terms of surveillance, but basically, when it used to be, you lived in a Christian country, in a Christian neighborhood, everybody went to church, you didn't go to church, somebody's going to look at you and say, why didn't you go to church? It's not, you feel pressure. And if you're an atheist, or if you're a disbeliever or a skeptic or a heretic, it makes you uncomfortable, right? And that's been a feature of life for centuries, and even into the present day, it's a feature in many rural communities, and some people who are outside their religious norms move into the urban center, especially now that it's filled with lots of cosmopolitan people. Sometimes that's a euphemism for Jews, but people who don't fit, and then they can be comfortable in their heterodox practices. Well, that's what's going on. I mean, it's a restoring of that old-fashioned community that you get when the Eruv is up, or you can get, and that was what leads to the guy not being willing to, being very uncomfortable washing his car. So it seems to me that one of the interesting things that's going on is, to what extent do we want to disperse, dissolve, get rid of the aspect of monitoring one another that has been very important for keeping religious communities together in the past? Do I think that it's going to be a good thing that liberal democracy, especially in its urban centers, tends to disperse that, and to what extent is that a loss?
Yeah, I mean, that's a good question. I'm not, I mean, one of the issues, since that comes up a lot, right? I mean, West Hampton Beach, as I say, is social engineering. So it's instituting the Eruv is about change. Something changes. Usually, more Orthodox will use. I mean, the argument is made that more Orthodox will move to town, and so therefore, right, you get more of that scenario of surveillance in theory, which I have not found a single study yet that sort of demonstrates that actually more Orthodox do move to town, or that that the presence of an Eruv, it may sway you to move to this side of the street rather than to that side of the street, which they, someone demonstrated that in Sharon, in Boston, in the neighborhood there, in Sharon Heights. But it doesn't per se, and that study still has to be done, how it really realistically, I mean, I don't know how, but influences sort of these kind of demographic patterns, and therefore, in theory, is really about social engineering, right? Versus it sort of creates a signature to somewhat to something that already exists. There is an Orthodox community in town. There is, right, and it's these people who live there who want the elephants. So it's more about that rather than creating more of a degree of surveillance, right, or changing it towards that. Of course, I mean, I guess in the end you would argue that just the fact that more people supposedly are on the streets now, right, in London, in the London controversy, came up again and again. I don't want to see Jews walking, right, more these religious Jews walking outside all the time on the Sabbath and whatnot. But it's just not a realistic kind of. I think in the end it's not a realistic issue.
Actually, I think this point that Sam raised is really quite common, like when it comes up in the hijab cases in Europe. Because the idea, for example, that Turkey gave in defense of prohibiting hijab in universities was that it made non-hijab wearing women uncomfortable to the point that they couldn't study properly. Because the idea is that even if a hijab wearing woman doesn't say anything, it expresses a certain view of religion that the non-hijab wearing woman will internalize as personal criticism of her, right? And so that's an infringement of her right, to sort of be free of religious proselytization or proselytizing discourse while she's at university, and so therefore it's reasonable to prohibit hijab. I mean, I don't think that applies in the United States, but that same kind of logic is that, and you see sometimes the European Court of Human Rights, when they analyze freedom of religion, they say freedom of religion is also very valuable for non-religious, the right to be free from religion, right? And part of being free from religion is that you don't have religious messages being communicated to you, sort of in an unwanted way, in the way that maybe my understanding is it's a fish line that you can't even see. So I don't know. Anyway.
Right. Yeah. No. I totally. I thought of something else to create the parallel there, but because but just on the last point, the visibility. I mean, first of all, the visibility issue is something that the Jon Stewart clip picks up on and just skewers. So you have to watch it on YouTube. Because you have to know where it is, because otherwise, I mean, unless you know where it is, but you could argue, actually, now that the maps of the Elwin are up, right, you could go on the maps of Congregation Kesher Yisrael, there's a map, so that creates a different kind of visibility in the urban landscape. Or Palo Alto, actually, they didn't put up the map on their website because they were so worried after all the controversy and the geschrei against it that people would sabotage the elves. So you actually really literally have to know where it is to see it. So the visibility, I mean, it becomes visible but only at that one moment of where the thing gets negotiated, and after that, right, it's just sort of integrated into the urban landscape. But the issue that I was going to raise as a parallel, I think, because in part the anxiety that comes up around the elves is also sort of now and I think Professor Friedman mentioned that, right, the Orthodox community only does it at a moment where it feels comfortable enough, maybe arguably in the social body of the city, but it sort of creates a symbolic permanence. So now they're here and they're putting up this thing, which in the end is actually not a permanent boundary, but it creates that kind of sense. And I think what I was thinking about as a structural parallel is the arguments about now that the Turkish Muslims in Germany are building mosques, and all of a sudden mosques are, they become a symbol of the permanence of these people that were formerly guest workers, so to speak. And not only that, they're radically supposedly changed. That's the argument. The skyline, and we are so obsessed with our skylines, right? In the issue around the mosque in Cologne, which is UNICEF protected with the cathedral in the middle, which already, I mean, there's all kinds of skyscrapers around it anyhow. But there, that issue about the minaret was, oh my God, now, right, the Muslims are visible. in the urban landscape, sort of. So there's a sort of also that moment of these people are now building buildings here, and therefore that means they're here to stay. And so that's, I think, also an aspect of that. Does that make sense?
Maybe we could ask, we could allow Charlotte to sit down, and then, thank you. Feel free to address your questions to any of our three panelists. Yes.
A couple of brief sociological observations about Arab issues. I hope the Muslim participants are not totally bored to death by this. In terms of sectarianism, I believe Rabbi Lopatin's mentor, Arnold Soloveitchik, and other center and right Orthodox rabbis are against Arub in any major city. So it isn't all Orthodox Jews. A very important large group are against, believe it's not permissible to do it in this
Lithuania.
Right. And many Hasidim. And many Hasidim also.
Wait, but some of those are technical issues, right?
Right, but they're insurmountable technical issues. In a large city, you just can't do it according to those authorities.
Right,
Also,
I mean, in some contexts, it turns into an issue of religious territoriality. My elk is better than your elk,
right,
and
well,
so therefore...
kashrut and things like that. Also, as an Orthodox Jew, I do have some sympathy with the Reform Jews who don't want to have an Eruv in their community, because it does, I really think you're wrong, that it causes Orthodox Jews to move in to or move around in Toronto and Skokie and Riverdale and Pico Robertson. I mean, Sam and Mark and Rabbi Belinsky and I from our small Orthodox community in Evanston are praying to be able to set up an Eruv there, because we hope that many families actually will move from Riverdale, from Lakeview. But it really affects, as people have said, if you have little kids, the mother in most cases has to stay at home. So it's a very important thing, and it really does draw Orthodox Jews. But I'm sympathetic with the people who don't want that. For example, you have the situations in northern New Jersey and Long Island, where communities have been taken over by Orthodox Jews, who then ran for the school board, and because their kids all go to day school yeshivas, slashed the budgets for everybody else. So, and total transformation of what kinds of stores were selling, which kinds of foods and things there. So I understand why they're worried about.
No, I see that. I
overrun.
just haven't seen a demographic study that demonstrates that.
Well, anecdotally, I think every Orthodox Jew can give you dozens of examples.
I also think some of those communities that you're pointing to might be Haredi communities that don't accept the Eruv. They moved in for different reasons. That's why this study is so difficult. There's so many different factors why they're moving into those areas.
The Kangaroo 5 towns is mostly modern Orthodox people, but...
Yeah, that's for Lena. On the first slide, you talk Sharia being equal to Torah and then Halakha to Fiqh. How about if Sharia and Fiqh is more to Halakha and Quran is to Torah?
Well, I'm basing it on Beirut, so I'm basing it on what rabbinic jurists living in the Islamic world who spoke Arabic fluently and wrote in Arabic would conceptualize it. So I think...
But it won't be wrong to do it that way.
Well, it's because it's a different, there's oral Torah and written Torah, so there's a different conceptualization of Torah built in that's also there within Sharia, right? When people sort of say Sharia, they also kind of think about Quran. But so the point is that it is Sharia Torah in a sort of general way.
I had a comment for Rabbi Lopatin, and then I had a question for Rabbi Lopatin for Dr. Sulaiman. So one, just on the argument that you made earlier about public space versus private space, a colleague of mine at the University of Pennsylvania has done some research on the Jury Robust synagogue, and has shown that actually it's basically just a house. It's the structure.
No, which synagogue? Sorry, the
Jury Robust synagogue. So one of the oldest surviving synagogues in existence actually is structured within a private dwelling, and so there's at least some precedent for that. The question was, I'm just wondering in terms of the way that you formulate your argument and your kind of self-definition as making an orthodox argument, that there have been Jewish legal, let me say that carefully, Jewish legal arguments made on similar issues that come out of conservative circles, that come out of rabbis like Rabbi Daniel Sperber a decade ago, more recently, out of the non-denominational movements such as Mahmoud Hadar, Rabbi Ethan Tucker, and Rabbi Michael Rosenberg have made arguments, all of which are very much in conversation with the sources that you're bringing. So I'm kind of wondering how you formulate the limits of your discourse, and I'm wondering this partially in connection to what Lena said earlier. What does it mean to think about one's law and where denomination fits into that? Because it seems like in some sense, if the boundaries are defined socially in terms of like who is orthodox, then there is a kind of separate element. It's not purely legal, unless definitions of what it means to have an orthodox legal interpretation versus another legal interpretation are made explicitly legal and not religious.
Great. It's a difficult question, and I appreciate it because I think that there is that element of sort of the Orthodox culture and the Orthodox world and not being open to arguments from outside. Certainly on a specific issue, like if there's a conservative scholar or a non-observant, non-denominational scholar who points to a text, let's say the Meiri. Once I use Professor Halbertal has some evidence from the Meiri about that you can cook for Gentiles on the holidays, on Yom Tov, and I showed it to Moshe Soloveitchik, and he took it seriously. So on a very specific, but on matters kind of judgment, then it's much more a cultural thing. Rav Daniel Sperber is definitely within the Orthodox culture, but he's not seen as a posek, as a halachic authority there. Are we being recorded here? Ethan Tucker actually happens to have Orthodox ordination. And I'd asked some of his rabbi, there was a question came up that, Ethan was on a Beit Din, and the question came up to another Orthodox authority, is on a Jewish court for a conversion, is he acceptable? And this person says, yes, he's part of the Orthodox world. So one way of doing this, of sort of opening up the Jewish legal world is to be adventurous and really to look at different sources from outside the Orthodox world. And I'm not sure how effective that's going to be within the Orthodox community. So I'm sort of looking for efficacy within the Orthodox community. And to do that, I kind of want to take the approach of bringing an Ethan Tucker into the Orthodox world and say, no, he's really Orthodox, or this tshuva that he wrote, this responsum that he wrote about egalitarianism is a very Orthodox responsum. So I take what you say really seriously, and I think that effectively to convince, to have movement within the Orthodox community, people are going to have to feel comfortable that these are sort of Orthodox authorities, but it's a very good point.
In the back. Yes.
This question is for the first speaker. The arrests that you were referring to with respect to the affiliations game, where are those taking place?
Everywhere in the U.S. And I'm mostly talking about individuals who have basically been subjected to forms of entrapment, where they're usually young kids who go to mosques and have espoused certain ideological positions but haven't actually done anything. That they happen to be talking to FBI informants without knowing it, and then have been subjected to various kinds of convictions for terrorism.
Right, but what about like the gang, the central gang stuffs? Because the gang here has been found unconstitutional. Are there other places where they are stopping for just...
Yeah, LA, for example.
LA
yes.
is, okay. Yeah. All right, thank you.
Stop.
The first question for Lena and then for Rabbi Asher as well. You mentioned, if I understood correctly, these terms are better translated than rather than they are left untranslated. But I wonder, because of their politicized and exoticized nature, but I wonder if that's a bit of a defeatist attitude. And instead of that, we should be attempting there's a need to redeem these terms and maybe clarify them in conferences such as this. So that's why, for example, the title of the conference, not that I considered it provocative, but if it was considered provocative by people, then that gives them the chance to come here and listen and then seek a clarification of what these terms mean, not necessarily by spending time defining them, but just by the subjects that these cover. that's one thing. The second thing about law was, in early Orientalism and views on Islamic law, Orientalists never really dealt with the ritual side, the ibadat side of the law, because they just couldn't conceive. But what their conception of law was, just didn't fit with that, so they thought, well, forget that, that's not law. So they only dealt with the mu'amalat, the issues with the transactions and dealings and capital punishments, punishments, criminal law, and so on. However, I think there's a shift now, and some views of modern Western academics on Islamic law don't like to call fiqh or Sharia law, because it also deals with, in a positive way rather, because it goes above and beyond what conceptions of law are, such as the way Tim mentioned, categories of moral categories as well, such as disliked and preferred, if we can call them moral categories. They don't use them in terms of classical Islamic law, call them moral. So in a positive sense rather, they think that it's something even perhaps more profound than what we conceive as what law is, because it contains moral guidance as well. And a question for, or a point on fantastic presentation maybe by Ashley as well as the other two. Yeah, we have it's interesting, we have the tradition that a woman should make a kind of a masjid or a prayer niche in her home. So there is this idea of kind of a private place of worship. What I think is quite interesting is that since the Amina Wadud case, the debates around women leading prayer have kind of receded, especially in the UK. I don't know about the States. So we don't really have that debate as much anymore. And as Professor Novak said, women are finding other ways for their religious, intellectual, spiritual fulfillments. There's more public presence of women in speeches and gatherings and learning in institutions. So that's happening quite a lot. But if this kind of, I think perhaps in a couple of generations, if women start calling this, I think your model is very interesting, because the interpretation of Dar, which you mentioned, which was spot on regarding the discussion, people have said, or scholars have said, that refers specifically to women who are like relatives or who are within the private domain of the house. So I can see possibly scholars interpreting maybe a section of the mosque or a building, if there's some kind of private membership in the way that you mentioned. And then that could perhaps act as the dar as well, because you know who the members are, who they all are. It's not guests, because people say there shouldn't be strangers. The women in the house means you can't invite strangers, for example, so that means it's no longer private. So if it's kind of a membership way of doing this thing, or a community, then I can see how the model may work, if there's the need for that. But at the moment, it doesn't seem to be that women are calling for, to be imams and whatever. But then, there's also the argument they can't leave the obligatory prayers. Some scholars say it should be only the optional prayers and so on.
So, okay, I'll start with your second point. So there are Orientalists who dealt with ritual, and actually there's an interesting story there about people like Goldziher, who was a Reformed Jew and was very much interested in reforming Judaism through his study of Islam. So I wouldn't make that kind of blanket statement.
Yeah, not all of them.
Right, about Orientalists having ritual. I think you're getting the moral category from what halal. And I take that as a valid point, but the point is that secular law also has morality. So it's not that somehow Islamic law or Jewish law are quite distinct because they have moral values in them. All legal systems have moral values. I think that Watt's position on these issues has more to do with his critique of modernity and his critique of the modern nation state. And so for an engagement with that, I would actually have Mafalda's review of Watt's book, which I think addresses some of these issues, right, if I remember correctly, on the sort of categorization of law. But the point being that I don't think that Watt is trying to say that it's not law, it's more than law. It's just that the law is infused with morality, which is true for lots of legal systems. On the defeatist issue, I don't think that this is a matter simply of, well, the market uses this term, so you should use the term because then you would draw attention towards your valid use of the term in some way, and that way you're just sort of engaging with the market. Because I think that there's something much more insidious in the use of the term Sharia in the contemporary political world. So just as an example, Bin Laden in his fatwa, his legal decrees, uses the term Sharia to describe his opinions. Now that's a really, that's something that could easily be contested, both on the grounds of the fact that he doesn't really have jurisprudential training and it's questionable whether he should even be making a legal opinion to begin with. But second, that the claim that it's Sharia and not that it's fiqh, and that doesn't follow, like if you read the legal opinions at the end, he doesn't actually say things like, and God knows best, for example, right? That he doesn't have this kind of recognition of the Sharia fiqh distinction, which is something that we know is typical of Salafis. means that when we engage in this kind of terminology, that we're not just sort of using Sharia in an innocent way, but we're actually intervening in that political discourse and legitimating the erasure of fiqh as a term. And that happens more often in English than it would in Arabic, because in Arabic people conceptualize that there's Sharia and then there's fiqh, and in that sort of native discourse, those things continue to exist. But in Western discourse, because there is no fiqh equivalent, when you use Sharia, it's sending a far more insidious political message than I think most people realize.
Sorry, did you want to, was there a second part of the question?
I was wonderful. Thank you. I want to follow that up. Thank you very much. And it's this has been a. I talked about this sort of the private-public thing, but some people know I talked over the years. Try to get into this journal and that journal and this journal and that journal, and finally it was in a journal. It was supposed to be in a journal, women's rabbinical school actually, and there weren't enough women in that journal, so they threw out all the journals and they're redoing it. So one day, but maybe I should publish it in an Islamic journal and more luck.
I wanted to draw a connection between Lena and Rabbi Lopatin's discussions. Lena made a plea that we should use the labels Jewish law and Islamic law in order to break down this barrier and make people realize that we're really talking about the same genre. And I think in response to that, Sam and Mark raised the question that actually there are differences. The difference isn't necessarily secular and religious. The difference is state law and non-state law. And the difference between state law and non-state law, I think, is highlighted by the question that Rabbi Lopatin was fielding, which is what makes your particular, halakhic view on this a legitimate or an orthodox halakhic view. And in state law, these questions are much more easily settled, because the highest court in the jurisdiction decides whether or not a particular view is the law or just an interesting legal opinion by some outlier. And in non-state law, we have a problem that we don't actually have reference to a decision maker like that. And another example of non-state law that was brought up was international law. This is a notorious problem in international law, and it's given rise to the debate as to whether international law is law at all. And the roots of this, in at least the Jewish law field, go back 35 years to Robert Cover's essay in Nomos and Narrative, in which I think what he wanted to do was to collapse the distinction, at least as a genre category, between states law and these other laws of the Orthodox world or the Mennonite world or any other world. And he viewed the difference between being able to declare what the law is in the state law side and not being able to as a way in which state law is jurispacific, that state law actually is in the business of destroying alternative views of law in order to establish what the appropriate law is. And I think that it's interesting that in some ways we're coming back to the question that he raised, but with the benefit of 25 or 35 years of a lot more sophistication in our discussion of Jewish and Islamic law in relation to what we study in law schools. And this desire to break down that barrier, I think, is exactly the thing that motivated that essay 35 years ago, which in many ways launched the Jewish law discourse in American law schools.
Shlomo.
I'm really, Alina, really sympathetic to that argument, your argument, and particularly the highlighting the distinctions between Sharia and fiqh and Torah and Halakha, which we discussed a little bit a couple of nights ago. I wonder, however, whether translating or using the terms Jewish law and more particularly Islamic law are any better. From my experience, and I'm very conscious of this in my own writing, but from my experience, using the term Islamic law is often then confused with, well, Islamic law, that's what they do in Iran, that's what they do in Saudi Arabia. Although the proper terminology for that, I guess, would be the law of Muslim-majority countries, or the state law of this country or that country. It does not, these things that are associated with the term Islamic law do not reflect fiqh, of course, but I think that's the baggage that the term often carries, and I wonder if there's any, I guess, convenient way of, if you think there's any convenient way of kind of detaching the one from the other. I don't think using the term Jewish law has the same problem, because I think there's a generally much more of a recognition that Jewish law does not mean the law of the state of Israel. It means something religious. But
on the other time, I get a lot of pushback whenever I use the term Islamic religious law.
So I talk about that in my article, Commodified Islamic Law in the U.S. Legal Academy, where I explain that there is Islamic jurisprudence and then what I call Muslim legalities. And Islamic jurisprudence refers to that jurisprudential methodology, usul al-fiqh, and the development of laws through a particular methodology, through using the Islamic canonical text. But what you would describe as, so the thing like Iran, I would say that's part of Middle Eastern law, contemporary law in Middle Eastern states, or contemporary law in Muslim majority states, as you alluded to. And those are referred to Muslim legalities. So I think that there is a way to create a terminological distinction, and I have done it in that essay.
Yeah. Just a couple of points on Rabbi Asher's discussion. One is that I think what you said about Ahl is interesting, but Muslim mosque really does not have any membership. And very few mosques even in the United States will have membership. So the mosque is, and because of high degree of mobility, the mosques are becoming more and more anonymous places. We really don't know who are these 1,000 people who are coming to the mosque. So I think that interpretation is practically very hard to apply, that mosque is an extended family, really the people we know. The second question about the Muslim women leading prayer. One problem, I mean, besides the legal discourse of ijtihad and reinterpretation, one problem which we have is that the Muslim community in the United States, particularly after post 9/11 situation, is highly suspected by the mainstream Muslim community in the Muslim world. This is a very important point. So many of the understandings and interpretations which will be do here under the pressures of pluralism or secularization are seen by the Muslim world part of our ability that we can't really function as a Muslims in American society, so we are under pressure somehow to distort our religion. So if this kind of interpretation or practice comes from Saudi Arabia, or if it comes from Qom in Iran, it will have certainly some legitimacy. But an American woman converting to Islam and leading prayer is really an aberration. I really don't think it carries any weight in the broader Islamic world.
I don't know. And I'm trying to think of the parallel to in the Jewish world between Israel and the diaspora. Interestingly, this kind of service where a woman leads for men and women, but it's an Orthodox-looking service because there's a mechitza, there's a divider, start almost simultaneously in Jerusalem and New York. In this sense, I think they're actually America, at least America and Israel are moving in the same direction, the same speed, really. But the thing about the mosques public, I think, thank you, that was helpful. I wonder if, in the future, next generation, that model will work for the Muslim world. I know that in 50 years ago, the model in American synagogues were these huge, sprawling synagogues. Now an organization called Synagogue 3000 came out with a report that it's really all about relationships, and Jewish organizations and synagogues are going to survive if you can create those relationships, not fancy programmings or dynamic speakers or anything like that. So I don't know, the culture and the sociology in the Islamic world, the Muslim world in America, but it might be that there will need to be a shift, or as Mustafa said, to a slight change in having a sense of membership, at least in a part of the mosque. I couldn't speak to that, but it's been an interesting evolution in the Jewish community.
Or part of the home, maybe.
Yeah.
If there's a space in the home.
Right.
I just have a question for Lena, and so it's I guess it's also a question perhaps partly for Michael. So I understand you making sort of suggested two-step transformation, right? From Sharia halakha to Jewish law or Islamic law, and then from that to state versus non-state law. That was just something that you alluded to at the very end. And that echoed Michael's suggestion that we should demystify religious law, think more in terms of it's just law. And I want to ask how far you push that, and also sound something of an alarm. And the alarm is that there's religion is treated differently within our American system, and although it for sociological purposes, for example, I think that most members of religious communities don't feel that they opt into religious traditions in the same way that my kids might opt into the Boy Scouts. And to the extent you want to erase or eliminate the religion category, it seems to me that that there's genuine risk that's posed to the religious communities. So I don't know how far you hope to eliminate religion and remake it entirely as a dichotomy of state non-state, but I'd be curious to hear. And related to that, one of the really great presentation that we gave was very interesting, and it's interesting to me to see etymologically that the source of maybe religion secular language might be racial, but I understand, notwithstanding its source, that we own the meanings of words. They develop. They have different. I'm not tethered to the source, and so the mere fact that the source might be problematic doesn't mean that that kind of conceptual distinction between, for example, religious and secular can't be meaningful, doing real analytical work, being, again, a useful dichotomy. So historical source and the analytical usefulness of that source, it seems to me, are two separate matters. And so I'm just curious what you have to say about those two things.
Okay, so I understand that you want to sort of hold on to the usefulness of it, but I think that what I'm saying is that you can't separate analytical categories from political discourse. And what I tried to do was not only show you the historical genealogy of religious and secular in the Aryan Semite world, and that's something that has been worked out by Gilad Najjar in his book on Semites, but so that I'm really just taking it up from him, but also to show you the contemporary manifestations. So the point of the circumcision case study is precisely to show you the ways in which discussions about religion actually do sort of manifest a certain sort of racial categories, right? And that also the other example being the jihadi, so that there is a way in which the discourse on religion is used and has traditionally been used for imperialist purposes, right? That's not a surprise. It's definitely used part of imperialist conquer and divide strategies, and continues to be used in certain ways for political gains. So it's not that I want to erase the religious category completely, but that I want us to be far more suspicious about how we use it and far more careful about when and how we use it. So there are lots and lots of times, and I think that Michael's example, the case that he talked about the OBGYN yesterday, is a perfect example of where religion gets stuck in where it's not about religion, right? And there's all sorts of ways that I think that we probably experience this in the academy, where people ask me questions about Islamic society or Islamic history, and I'm like, but that has nothing to do with religion, that has something to do with an economic situation, or that has something to do with a political situation. But religion becomes, unfortunately, a false causal explanation for all sorts of things that have nothing to do with religion. But the reason why it plays that role is precisely because of these kinds of racialized issues. Does that make sense? Does that answer that?
Yeah, let me just say one thing about that. The fact empirically that you show me a slide that admittedly correlates religion with race is far. I need a lot more data to suggest that that's the ordinary association that people make, or that's the ordinary usage of the term. Mm-hmm. Although it was absolutely striking to see that. I'll just add that.
No, I understand completely, but I think you're being empirical about it. So I don't think that I need to show you that the majority of times when religion is used, it's used in racialized ways. I think that the fact that it's used in racialized ways quite often is sufficient for us to start questioning why it's being used in that way.
Well, I don't even know that it's quite often. That's what I mean by empirical.
Right. I mean, okay, so then then you can sort of, disagree about the amount. But I would also say that there's a way in which you can't empirically measure this, because the point of that comic is that it happened to be that there's this one person who was brazen enough to do the Foreskin Man comic, right, and put these anti-Semitic images out there. But most bigots aren't that obvious, right? So there's a way in which you're asking me to measure something that actually cannot empirically be measured, that we need to be suspicious about it, because these are not the kinds of things that people are sort of obvious about, right? And that was also the point of me talking about the way in which secular discourse is used, right? The discourse of human rights was what was being used to attack male circumcision practices, right? But really underneath all of this, and partly I know this because I participated in a conference on circumcision at UC Davis, and the people that were invited included people from the community who were involved in the anti-circumcision debate. And one of them was a Jewish physician from San Francisco who was against male circumcision, but who admitted to me that, and to the conference participants, that there were lots of people involved in the anti-circumcision debate who were really anti-Semitic. And that there was all sorts of anti-Semitic things being said at these meetings, and not that you could record it. I mean, I'm not going to necessarily be able to find it online or find an empirical way to measure it. But that it's there, it's there. I mean, I don't think we can deny that it's there. The question then about its efficacy.
The anti-Semitic is not racist, though. There's still a gap between the two.
No, I would disagree with you on that, because Semitic is understood as a race, and that's the whole point of Aryan versus Semitic discourse. Semites were invented as a racial category in this context of 19th century Europe, in which Aryan was white and pure and, the blonde foreskin man, basically, right? And Semites were the brown people.
Tim, yeah, I just want to suggest that you could both be right. That is, it is possible that one function or use of these categories is for racial power redistribution, and it's also possible that one use of these categories is for special designation of certain kinds of association that American political culture treats differently. And this is what related to what Charlotta talked about, which is that if any group wants to put up some sort of mechanism that will allow them to collect, there are certain protections against trying to stop that. But the protections are much higher if it's a religious group that would like to get together and use some public mechanism to do that. And so it's entirely possible that one of the costs of calling things religion or religious law is that it becomes a proxy or a tool in the kind of racial dynamics you're talking about, and at the same time it plays a very special role in protecting certain kinds of associated groups or certain kinds of activities that it wouldn't in American political culture unless it was called religion. So it seems like it's a cost-benefit thing, not so much, you don't have to take one side. I mean, the question is it worth it? And that is an empirical question, I think, and that would be hard to measure.
You're right.
So we'll take one last. Mohammed, are you still interested?
He wants to speak now.
No. What would you think? I mean, I think what's interesting about those comics is not so much the villains, but the hero. I mean, could you imagine Foreskin being like a brownie? It's sort of hard.
No, he wouldn't.
It's sort of hard to imagine Foreskin Man being a brownie, right? I think that's sort of the point. It wouldn't really. I don't think it would go very far.
No, he's like a Superman Jesus. That's what he's supposed. I mean, that's what he looks like. Right?
Okay. On that note. So we have a 15-minute coffee break. Please reconvene in 15 minutes at 3 o'clock for the keynote. I keep my guess.
Here you are. You make the bonds together.
So I think we'll get started, everyone. I'm pleased to be able to introduce our keynote for today, Mohammed Fadel, who is Associate Professor and Canada Research Chair for the Law and Economics of Islamic Law at the Faculty of Law at the University of Toronto, which he joined in January 2006. Professor Fadl wrote his PhD dissertation on legal process in medieval Islamic law at the University of Chicago. He was admitted to the Bar of New York in 2000 and practiced law with the firm of Sullivan and Cromwell in New York City, where he worked on a wide variety of corporate finance transactions and securities-related regulatory investigations. He also served as a law clerk to the Honorable Paul V. Niemeyer of the United States Court of Appeals for the Fourth Circuit and the Honorable Anthony A. Alaimo of the United States District Court for the Southern District of Georgia. He has published numerous articles in Islamic legal history and Islamic liberalism, and let me give you just a couple of titles, very randomly chosen to give you a sense of his work. The True, the Good, and the Reasonable, the Theological and Ethical Roots of Public Reason in Islamic Law in the Canadian Journal of Law and Jurisprudence. Public Reason as a Strategy for Principled Reconciliation, the Case of Islamic Law and International Human Rights, Chicago Journal of International Law, and Muslim Reformists, Female Citizenship, and the Public Accommodation of Islam and Liberal Democracy in Politics and Religion. The topic of his talk, his keynote lecture tonight, is Religious Law, Family Law, and Arbitration. Have fun.
Well, I certainly appreciate everybody's patience. It's been, it's quite, I guess, heroic for you to stay this long to listen to my talk, and I hope I can live up to your expectations. What this talk really, what it's not going to be about, it's not going to be about Islamic law. It's really about political liberalism, and what I think liberalism requires in terms of recognition of pluralism with respect to the family, while at the same time the kind of limits that liberalism at the same time imposes on family life. And I will use sort of Islam as an example of how liberalism, I think, should approach issues of family law, recognizing that Islam is not the only religious conception in the United States or liberal democracies, but just using it as a paradigmatic example that may be especially politically salient. And the basic take-home point is, I think for the vast vast spectrum of issues, there's really no problem at all. And if you're a good liberal, you should have no problem endorsing family law arbitration. But let me tell you why I think you should reach that conclusion. Now, Western democracies in recent years have witnessed dramatic and often highly charged debates regarding Islamic law, women, and the limits of pluralism in a liberal polity. Perhaps the most relevant of these in recent years has been the Sharia, the so-called Sharia arbitration controversy of Ontario, Canada, which took place between the years 2004 and 2005. In fact, my hire somehow got embroiled in that. People accused the University of Toronto of hiring me in part as part of a scheme to impose Sharia on the people of Ontario, which was funny because I had no idea this was going on at all until I read about this. Anyway, although other religious groups resident in Ontario had long made use of private arbitration for the resolution of intracommunal family disputes, when a group of Sunni Muslims announced their intent to establish a mechanism to allow Sunni Muslims to arbitrate their family law disputes in accordance with their understandings of Islamic law, a transatlantic controversy erupted that was resolved only when Ontario took the drastic step of prohibiting the arbitration of all family law disputes in which the arbitrator purported to apply non-Canadian law. Great Britain, too, experienced its own moment of Islamic law anxiety when the Archbishop of Canterbury suggested that British commitments to pluralism might require the English legal system to recognize certain aspects of Islamic law. That controversy was subsequently heightened when it was revealed that British Muslims had indeed already set up judicial councils that engaged in legally binding arbitration of family law disputes, pursuant to already existing British law permitting binding arbitration. The debates surrounding whether to permit binding family law arbitration, particularly when such arbitrations are based on religious or otherwise non-liberal legal systems, raises many important and difficult questions from the perspective of liberal political theory, because it forces a confrontation between various core values within the liberal tradition, particularly gender equality and religious freedom, or even more generally, the conflict or potential conflict
between liberalism's egalitarian commitments and its commitments to personal and also associational autonomy. I will try to answer the question whether the results of religiously based arbitration of family law disputes should receive legal recognition from the perspective of political liberalism. I will begin with a discussion of the role of the family within political society as described by John Rawls in his discussion of the family and the idea of public reason revisited. Following that, I will discuss why we should expect religious conceptions of the family to conflict in certain respects, in certain important respects, with the politically liberal conception of the family, using certain examples from some aspects of Muslim family law. Third, I will discuss Rawls' conception of reflective equilibrium and argue that arbitration is, from an institutional perspective, an effective tool, maybe even a catalyst, for generating a reflective equilibrium between public conceptions of justice and non-conforming conceptions of justice, including religious ones. I will illustrate this potential for arbitration to act as a catalyst for producing a reflective equilibrium by discussing Islamic conceptions of distributive justice within the family and comparing them to the default norms that apply in North American family law. Canada. Since I'm a Canadian now, I can never just say America. I will conclude with a discussion of whether arbitration in fact can act as an effective tool for protecting the autonomy of individual religious believers while vindicating liberal commitments to the political role of the family in a democracy. One of the central objections to the legal recognition of Islamic family law arbitrations raised at the time of the Sharia arbitration controversy in Ontario was that Islamic law would conflict with Canadian commitments to gender equality within the family. The meaning of equality within the family, however, remains deeply contested even among liberals. And even religions that are commonly viewed as endorsing a patriarchal family structure have their own conceptions of gender equality. Islam, for example, teaches of equal moral worth of men and women, and the New Testament states that men and women are, quote, all one in Christ Jesus, unquote. Equality, therefore, can mean radically different things, especially in connection with its application to particular disputes. Numerous plausible, though incompatible, theories could be advanced regarding the family that are consistent with some version of liberal equality. For example, one could take the view that gender equality in marriage should be viewed as a matter of distributive justice, in which case equality means that men and women should receive an equal share of the benefits of married life. One potential drawback of such a conception, however, is that it would not exclude marriages organized around a gendered division of labor, if such a marriage in fact did result in an equal or relatively equal sharing of the burdens and benefits of marriage. And in fact, there is a lot of empirical evidence that oftentimes traditionally structured marriages do result in some kind of rough justice between the parties, and certainly a great amount of happiness for those that find that an attractive model. Alternatively, equality within the family could produce a conception of marriage as, quote, an egalitarian liberal community, unquote, that resists individual accounting of deserts. But such a conception would preclude traditional homemakers from receiving any tangible rewards for non-market services they perform in the household. Some feminists, however, argue that marriage should be treated in a manner analogous to a partnership, in which case equality would require valuing the individual contributions of each spouse to the family, including the non-monetary contributions historically provided by wives in the form of child rearing and housework. Now, the problem with this conception, however, is if this care work, as it's known, is monetized, it might in fact encourage women to continue to specialize in household rather than market production. Of course, this would have the intentional effect of reinforcing the very gender division of labor that many feminists have traditionally sought to eliminate as being the cause of female inequality. So the commitment to equality, right, is often in the eye of the beholder. It's very controversial. It's not quite clear which conception is right. And each one comes with different sort of advantages and disadvantages. Right? Now, political liberalism does not attempt to determine which of these liberal, or for that matter, non-liberal, conceptions of equality is correct. It instead regulates the family from the perspective of what is required, quote, to reproduce political society over time, unquote, in a manner consistent with its ideal of treating all citizens as free and equal. Because the family is part of political society's basic structure, labor inside the family, according to Rawls, is socially necessary labor. On this account, the family is an association, and therefore the principles of justice, including distributive justice, do not apply directly to the internal life of the family.
they are only relevant in a negative sense, meaning that the basic rights of women as citizens place limits on permissible forms of family organization. The public constraints of justice on matters of internal associational life must not be so severe in Rawls' view, however, as to constrain, quote, a free and flourishing internal life of the association, right? So according to Rawls, a family is a kind of association, but it's a particular association because it has the responsibility of reproducing political society over time. So principles of political justice apply to it, but not in the same way that it applies to purely public institutions like courts or legislatures or other elected officials, right? But they are still relevant, okay? So it's in a median position between public institutions and associations. On the one hand, the family, because of its essential role, is part of the basic structure of the society. On the other hand, it is a voluntary association, and thus the principles of justice cannot apply to it in the same way that the principles of justice constrain a wholly public institution. Rawls' analysis of the family, therefore, has important implications for equality within a system of family law that is politically liberal, or it should. It tolerates the continued existence of inequality within the family, but on the condition that such equality, according to Rawls, is, quote, fully voluntary. Religiously justified hierarchies of the family, therefore, are consistent with the principles of justice, according to Rawls, if the background conditions of political justice are reasonably met. So according to Rawls, the only gender-based inequality that must be abolished as a matter of the principles of justice is involuntary gender equality. Religiously justified inequality satisfies the voluntariness requirement, according to Rawls, because in a politically liberal regime, adherence to religion by definition is voluntary. While Rawls appears indifferent as to whether the burdens of labor in the family should be shared equally between men and women, or whether it is enough for women to be fairly compensated for taking on a disproportionate share of such labor, he insists that justice requires that one of these two possibilities be satisfied. So either, there's equality in kind, right? If there's not equality in kind, then women have to be systematically compensated, or they're taking on a disproportionate share of family labor. So for Rawls, I think it's fair to say that family law plays a secondary role in guaranteeing gender equality, because he assumes that women enjoy all basic rights of citizens and also have access to the material means necessary to allow them to make effective use of their liberties and opportunities. In such circumstances, any residual gender-based inequality can be assumed to be voluntary, at least from a political sense, according to Rawls. So as long as women are being fairly compensated for any additional work they take on with respect to reproductive labor, measured, of course, against a hypothetical baseline of reproductive labor that reflects a gender-neutral division of such labor, and the background political conditions are otherwise just, then, according to Rawls, political liberalism really has nothing to say about the internal organization of the family, even one that explicitly endorses a gender division of labor. Now, while political liberalism seeks to regulate the family from the perspective of its role in the reproduction of political society over generations, primarily by ensuring that the family plays a positive role in nurturing the next generation of citizens in a fashion that is consistent with basic constitutional values, religious conceptions of the family are generally organized around much broader concerns, such as reproducing the way of life of a particular religious community, including its particular conception of good, and in the case of salvation religions, preparing the ground for its members' ultimate salvation. The much broader concerns of religious regulation of marriage are reflected in the importance that traditional religions accorded marriage, which was often viewed as a relationship that included both secular and worldly concerns. And this is really, I think, the important source of the conflict here, is that political society is, of course, terribly concerned with the regulation of the family because that's how it survives. Religion is terribly concerned with the family because that, too, is how it survives. But they are concerned with very different things. Religion has different ends than the ends of political society, particularly a politically liberal one. And this is where the challenge is. How do you reconcile the fact that we have two different views of the ends to which family is supposed to serve? In terms of Islam, marriage is viewed as so significant to one's standing as an upright member of the community that it is often referred to as half of one's religion. So one might say, when he or she wants to get married, I want to complete half my religion, instead of just saying, I want to get married. Marriage is viewed as indispensable to an individual's spiritual well-being because, among other things, it allows for the illicit expression of sexual desire. It is also generally productive of a thick web of family relations, not only because most marriages will produce children, but also because it is expected that marriage will generate important ties of social and moral solidarity among the families of the spouses. At the same time, however, marriage represents a critical secular institution that was probably more important to the secular lives of their members than any other social institution with which an individual would interact during his lifetime. Historically, marriage involved the formation of a household and generally triggered what were often substantial transfers of property. It imposed a regime of economic rights and responsibilities among the members of the household and sometimes others in an extended family relationship. It established rules for the intergenerational transfers of wealth. It established rules for affiliating children to parents and assigning financial and nurturing responsibility over them. And it established rules for the dissolution of households, at least in some, along with a substantial body of rules governing ongoing economic relations among former members of a household. In considering how Islamic conceptions of marriage interact with liberal ones, therefore, it is always crucial to distinguish, to the extent possible, those Islamic commitments which are religious in nature from those which are more narrowly legal. Now, since we've been sort of talking about this theme regularly in the conference, let me just say very quickly what I mean by a religious commitment as opposed to a secular one. So in Islamic law, we talk about an intent to draw near to God, right? So if a rule, the purpose of the rule is to further one's relationship with God, then I call that a religious rule because it formally requires a religious intention, which is called niyyah in Arabic. And then there are other rules whose validity and applicability are completely independent of people's subjective intentions, right? And so I call those secular rules. Now, Islam as a legal system regulated the formation of marriage contracts by stipulating who had the capacity to enter into such contracts, the conditions for the validity of such contracts, the remedies for defective marriage contracts, as well as remedies for breaches of a marriage contract. Because of the existence of legal pluralism with Islamic law, numerous potential answers exist for all of these various questions, some of which may be, from a substantive perspective, more in conformity with liberal values of equality, and others less so. As a general rule, however, Islamic law's treatment of the family was highly gender structured, with men and women assigned different rights and obligations within the household, with men generally expected to specialize in economic production outside the household, and women specializing in domestic and reproductive labor inside the household. Likewise, Islamic law afforded men the prerogative to divorce their wives at will, as well as the right to marry another woman while remaining married to their first wife, without granting a reciprocal right in the wife. Men also had a qualified right to discipline their wives, including the privilege of using force in limited circumstances. Inheritance rules also provided that males of the same class received twice as much as a similarly situated female. For example, a widower would receive 1/4 of the estate of his deceased wife, while a widow would receive only 1/8 of the estate of her deceased husband. Likewise, sons also received twice the share of similarly situated daughters. The rules governing custody and guardianship of minor children were also gendered. Accordingly, upon the dissolution of a marriage, if there were children, the mother would generally be awarded custody of the couple's minor children. But upon the children reaching a specified age, which differed for sons and daughters, and at least in some cases, the father would become the custodial parent. The father, however, in all cases, no matter what the age of the child, was entrusted with legal guardianship from the time of their birth until such time as the children became legally adults. The gendered structure of rights within the family could be remedied to a certain extent through the device of contractual stipulations at the time of the marriage contract or after the marriage contract. Accordingly, a woman could obtain a condition that would prohibit her husband from exercising his right to marry a second wife without her approval, or would require him to grant her the option either to divorce herself or divorce the second wife. These were very common contractual stipulations. She could also stipulate the right to divorce her husband at will, at least according to some versions of Islamic law. Likewise, the gendered rules of inheritance law could be, I don't like to use the word circumvented, but their effect could be nullified almost in their entirety through other lawful means of intergenerational wealth transfers, such as inter vivos gifts, which were themselves subject to an explicit norm of equality. So gender was not considered a relevant basis for discrimination with respect to inter vivos gifts. Likewise, Islamic law permitted property owners to establish trusts in which they could divide beneficial interest in the property any way they wished, again, as long as they did that in their lifetime. So the system of intergenerational wealth transfer in Islamic law is much more complex than that of the inheritance system. The inheritance system is one portion of it, but you also have inter vivos transfers, whether outright gifts or through trusts, in which there was basically complete freedom for the donor to do with the wealth as he wished. Religious norms, however, emphasize the spiritual element of marriage, such as the notion prevalent among some Muslims that marriage is a ritual that has otherworldly significance in addition to its secular functions. This ritualistic view of marriage, in turn, encouraged, in many cases, an ethic of sacrifice and self-abnegation, particularly among females, in the name of preserving the family, and promised women special religious merit for bearing with patients, for example, abusive husbands. Likewise, there was the popular conception that divorce is, even if it's legally permissible, it's a very bad thing, and people should exert their utmost in forbearance without resorting to this remedy. So it was encapsulated in a saying that was attributed to the Prophet that the most detestable of permissible things to God is divorce. Religious ideals also influenced the way jurists interpreted provisions in marriage contracts. Instead of interpreting contractual provisions using an assumption of arm's-length bargaining that would be appropriate for commercial contracts, mushahat, that's what the Arabic term is, they interpreted stipulations in marriage contracts often under an assumption that marriage contracts were to be construed pursuant to a norm of mutual generosity and forgiveness, mukarama. Sometimes such an assumption could be favorable to women, like the rule adopted by one school of Islamic law that breaches of representation that were irrelevant to the wife's ability to perform the marriage contract, for example, a representation of physical virginity, were not legally actionable if they were breached. But at other times, they could be disadvantageous to women, such as a rule that a woman's contributions to household expenses, although legally alone, and thus a debt repayable by the husband, converts to a gift if the wife fails to enforce her claim against the husband in a timely fashion. Despite the gendered nature of Islamic law, I've argued elsewhere that there are good reasons to believe that many of these rules represent neither categorical Islamic commitments, nor would it be implausible to believe that Muslim citizens of liberal regimes would be more inclined to adopt interpretations of Islamic law that are more, rather than less, in line with the values of gender egalitarianism. I've also argued that the very same extra-legal religious discourse that was used in the pre-modern period to justify an ethic of self-sacrifice can be expected to take a very different, more egalitarian turn in the context of liberal regimes, where even religiously conservative Muslims tend to interpret the religious aspects of marriage in a more gender egalitarian fashion. The question here is whether the arbitration of family law disputes can be viewed as a normatively justified institutional solution to the conflict between liberal family law norms and religious family law norms. So I don't mean to revisit, all my substantive arguments about the substantive rules of Islamic law. I just want to think now more about, is family law arbitration normatively justifiable from the perspective of liberalism? Now, as discussed above, political liberalism, in its Rawlsian version, recognizes a certain degree of pluralism within the family. Pluralism is tolerated within the family because the role of the family, from a political perspective, is limited to the reproduction, or contributing to the reproduction of political society. Physically, by having children, and morally, by inculcating in them the values of good citizenship, or contributing to the teaching of citizenship. It's not the only institution for that, but it is an institution that teaches political values. Permissible forms of family life, therefore, may be restricted according to Rawls in light of these goals, but not in furtherance of any other goals, right? So while it's okay to restrict family life in light of the political goals of political liberalism, it is not okay, according to Rawls, to restrict family life for other reasons. because that would violate the equal freedom of individual citizens to pursue otherwise reasonable conceptions of the good. Right? So as long as the family is furthering the political conception, right, they should be free, according to Rawls, to organize their lives in a way that furthers their own conception of the good, which may include a certain amount of gender inequality that's justified on religious grounds. The fact that religious communities are permitted to pursue their rational conceptions of the good within their families, however, does not necessarily argue for recognizing a right to arbitrate family disputes pursuant to the norms of that community. Now, I don't want to take the position that political liberalism mandates the recognition of such a right, but I do think I'm going to defend the view that the qualified right to arbitrate family law disputes is deeply consistent with the ideals of political liberalism. And in fact, it may be an ideal institution for effecting the kind of interaction between public principles of justice and the internal norms of various religious communities that may reject some applications of those norms. Right? So it could be an ideal practical institution for effecting the kind of reconciliation between public doctrines and non-public doctrines that Rawls views as essential to generating stability of the social contract for the right reasons, right? It helps contribute to a consensus. This is so because one of the central values of political liberalism, perhaps its most crucial value, is the hope that we can generate terms of political justification to which all reasonable citizens can agree. Rawls derives his account of the principles of justice using a heuristic of the veil of ignorance. But in order for such an arrangement to be practical and stable in the real social world, it is necessary for a reflective equilibrium to exist in the minds of reasonable citizens that reconciles their actual subjective convictions with the principles of justice that are derived through this abstract process. As Rawls describes it, a reflective equilibrium results from a dialectical process between our considered convictions and the results of our theoretical inquiry resulting from the original position. It comes into existence when, quote, our principles and judgments coincide, unquote. But even after reflective equilibrium is reached, quote, it is liable to be upset by further examination of the conditions which should be imposed on the contractual situation, and by particular cases which may lead us to revise our judgments. So in other words, we can engage in this exercise of the original position behind the veil of ignorance. We can draw up what we consider to be the principles of justice. But in an important sense, these are provisional. Because as we sort of live and gain social experience, we might encounter new cases that might cause us to revise what we consider to be our principles of justice, because we discover that we made a mistake in our setup of the original position, right? So just as Rawls envisions individuals engaging in a dialectic between their subjective ethical commitments and the results of their philosophical inquiry until an equilibrium is reached in their minds, it is possible to imagine a similar process taking place between the public institutions of justice, represented by courts of law, and the internal norms of a religious community. Public arbitration provides an institutional forum in which a dialectical process that helps to generate a reflective equilibrium, to use Rawls's term, or to use Rawls's term from political liberalism, help generate an overlapping consensus. Binding arbitration can perform the salutary function of deepening an overlapping consensus with respect to a liberal society's political commitments to both religious freedom and gender equality, because it empowers private parties to adjudicate their disputes pursuant to their own rules, provided that the results do not contradict mandatory principles of justice. The process of binding family law arbitration therefore mirrors, in institutional terms, the relationship between the family and the principles of justice as Rawls envisions. Pluralism, while presumptively permissible within the family, is subject to the limits demanded by the principles of justice. Accordingly, arbitration, far from insulating a religious community's practices from the principles of justice, acts to confirm that a community is applying its norms in a manner consistent with those requirements. At the same time, binding family law arbitration, particularly when performed by religious communities, provides public institutions, as represented by courts, an important opportunity to determine whether mistakes have been made in the formulation of the principles of justice. In other words, it allows a feedback mechanism where new experiences can be obtained, and that can sort of allow for a gradual change in the background conditions of the law as we learn more. Right? Arbitration, it should be clear, is limited to such issues as the parties themselves have the legal authority to resolve by consensual agreement. This is a very important point. The right to submit family law disputes to binding arbitration is therefore an extension of the party's own contractual freedom. It is also limited by the contractual nature of arbitration. The parties to a dispute cannot, for example, arbitrate the rights of third parties, such as that of children, or matters of criminal law or civil status, such as whether or not a person will be married or divorced, right? Because those are not within the contractual parties of individuals. So what this means in practice is that binding family law arbitration is generally limited to financial matters between the spouses, such as division of marital property or future support obligations or both. While many opposed to recognizing binding family law arbitrations conducted pursuant to Islamic law have pointed to the disparate rights given to men and women under Islamic law, in the vast majority of cases, the discriminatory rules of Islamic law, for example, different rights to divorce or child custody, could never become the legitimate subject of a binding family law arbitration, because arbitrators can never have that power to award child custody, right, or to grant a divorce. Islamic law, however, does include its own rules regarding the distribution of marital assets and post-marital support obligations that are generally inconsistent with the prevailing approach to these questions in North America. First, there is no concept of marital property in Islamic law. Both parties enter the marriage with their own property entitlements fully intact, with some qualifications that are of little importance in this context. Second, so long as the marriage remains intact, the husband is under a non-waivable obligation to maintain his wife, regardless of how wealthy or poor she is, and to maintain his children until they reach the age of majority, again, regardless of how wealthy or poor they are. And in the case of minor boys, in the case of minor girls until they're married. Third, upon dissolution of the marriage, the husband's obligation to maintain his wife for all practical purposes comes to an end, although he is encouraged to give her a departing gift. Now, to what extent does political liberalism require some kind of redistribution of household assets that approach equality as a condition to respecting the party's private resolution of their claims? Rawls seems to suggest that it does, right? He states in The Idea of Public Reason Revisited that because reproductive labor and household labor are both socially productive, they must be compensated. Moreover, he suggests that the preferred mode for compensating women for their specialization in household and reproductive labor is to award them the equivalent of a partner's interest in their husband's earnings during the marriage. So let me quote this paragraph. He says, "But now a common proposal is that as a norm or guideline, the law should count a wife's work in raising children, when she bears that burden, as is still common, as entitling her to an equal share in the income that her husband earns during the marriage. Should there be a divorce, she should have an equal share in the increased value of the family's assets during that time. Any departure from this norm would require a special and clear justification. It seems intolerably unjust that a husband may depart the family, taking his earning power with him, and leaving his wife and children far less advantaged than before. Forced to fend for themselves, their economic position is often precarious. A society that permits this does not care about women, much less about their equality, or even about their children, who are its future. Yet this is what Islamic law appears to do. Upon dissolution of the marriage, the husband is entitled to depart with his earning power. Yet it is far from clear that Islamic law's refusal to recognize an ongoing post-divorce maintenance obligation akin to traditional alimony, or even an obligation to allow the wife to share in the increased value of the family's assets during the term of the marriage, inevitably leads to the stark conclusion that Islamic law, quote, does not care about women, much less about their equality or even about their children, unquote. Indeed, it would be extremely implausible to believe any society could long exist if it were truly indifferent to the fate of its women and children in the manner Rawls seems to suggest might be the case if the rule that he advocates is not really adopted. While it is certainly true that as a default matter, most jurisdictions in North America adopt a presumption of equal sharing of assets acquired during the marriage, parties are permitted to depart from that norm, whether by entering into a valid prenuptial contract or pursuant to a settlement agreement concluded at the time of divorce. So parties in the United States and Canada are free to adopt their own norm of distribution of marital assets, whether ex ante, through a prenuptial agreement, or entering into a separation agreement, right? So, and it's not really clear that Rawls's preferred solution is actually the law either in Canada or the United States. In both cases, so long as the terms of their agreement are untainted by unconscionability, courts will enforce them in accordance with their terms, right? So it's actually not the case that special circumstances are required. It's extraordinary circumstances when these private agreements will not be recognized. That's the state of the law today. And indeed, there's a very recent case in Quebec, which is quite interesting, because Quebec is sort of, in some respects, it's much more robustly egalitarian than, say, Ontario, which is more of a common law as opposed to the civil law tradition. And there we had a case where a woman had lived for many years with her partner, and they never married. And Quebec has, I believe, community property rules which are very hard to evade. But she never got married, right? They were never married. They lived together as what we call in Canada de facto spouses, right? So when she and her partner split, she brought a suit claiming that she should receive all the benefits of a de jure spouse, and that it was unlawful discrimination, a violation of Section 15 of the Canadian Charter of Rights and Freedoms, that she should be deprived of the protections of the Quebec Family Law Act simply because she never went through the formal process of getting married. Okay, so there's a radical difference in distribution between de jure spouses and de facto spouses, right? She's de facto spouse. She wants to get the benefits of being a de jure spouse. The court, however, the Supreme Constitutional Court in Canada, rejected the argument and said that there is no violation of equality here, in large part because this would amount to an undue interference in the autonomy of individuals in Quebec to choose whether they want to live under the de jure regime, subject to these strict rules of property distribution, right, or live together as de facto spouses, in which a much less generous scheme of distributive justice would apply upon the termination of the relationship. Not all scholars, moreover, are convinced that an equal sharing of marital surplus is the appropriate rule, rather than, for example, a norm based on unjust enrichment, pursuant to which one spouse, the husband, for example, would compensate the wife for the value of the services she provided to the household during the term of the marriage, as well as the opportunity costs he incurred for specializing in household production. Indeed, from an ex-ante perspective, it's not clear which rule would consistently further the material interests of women who specialize in household and reproductive labor. If she is fortunate enough to marry a successful professional, for example, the sharing rule recommended by Rawls might be preferable, unless, of course, the couple failed to amass any significant savings because they preferred to consume it immediately. Right? When marital assets are scarce, either because the husband wasn't a good earner or because the couple dissipated his earnings, she clearly would be better off with a remedy that simply compensated her for her contributions without regard to the value of the household's wealth. The point is that unless women are given an option to choose which of the two remedies makes them better off ex post, a possibility that itself seems unfair, Rawls was perhaps a bit optimistic when he suggested that a strong rule in favor of equal sharing should be mandatory in most circumstances. Indeed, it would seem that the answer to the problem of female specialization in household and reproductive labor should not lie so much in the earnings of the other spouse, but rather in the public, insofar as Rawls is correct when he asserts that household and reproductive labor is socially necessary labor that must be compensated. Accordingly, one might say that no society that truly respects women and children if their economic security is dependent largely on their ability to form and maintain intact family relationships. I mean, I think the real question is, why do we depend on the family to provide economic security to women and children? Viewed from this perspective, there's nothing necessarily sinister about Islamic law's approach to the distribution of property upon the termination of a marriage. Instead of judging whether a particular distributive norm is, on its face, consistent with the equality of women, it might be more important to determine whether, if as a result of a divorce, the woman is left in a precarious economic position solely as a result of the divorce. There are at least two reasons to think that why this might not be the case, in the event that Islamic law of property is applied by arbitrators to the dissolution of a household governed by Islamic law. First, because Islamic law recognizes the independent property rights of a wife, and it requires the husband to make a marital gift of property to the wife at the time of the marriage, it could very well be that her marital gift has substantial economic value. Earlier today we heard a case where a woman had a claim to almost $700,000 pursuant to this idea, but then the court struck that down. But I suggest that, if that's what she gets, she's probably not in a situation of being economically precarious, and there would be no reason for us to worry about that. Second, because Islamic law does not require a wife to contribute to the household's expenses. If the wife worked outside of the home, she might already have a substantial sum of money in her own name that she's saved from her own market labor. If, on the other hand, she used her earnings to offset household expenses, it is not unreasonable to believe that a Muslim arbitrator could deem such sums to be loans to the husband, which he must repay at the time of divorce. An arbitral award based on a combination of her marital gift and the economic value of her household contributions, if she did not work outside the home, or if she contributed her income to the household cases in where she did work, could very well prevent the result that Walsh was rightly concerned about in the previously quoted passage, namely, that divorce should not leave women in an economically precarious position, at least in circumstances where marriage had provided her some sense of economic security and she had been an active contributor to the welfare of the household. Of course, it is possible that an arbitrator applying Islamic law could fail to take into account the wife's non-monetary contributions to the household when he is determining how much household property should be allocated to the wife. This might be particularly a risk in the stereotypical household characterized by a professional husband who specializes in market labor and a non-professional wife who specializes in domestic and reproductive labor and thus lacks any skills that are valuable in the market. It may even be the case that some Muslim men in such a position would prefer to use Islamic law in an effort to minimize the amount they would have to pay their former spouses. It's also true to say the reverse is true, where if you have a Muslim woman who earns a lot more money than her Muslim husband, might prefer to use Islamic law to avoid any kind of maintenance obligations she might have to her husband ex post. Right? But the point here is such a motivation in itself is not wrongful from a political perspective, as evidenced by the fact that only unconscionable prenuptial agreements and separation agreements are enforceable. The mere desire to reduce one's obligation to an ex-spouse is not generally considered a legal cause for not recognizing their agreements. So as long as the arbitrator's award does not lead to an unconscionable result, it is hard to understand why there should be a principled objection to an arbitration based on principles of Islamic law that lead to an unequal but not unconscionable distribution of household property upon divorce. But the reason, the risk that there might be an unconscionable distribution, right, because of bias in the arbitrator or ignorance on the part of the arbitrator, of course, that's why we have to have public arbitration, right? Because we need to make sure, in fact, that these arbitral awards do not violate these minimum standards. But what about the argument that arbitrations conducted pursuant to Islamic law ought not be respected, regardless of their substantive conformity with minimum norms of fairness, because this would amount to a public recognition of a mode of deliberation that is overtly discriminatory against women, and thus could be said to be expressively discriminatory, and on that ground contrary to public policy. You've seen this, I've seen this argument in some cases. Now this argument might be plausible if Islamic law could be construed as endorsing unequal distribution of household assets as a means of expressing a dogmatic view, for example, that marital breakdown is always the fault of women, and therefore women must be punished when divorce occurs by giving them a very trivial amount of marital property. In fact, however, the distribution of household assets in Islamic law is a result of gender-neutral principles of property law, which in certain circumstances, for example, the high-earning professional male and the woman who is 100% dependent on her husband's earnings because of her complete specialization in household and reproductive labor, favors the male. But in other circumstances, it could equally favor the female. For example, if the female works outside the home, earning an income equal or nearly equal to that of her husband. Because in that situation, she would be able to keep all of that for herself. Because the application of Islamic law governing the distribution of marital assets does not communicate a message of female inferiority, and in many cases could result in a distribution of material assets that in fact is skewed in favor of the female relative to the norm espoused by Rawls and other liberals, it is hard to understand on what grounds one might argue that recognition of even substantively fair arbitrations conducted under Islamic law should not be enforced because they undermine fundamental commitments to gender equality on some sort of expressive grounds. Finally, one might conclude that as a theoretical matter, liberal family law ought to permit binding arbitration of family law disputes in accordance with religious norms in the proper case, but still object on the grounds that as a practical matter, religiously inspired arbitration will effectively shield the discriminatory practices of religious communities from public scrutiny. Accordingly, parties to a family law arbitration might enter into an agreement that effectively insulates the results of the arbitration from meaningful judicial review. Again, this objection was very common in Ontario, that if you allow religious religious arbitration, courts will never be able to determine whether or not the results were fair. Now, this objection appears to confuse the power of courts to review the substantive decisions of an arbitrator with the power of a court to determine as a threshold matter whether a particular legal claim is amenable to arbitration. While it is true that courts are highly deferential to the substantive decisions of arbitrators on the merits of the party's claim, they review de novo the threshold jurisdictional question of amenability to arbitration. This is the path family law arbitration has taken in numerous decisions of New York courts involving disputes between Jewish couples who had submitted or agreed to submit some or all of their family law disputes to Jewish religious courts for resolution. The New York case law is clear that as a threshold matter, the court is to determine whether the dispute is amenable to arbitration, i.e., that it does not involve some matter of mandatory public law that cannot be resolved by arbitration. Because matters such as division of marital assets and post-divorce spousal support are not, as a general matter, subject to public policy restraints, they are presumptively amenable to arbitration. Of course, provided that the procedural requirements are met and the results are not unconscionable. And in these cases, arbitrators' decisions will be enforced subject to perfunctory review. Right? Decisions regarding child custody, however, are not amenable to arbitration because that would violate mandatory public policy, which in New York requires the court to determine that custody arrangements are, quote, in the best interests of the child. New York courts also specifically enforce the obligation to arbitrate the dispute, even if the arbitration agreement provides for religious norms to govern the arbitration. More controversially, perhaps, they refuse to find that an agreement to arbitrate could be set aside on the grounds of duress, where a woman was subjected to the threat of, quote, shame, scorn, ridicule, and public ostracism, unquote, by the members of her religious community if she did not agree to participate in the arbitration. Right? Again, here I think this is sort of consistent with Rawls' idea that when we look at voluntariness, we're looking at voluntariness from the perspective of political voluntariness, not some kind of deep, subjective, psychological voluntariness. And individuals as citizens sometimes have to make hard choices, right? Are they going to are they going to be members of a religious community, in which case they might subject themselves to shame, scorn, ridicule, and public ostracism if they violate those norms? Or do they want to exit that religious community and sort of give up those benefits, but have the freedom to live their lives without such threats, right? But the New York court agrees that that does not constitute legal coercion. Right? In short, the jurisprudence of New York courts with respect to family law arbitration seems to be to enforce agreements to arbitrate and to enforce the results of such proceedings to the same extent that the court would enforce the parties' own agreements, which I think is the right approach, right? As long as there are no violations of public policy and it's within the contracting powers of the parties. Okay. And this is consistent with a politically liberal conception of family law. This approach understands that the function of public law in the context of the family is to ensure that the internal governance of the family does not deprive any of its members of their fundamental rights as citizens. And as long as that condition is satisfied, the family should enjoy autonomy. This approach contrasts with the categorical approach taken by those who would, in principle, refuse to recognize the results of family law arbitrations that apply a religious family law. The success of New York courts in policing family law arbitrations in the Orthodox Jewish community of New York, however, suggests that courts could easily apply the same principles to arbitrations conducted pursuant to Islamic law, as they have done with Jewish law, right? So that if we are worried that Muslim arbitrators are going to systematically undermine norms of public law by, for example, affirming unconscionable property divisions or ruling on issues outside of their arbitration, we can trust that courts will not recognize such arbitrations. So to conclude then, it seems that there are very good principled reasons to believe that family law arbitration is a good thing from the perspective of political liberalism, and that the prudential reasons for not recognizing are more a criticism of courts than they are of religious communities. Thank you.
Yes. If I understood your example, under Islamic law, a man and a woman live together for a long time. They want to separate. And the woman wants part of the assets. And the court ultimately rejected her claim, correct?
Okay, we'll keep on.
In that illustration you gave us. What if they would have had children?
Well, I mean, what I'm saying is that the wife's claim, the wife cannot, neither spouse, it's not the wife, neither the male nor the female can make a claim to property based simply on the fact of marriage. Because in Islamic law, marriage does not create a separate estate, right? They each have their own property entitlements intact. Okay? So the wife might have claims, for example, that she contributed to the household over 30 years, right? That would be a debt that she would be able to enforce against her husband, right? But it wouldn't be necessarily a specific piece of property, right? We'd have to. So the point is that marriage does not create a separate marital estate, right? That's the basic point. There might be other claims, monetary claims, etc. Right? Now, as far as children goes, for example, when a woman is acting as custodial caregiver, right, she has to be compensated for that. So the father has to support the children and reimburse the mother for taking care of the children, right? As well as providing them a house, etc., etc.
Even though they were not legally married?
Even though they're no longer legally married, right? Because as a custodial caregiver, she has certain claims against him.
Thank you.
Any other questions?
As you said that marriage does not create a marital property between the two of them, and each one has entitlement to whatever they had before.
And whatever they earned during the marriage.
During the marriage. Now, is this sort of idea general across the Islamic world that during the marriage, the man's property can be shared by the woman?
Well, he has to. He has an obligation to maintain the spouse, right?
But he cannot access or help himself, so to speak, to her property.
That's right.
So, in that way, how equal is that type of
Well, it's not equal. It's not equal, right? That's my point. It's not equal.
Isn't it reverse discrimination?
Well, I mean, I don't. It's not equal, right? You can argue about who benefits more from it. The point is it's not equal. Because she has no obligation to maintain him or their children while he does. And so that means she can take his money, he cannot.
He cannot.
He cannot, right? But that's part of the point is that there's not, it's true that there's not an ongoing marital obligation post-divorce, but inside also, she doesn't give up her property. Like, for example, in common law, a woman's property interest would vest in the husband at marriage. Right? So, I mean, one of the points that I didn't bring out here, but I brought up in another paper, is that many of our remedies assume a certain conception of marriage that is deeply historical and ultimately sectarian in its own conception of marriage and how marriage works and the rights that marriage provides to spouses. But if you vary the presumptions, right, the results can be sensible from a different perspective, right? If you just look at one rule, it looks crazy, But if you look at complex of rules together, it doesn't look crazy.
So I'm a little hesitant to ask a question of such an erudite legal talk that come from a philosophical perspective, but I do want to warn you that you invited it by talking about laws so much. But my question is very much a philosopher's kind of question. It's somewhat on the abstract level. I don't know what concrete applications of that. I thought it was very interesting at one point early on when you said religion and the state have similar interests in the family because that's what reproduces their kind of society. And I think that's exactly right. And actually, I hadn't thought of it quite in those terms before, but it was, I thought, a clarifying moment. But you could also say that it's precisely in that common interest that you can see most sharply the differences, too. Because what the religion, and this doesn't apply just to Islam, but religious groups in general, have interest in reproducing the religious character of the society, that is, raising the children in particular, and perhaps the spouses in an environment that is close to God in various ways. And the state isn't necessarily opposed to that, but certainly the Rawlsian state is primarily interested in raising citizens, that's the big focus, especially in the later Rawls, who are free and equal and free to make choices, free to exit all their agreements, including their family agreements and so forth. So one would think that there will be a number of cases, many kinds of cases, though I have to say it seems to be those will primarily have to do with educating children. They could have to do, especially with educating daughters, with raising the gender issues, could have to do with the wife's participation in various activities which on the religious level are considered to be too public or something like that, where the state will have, certainly the Rawlsian state, precisely the opposite interests of the wife or the children. But it seems like you've narrowed the range, I do it. So my question is, what practical implications does this have? It sounds like you've narrowed the realm in which you want the state to allow for arbitration, that the kinds of issues I'm concerned about won't be.
I agree with everything you said.
Okay.
Right? That there will be a host of conflicts because the state, particularly a liberal state, politically liberal state, is going to view the family from this very narrow perspective. Religion will view family from a much broader perspective. They have different ends. Religion might teach women that their role is nurturing, raising the children, etc., that it's not valuable for her to participate as a citizen, etc. And the point of political liberalism is to say, that's perfectly fine if you want to teach those values, right? But you cannot coerce women into abiding by them. So if a Muslim woman or Orthodox Jewish woman or a Catholic woman wants to take on sort of traditionally masculine roles, right, the religious community will not be empowered to stop her, right? I agree with that 100%, right? My point is that there's nothing in arbitration, the doctrine of arbitration, that would ever allow a religious community to stop her from doing that, right? In fact, one of the points is that arbitration, when it comes to family law, is by the way it's set up, is going to be limited to an extremely narrow set of cases, right? And so it should not be the instance of raising so much anxiety, right? It's not the anxiety that is associated with allowing religious arbitration of family law disputes is not at all reasonably related to the set of concerns that they can have, that they can resolve, except unless one goes beyond that to start bringing in other kinds of considerations that are beyond the ken of political liberalism. Some of the things we talked about earlier in the day with the, I can't pronounce the Hebrew word, with the Orthodox communities and putting up
Eruv?
Yeah. I mean, you hear this argument, in Canada, for example, is that if Canadian courts recognize the results of Muslim arbitration, what's going to happen is that Muslim women are going to feel psychological and communal pressure to use these, right? Because they will be subject to criticism of being bad Muslims if they don't, right? And so there's this idea that even though the nature of it is voluntary and it only has jurisdiction over a very small set of issues, and it doesn't impinge on the freedom of a woman to leave, the freedom of a woman to pursue a profession, all these other sort of things, right? It has a kind of sociological effect of locking women into a religious community that will substantially narrow their lived experience of citizenship, right? That is sort of the parade of horribles, right? But from the legal perspective, there's no basis for making any of those assumptions, right?
It's hard to comment because it was a very sophisticated and very sophisticated treatment. I want to understand building actually I guess on Sam's point. Are you claiming that properly understood because there's multiple conceptions of equality and because the jurisdiction, so to speak, of the arbitration is limited, that in fact there's really no conflict at all? Or because that's what it sounded like you were suggesting, that in fact there's a plausible conception of equality that that any of the property allocations that you identify would satisfy, and hence there is no conflict at all between equality and religious liberty. Or that's what I thought you were arguing. Or are you arguing that there is ultimately conflict here between equality and religious liberty? I don't hear you making that second argument, and that religious liberty ought to win out.
Okay.
Yeah.
There is a conflict, I think, between equality and religious liberty, but those conflicts always are resolved in favor of equality from the perspective of public law, except for those cases, right, that involve sort of property. Like I said, so if you're an Orthodox Muslim and you believe that a wife has a duty of obedience, right, and she can't leave the home without your permission, this classical doctrine, right, you can't get that enforced, right, and there are many Muslims who adhere to that. Allowing Muslims to arbitrate family law will never, not in a million years, ever allow that rule to be applied.
Okay,
right?
but that's what I said.
Okay.
I said, given the limitations of what you say arbitration can order, which is to say it's only property, you're saying essentially that anything that's within the power of the arbitration panel to order cannot implicate equality.
Well, it cannot implicate equality in a politically meaningful way, right? Because we don't require strict equality in distributive justice in the family. Right?
Okay.
That's what I'm trying to say. Is that there's a idea, there's a notion that's sort of in the ether that strict equality in distribution of marital assets is a requirement of political liberalism. And I'm saying that's just not true.
Okay,
right?
so good.
That's not true.
Okay.
Right? And so the fact that Islamic law does not adhere to that, right, should not be counted as a strike against it, right?
But the permissible deviations within the secular side that you identified are predicated on real consent.
Yeah.
Okay, so then does that open your analysis to interrogation as to in the circumstances where you're advocating non-problematic arbitration, is to inquire whether there's meaningful consent that the parties, particularly the woman, gave? Is that?
Well, I think it's a general question, but it has to be asked generally and answered generally, rather than specifically to certain kinds of communities or sub-communities. For example, in Canada, one of the cases dealing with this, the prospective husband presented his prospective bride with a prenup on the morning of their wedding, right? But the court found no duress. Okay, I mean, even though thousands and thousands of dollars had been spent, the guests were there, she was getting her bridal gown on, oh, here's a prenup, right? So, but that was not considered duress. So, whatever the proper level of duress is, it's pretty high, right? Which I think, again, is sort of consistent with Rawls's idea that what we're concerned about is political voluntariness, not sort of actual. Because what does actual voluntariness mean? More generally, though, what I wanted to point out, and I didn't sort of develop this deeply enough, is I think there's a deep problem with this idea of relying on the family, on family law, and distribution of family assets to assure the financial security of women and children, right? Because the fact is, it's sort of random, right, how families are going to do economically, right? And a norm of sharing doesn't do women any good if the family has nothing to share, right? So one might say that the appropriate rule is that the public should bear the risks of these things, and this public should take a much more active role in guaranteeing the social security of caregivers and children, right? If we take seriously the idea that we care about the family because it reproduces political society over time, and then we need to compensate women for that, specializing that labor, well, it seems to me that the best institution to do that is the public, not the husband, whose resources are going to be variable in a very random way. So why should we say, if a woman has the bad luck of marrying somebody who's economically, obsolete or not productive or whatever, that her ability to get support is going to be reduced to that extent? It doesn't seem like a very rational system, right? So it seems if we, to take this seriously, we should not really look at family law as a way of compensating women for this specialization, but have things like public health, public daycare, et cetera, all these other kinds of services that the socialist countries provide, which aren't really on the table here, but that seems to be the best optimal solution.
Really enjoyed that. Very extremely sympathetic to a lot of what you said. I guess one of the things that I wanted to ask about, although I'm not sure at this point, kind of your use of unconscionability. And I guess when I've made similar arguments, I get pushed back, at least in the American law context, on two fronts, and I'm curious kind of what your thoughts are. One is kind of the way in which American doctrine splits up unconscionability into procedural and substantive elements. And so in almost all jurisdictions, not all, but almost all jurisdictions in the United States, mere substantive unconscionability is not going to be enough in order to, let's say, void an agreement. And so in that way, it seemed like at certain points you wanted to use unconscionability as a backstop, and I'm completely with you on that. I'm just curious what you think about that, maybe what the relationship is between that and some of the questions you were getting about duress and things like that. And then the second part of the question, I want just, again, teasing out some of this unconscionability stuff. The other kind of pressure point I get from arbitration scholars is that unconscionability under U.S. doctrine can only be used to void an agreement, not vacate an award. So once you've participated in arbitration proceedings, you actually typically, there's complicated arguments, maybe why not, but typically you've waived your right to challenge the validity of the agreement. And so you end up in this bizarre situation where by the time many people realize that the agreement is substantively unconscionable, A, they're stuck on making a procedural unconscionability argument, and B, they may have waived their right to raise the argument in its entirety. Because once you participate in proceedings, again, in most jurisdictions under federal and state law, once you participate in arbitration proceedings, you waive your ability to challenge the underlying agreement. So I guess that's the pushback I get. I'm curious what you think about that.
I don't know enough about the details of unconscionability doctrine, because the family law principles of the ALI sort of make it clear that you should have, the courts have a right to vacate an unconscionable arbitral award. So I don't actually know how that's applied. So I'm sort of speaking more from a philosophical perspective, right? But I've always viewed unconscionability as sort of a black hole. You don't really know what it means, right? But the basic idea, I think, what Rawls is getting to is, the basic idea is a woman should not be left in a position where she's a pauper after she had been living sort of a decent life, right? So it's kind of like I know it when I see it type of thing, right? And so, I take it that there's a risk of something like that, and that's why there needs to be public supervision of these things. But I don't think, which seems to be the argument, is that the application of Islamic legal principles inevitably leads to this result, right? That's what I'm trying to respond to, that there is there's nothing inherent in Islamic property law that will inevitably lead to the pauperization of divorcees, right? Now, it might happen because of, there might be a woman who's extremely naive, unable to assert her rights, blah, 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 for the same reasons why we have unconscionability doctrine generally. But it's not something inherent in the legal norms that should be dignified.
That, I think brings an end to not just this lecture, but the conference in general. Thank you to my co-organizers,
There is a reception in the back.
There's a reception in the back for anyone who wishes, a little bit of snacking, further talking.
In a way.